Y'all have found a place to sit, socialize, get to know each other. Except for Washington County, they have added chairs to the table. I mean, they're going to become standing room only at that table, so don't bother getting to know anybody from Washington County. But the rest of you, mix and mingle, and just enjoy yourselves. There should be no excuse for anybody to be hungry. In fact, there is another food table. Is it just right out that door, Marilyn, or is it further down? Okay, so there's a food table out this door that apparently is shielded. Nobody can see it because it's full of food. So if you want seconds, thirds, second breakfasts, we're going to leave the food out until I think probably about the first break. Okay, so plenty of food, so nobody needs to be hungry. Let's see. Okay, so welcome to Spring Conference, everyone. I'm Bob Church. I'm the director of the Utah Prosecution Council. I know we've got some new faces here, and so we want to welcome you out to our annual Spring Conference. If you haven't already discovered, it's Marriott_conference is the Wi-Fi, and the password is in uppercase letters MH2024. And so you'll actually join the network, and then it will prompt you for an access code, and it's the MH2024. Because we do have some new people here that are not familiar with the Prosecution Council, because I've got a couple of minutes, I just want to take a brief minute to introduce to you, the new ones, who we are, and maybe refresh everybody else's recollection. Is UPC, we are created by statute. Our code is up there. We are mandated to train you all, as well as law enforcement officers in certain specific areas. For example, trauma, we're mandated to train you all. We are a council of 12 individuals, 4 city prosecutors, 4 county attorneys, the director of our Prosecutorial Assistance Association, the Attorney General, SWAP, and a member from Police Association, officers. I can't think of their title right now. Anyway, it doesn't matter. We put on anywhere from 8 to 10 conferences per year. I will just put a plug in now. Many of you have seen, we have just started last week was our first session of our visual trial skills course. This is a course that Blair Wardle from Box Elder County has put together for us. It's an all-day course. We teach it at our offices at Murray, and it's teaching you how to use PowerPoint to give effective closing arguments. You can use it in opening, in directs, voir dire. But this is a course that will teach you how to make the presentation of your case much more visually dynamic. Tyson Trent and I have been through it now twice, and we do PowerPoint all the time, and each one of us have learned something every time that we've sat through Blair's course. So that's something that we would encourage you to take advantage of. It is limited. We keep it small. We only have 10 people per class, so you'll want to get on and sign up. We've got 3 more sessions this year. If we get a lot of people and get a waiting list, we could actually add some more, and we will certainly be offering it in the years to come, but that's just the newest course that we have offered. We also hold multiple regional training events. As soon as we're done here at Spring Conference, throughout the end of May, or end of April into May, Tyson and Trent will be traveling across the state doing our regional legislative updates. This is for your officers and for any of the attorneys in your offices that maybe were not able to be here. And so we would encourage you to look for that and really encourage your officers to attend, because that's it's geared for law enforcement, so they understand what the new statutory, their obligations are. You will meet, most of you know Tyson, but you'll meet my 2 resource prosecutors tomorrow, so I will wait to introduce them, but they are here in case you have questions on anything DUI, traffic-related, sexual assault, domestic violence. We've got those folks for you. I'll show you our webpage in just a second. For those of you, again, that are new, you need to know about our webpage, so I will get there, as well as our Google Forum. So whoops, I don't want to black out the screen. Let's go to the next one. This is our webpage. If you have not been here, the address is upc.utah.gov, https://. And this is your resource page. And that's just the initial screenshot. And like I said, I'll show you a couple of things on that here in just a second. I'd encourage you to join. Many of you, I think, don't know that we have this toolbox. And so here's what our toolbox, let me get my mouse, I thought I had done an arrow, is from our webpage. If you come up here to the members, is the cursor showing? Okay, it's not showing. So, sorry about that. Across the middle there, you can see several of the drop-downs. If you click on that Members tab, that will prompt you to sign in or to join. But once you join on that Members page, we have this prosecutor toolbox that I want to draw your attention to. Again, I don't think very many people realize that that's there. We try to keep things current in here, checklists, and this is just a portion of what we offer. When you scroll down, you'll see a lot more stuff on there. And so we'd encourage you to take advantage of our toolbox. There's a screenshot from our Google Forum. If you would like to join, send me an email, send Tyson an email. Just by show of hands, how many of you use our Google Forum? Okay, so quite a lot of you. It's really great. You're able to post questions there. One thing I was going to mention on our toolbox, we don't keep a lot of motions in there just because things change. And so if you're looking for a motion, this is a great place to get that information, to put it out there that you're looking for something. And as Tyson will tell you, and I will tell you, is if you have a question that you think is too dumb to ask, we will ask it for you so that you can remain anonymous. So, just email us and we'll get your question out there. Okay, so that's a little bit about UPC and who we are and what we do. The restrooms here in this conference facility, if you've not been here before, are just straight out the doors against that back wall. Or if you want to go all the way down through the hotel lobby and circle back around, there's some restrooms down that way. There is a Starbucks down there. I'm not sure. I didn't see any coffee. Did they put coffee out, Maryland? It's there. Okay, I didn't see it. So, okay, we do have coffee. Okay, good. We have been trying to do that. In the past, we haven't always been so good about the coffee. Lunch today is on your own. The hotel said they were going to get us a list of restaurants. Did we get that yet? Okay, we'll have that. But here along in Provo, there's a ton of places to eat. Who are my Utah County people or that are familiar with where to eat in Provo? Okay, so they're kind of scattered around. Look for one of them and ask them, where are some good places to eat, because like I said, you won't go hungry here. On Friday, we will provide lunch. We will have our business meeting, our SWAP business meeting at the same time. I sent out an email yesterday indicating that we would be holding elections for 2 associate positions on the SWAP board, one for a juvenile prosecutor, one for felony prosecutor. It was my mistake. It's only for a felony prosecutor. Angela Adams was elected last year to be the juvenile representative to the SWAP board, so it will only be for felony prosecutor. If you are interested in that, look at my email and email Jeff Buman, who's the executive director of SWAP, either to nominate yourself or to nominate someone else. And we need to have that in by tonight or the end of the day today, and we'll do the elections. And then on Friday, we'll also be announcing and awarding our Prosecutor of the Year. All of these sessions are being recorded, and we will post them to our webpage early next week. Bill Francis, who is doing our recording, he's been with us since COVID. Every year he does a phenomenal job, and he gets these recordings back to us in a really timely manner. So if you have to step out, leave, you miss something for some reason, we will have those recordings. Email me or email Ron Waite. I'll put our email addresses up here in just a second, and we can give you the access code to get those, so they will be recorded. Your course evaluation, this is for those of you that are new and those of you that are not so new, because every year we always get somebody that will email us or call us and say, I didn't get my evaluation done, can you please open up the evaluation for X conference? So let me walk you through this really fast. So you'll go to our webpage, and you'll go over to the training tab. Click the training tab, it'll bring you a drop down, you'll click on evaluation. And it will bring up this drop-down box, and I populated it already with spring conference, but when it actually pops up, it's going to have all of this year's conferences, so make sure that you find the correct conference. Click on spring conference, and it will give you the evaluation. This is just the bottom of the page, because again, I want to draw your attention to this, is there's 2 options. If you decide that you want to complete your evaluation as we move through the day, through the course, just save it by Save Progress there, because if you click on Save, that closes you out, and if you're actually not done, we will have to reopen it for you. So just click and save your progress. We're going to close the evaluation page around June 15th to send the CLE into the bar, but please don't take that as license to delay getting your evaluation done. Let's see. Oh, I forgot to move these slides up. This is the other thing that we have on our, oh no, there it is, members toolbox. I just forgot to drag this slide up. That's how you find our toolbox. Okay. The last thing I want to mention is our John R. Justice loan forgiveness or loan repayment program. I also sent this out last week or so, the application. In years past, the amount that we have gotten has been fairly low. And the rules at the time were that I had to divide the loan amount equally between prosecutors and public defenders. And because we had only a handful of public defenders that would apply, they got huge awards, whereas when we had a lot of prosecutors apply, some of you were only getting pennies on the dollar. That rule has changed. So now what it is we take the pot of money and we don't have to split it in half. The review committee evaluates it based on least ability to pay is the standard that we get from John R. Justice. And so last year we saw prosecutors that were getting a little bit more in awards. And so I bring that to your attention only if you have not applied in the past thinking it wasn't worth your time, you weren't getting very much money. I can't guarantee you're going to get a lot of money, but I just want to make you aware that the rules have changed with that. And so I have to have your application by April 29th. Okay, there is our email addresses if you need to contact us. If you want to take a screenshot or take a picture of that, or if you've already got us in your system, you can email us for questions. Marilyn, have I forgotten anything? Okay. What's that? Oh, yeah. Oh, geez. That's what I get for using an old slide. I apologize, Marilyn Lawson. Okay. So let me switch this out, and we will start with our case law update. Give me just a second. There it is right there. What's that? New one's on the desktop. Oh, there it is. Okay. Okay, so let me introduce to you our presenters today. David Simpson. David was here last year. Is this your second year or third year?
Maybe fourth.
Fourth or fifth? Has it been that many years? Okay. Okay, David is an Assistant Solicitor General at the AG's office and currently serves as the Deputy Director of the Office's Criminal Appeals Division. Received his BA from Stanford and his JD from Stanford Law School. Before moving to Utah, he served as a law clerk to the late Judge Michael S. Caney for the U.S. Court of Appeals for the Seventh Circuit and worked as an appellate attorney for the Illinois Attorney General's Office, the Arizona Attorney General's Office, and in private practice. He's taught courses on advocacy, writing, criminal law, criminal procedure for Loyola University Chicago, Arizona State University, and the University of Utah S.J. Quinney College of Law. We're thrilled to have David back. Mike Palumbo is a new presenter for us this year. Mike is also an Assistant Solicitor General at the AG's office. He's been a prosecuting attorney at the AG's office in the Mortgage Fraud, Financial Fraud Unit, and at the Salt Lake County DA's office. Before becoming a prosecutor, he served as the chief investigator for the Utah Division of Consumer Protection. And Mike received his JD from the New England School of Law in Boston and a BA and BS from Ithaca College in Ithaca, New York. And then our third presenter for our case law is Tanner Hafen. Again, Tanner is new to at least our conference presenting for us. Is also an Assistant Solicitor General in the Criminal Appeals Division. Primarily deals with state post-conviction and federal habeas corpus cases. Tanner received his BS and JD from BYU, and while at school, he interned for the Washington County Attorney's Office. You guys are going to need to make room for him. And the Utah County Attorney's Office, oh, I guess you could sit with them too. And the U.S. Attorney's Office for the District of Utah. I don't think we have any U.S. attorneys here. Anyway, those are our three presenters, and so please welcome them, and we will turn the next several hours over to them.
Bob, thank you very much. Are we good? Can everybody hear me? All right, if you can't hear me, wave your arms. Okay, great. So welcome, everybody. Before we get started, just a quick note. As in past years, I'm going to try to make this a little bit interactive. So these are our email addresses. If you have questions throughout the presentation, send us an email to one of these addresses, and we'll try to answer them throughout the course of the presentation. So because we sort of all trade off, stand up and sit down, I've got my email loaded up here. So if something comes in, we'll try to answer it as they come in rather than make you wait for a couple of hours or until the end of the day. The one other sort of preliminary statement that I wanted to make, this is all about betterment. This is not about blame. So there's a good chance that we're going to be talking about a case and maybe a reversal in a case for somebody who's here today. And you may remember that that could lead to painful conversations with victims, with your police officers. And so the goal of this presentation is not to blame anybody. The goal is to be better. So I have this sort of image here because in aviation and in space exploration, the whole idea is not to try to find out who did wrong and punish them. It's to try to build better systems so that we produce better results. In fact, in a lot of these cases, I'll be honest with you, I think there probably wasn't anything that any of our prosecutors did wrong. There was either something that a trial judge did wrong, or frankly, that maybe our Court of Appeals got wrong. And so my goal here is to try to set us up as well as we can to try to produce better outcomes in the future, not to blame anybody. This also means that for the sake of keeping this interesting, this is going to be from now until 2 in the afternoon. We're going to tell some jokes. We're going to try to keep it as light and entertaining as we can. Again, that doesn't mean that we don't take this seriously or that we don't take it seriously if we believe that there was an unjust result in your case. The last thing last two things before we get started with the substance. One, it's great to have everybody back here in person. I gave this presentation during the pandemic to a completely empty ballroom, and nobody laughed at the jokes. And it was pointed out to me that maybe that's because the jokes weren't funny, and I refuse to believe that. So you guys have to prove those doubters wrong. Last point is that keep in mind if you come across a thorny issue, that any of the issues we're discussing in any of our cases today or just in general, feel free to reach out to us in the Criminal Appeals Division at the AG's office. That's sort of part of our job is to provide this degree of consultation. Now, we're not able to necessarily swoop in and draft your motions for you. This is kind of the way our working conditions look. You can see here there's our director, Andrew Peterson, and then our poor line attorneys over here suffering under his rule. For what it's worth, all I did for this was just Google Dickensian workhouse, and this is the first thing that came up, and it seemed to be fitting. So we're busy, but we do want to be able to consult with you, so please feel free to reach out to us at any time so that we can all sort of be on the same page. All right, so with that sort of preliminary discussion out of the way, let's talk about substance. So one of the big themes we have seen over this past year in terms of areas where you're going to get a reversal and kind of tying into what I've said before, even get a reversal where it's not your fault, are in self-representation cases. So I've said here, Frampton comes alive. We'll explain what I mean about that. So, State versus Frampton. This is a 1987 case from the Utah Supreme Court, and this case applies when a defendant asks to represent themselves. Frampton says that trial courts have an independent duty to secure a waiver of counsel that's knowing and intelligent, and generally this information can only be elicited after penetrating questions by the court. So therefore, a colloquy on the record between the court and the accused is the preferred method of ascertaining the validity of this waiver because it ensures that the defendant is going to understand the risks of representing themselves. So what does that Frampton colloquy look like? Well, if you look at the Frampton colloquy, there are multiple points. Have you studied law? Have you represented yourself before? Do you realize you're charged with these crimes? And then you list all the crimes that they're being charged with. Do you realize that if you were found guilty, you could be sentenced to as much as or fined as much as, and then you tell them what the sentence is and you tell them what the fine is. You realize that if you're not found guilty of more than one of these crimes, you can order the sentences to serve consecutively. Do you realize that if you represent yourself, I cannot tell you how you should try your case? Are you familiar with the rules of evidence? Blah, 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 blah. I'm not going to read you every single one of these, but I want you to get a sense of how long this colloquy is, right? Is your decision voluntary? Did the answers to the two preceding questions are in the affirmative? You should consider the appointment of standby counsel. Why do I go through all of this so quickly? Because this is what our Court of Appeals thinks trial courts should be doing in every case where someone wants to represent themselves. This is what they think a colloquy with a self-representing defendant should look like. If the colloquy that you are hearing from your district courts is, are you sure you want to do that? That might be a bad idea. Okay, go ahead. That doesn't sound like this, right? And this is what our Court of Appeals thinks is the right way to go about it. So my big takeaway from all of these Frampton cases is going to be this. If a defendant wants to represent themselves, ask the court to give the Frampton colloquy. And if you get pushback from your courts about that, ask them again. I'm going to stand up here and do jumping jacks and wave my arms around so that when 6 months in the future, if you have a defendant who wants to represent themselves at trial and you say, Judge, I want to give a Frampton colloquy, and the court says, no, I don't think that's necessary. You say, that strange, goofy, balding, but not at all sensitive about it man from the AG's office was waving his arms around in front of us saying, you have to give the Frampton colloquy, right? This is critical. Although it's possible for a defendant to knowingly and intelligently waive the right to counsel without a Frampton colloquy, our courts have found that that situation is going to be rare. So if you don't get a Frampton colloquy, we might be able to save the conviction on appeal, but there's a good chance we might not. And that's particularly concerning because self-representation without a knowing and intelligent waiver is also structural error in many circumstances, particularly if a defendant doesn't have standby counsel. The idea behind that is that if you're representing yourself, you're doing it incompetently and you weren't adequately advised about the risks of doing that, we're not going to know if you had a good defense or not because you were too incompetent to raise that defense. So this is one of the leading sources of easily preventable reversals that we see. This is the frustrating part of this is not primarily prosecutors' responsibility. This is the responsibility of the courts to engage in this colloquy. But if courts don't do it, there's a very good chance you're going to get an automatic reversal. It's not enough for us to say that this is in the judge's hands. If district courts refuse, we need to push back strongly. And if we think the colloquy is inadequate, it may even be worth reaching out to our office to consider an interlocutory appeal to force the district courts to do the colloquy. I would hope that sort of the threat of the AG's office intervening with an interlocutory appeal to force them to do the colloquy would just get them to read the darn colloquy. But if not, please reach out to us. We'd rather make an example out of a recalcitrant district judge who's not giving the colloquy than have to retry the whole case again at the end. So examples here. So State versus West, this is a case in which the district court permitted the defendant to represent himself during sentencing. The court said this was going to put her at a disadvantage, but it didn't explain why. It didn't click through the risks of the sentences. It didn't click through the rules of evidence, any of those sort of multiple factors that I've outlined. The defendant's filings showed that she didn't understand the need to to conduct herself with decorum in the courtroom, and the Court of Appeals found that this waiver was not knowing, intelligent, and reversed the conviction. My colleague Tanner is going to talk about another case, another couple of cases with similar results.
I'll start by letting some legal experts demonstrate what something like this might look like. Let's see.
Mr. Larch, you have heard the case for the prosecution. Is there anything you wish to say before I pass sentence?
Well, I'd just like to say, my lad,
Let me turn it up.
Mr. Larch, you have heard the case for the prosecution. Is there anything you wish to say before I pass sentence?
well, I'd just like to say, my lad, I've got a family, a wife and 6 kids, and I hope very much you don't have to take away my freedom. Because, well, because, my lord, freedom is a state much prized within the realm of civilised society. It is a bond wherewith the savage man may charm the outward hatchments of his soul and soothe the troubled breast into a magnitude of quiet. It is most precious as a blessed balm, the saviour of princes, the harbinger of happiness, yea, the very stuff and pith of all we hold most dear. What frees the prisoner in his lonely cell, chained within the bondage of rude walls, far from the owl of thieves? What fires and stirs the woodcock in his springe, or wakes the drowsy apricot betide? What goddess doth the storm-tossed mariner offer most tempestuous prayers to? Freedom! Freedom! Freedom!
It's only a bloody parking offence.
Okay. So I'm going to just cover two cases from the past year that where there was an inadequate Frampton colloquy. One from a more sympathetic defendant and one from a much less sympathetic defendant. The first is Patton. I think this was covered last year, but it's worth repeating again. So Mr. Patton was charged with possession of a controlled substance and theft after he picked up a prescription for his son at the pharmacy. When the judge asked Patton if he wanted an attorney appointed, Patton told the judge, "No, this is a garbage case. I'm not worried about it." The judge was understandably maybe a little offended by that and proceeded to not do very much in way of a Frampton colloquy. Not surprisingly, the trial did not go very well for Mr. Frampton. It was or Mr. Patton, sorry. It was a remote trial. He didn't show up at the beginning, and so the trial judge proceeded in his absence. He showed up at the end, explained that he didn't really know what was going on, and he was convicted. So, unsurprisingly, that was not enough from the trial judge in that case. The more interesting case, and much more recent one, is State v. Lee. So Mr. Lee was pulled over, I believe in San Juan County. He was going about 30 miles over the speed limit, led the police about 4 miles down the road before he actually pulled over, was driving on an expired license and expired registration, and had several THC products in his car. He hired an attorney initially, but when he came to court for his initial appearance, he decided he was going to fire his attorney and represent himself. The court began to set a hearing date for a later time to conduct a Frampton colloquy, but Mr. Lee insisted on going through it right then because he wanted to have his right to a speedy trial vindicated. The court started asking a few questions, but again, Mr. Lee insisted that he wanted to get to trial right away, and he would explain more in the future why his waiver of his right to counsel was knowing and voluntary. The court provisionally found that he had waived his right knowingly and voluntarily, but then at the later date, when they were going to follow up on that, they only confirmed that he still wanted to represent himself and moved on. I wanted to add this next bit just because it's kind of fun. So the day after this, Mr. Lee showed up at the courthouse in Monticello, and I wish I could have found the actual exhibit of the picture of this, and so I'm sorry I didn't, but I did my best to reconstruct it. But he spray painted on the side of the courthouse, "Tim Lee versus Utah, justice delayed is justice denied, a trial 2,000 years in the making." And I'm sure it was. So the information against Lee was amended to include a graffiti charge. Mr. Lee then went to trial and was convicted, unsurprisingly. So yeah, from both of these cases, the issue, of course, was whether the defendant's waiver of their right to counsel was knowing and voluntary, as David discussed. Frampton was the basis of those. We all understand this. So in Patton's case, the Supreme Court decided that his waiver was not knowing and voluntary. They go into some depth as to, they cover each of the Frampton questions, and decide that the trial court really only covered a couple of them. And in fact, the court's warning, that he would be at a bit of a disadvantage at trial, actually the Supreme Court decided that they downplayed the risk there, which is probably true. And for all of those reasons, they decided that Mr. Patton's waiver was not valid. Thanks, David. Appreciate it. And the same in Mr. Lee's case. The Court of Appeals, this was a decision handed down just recently, decided at best the court's attempted colloquy addressed only one or only two of Frampton's recommended questions of the, 15 or 16 or something like that. And they clarified here, a colloquy need not follow Frampton's precise script, but the partial colloquy here did not show whether Lee had an actual awareness of the risks of proceeding pro se under the particular facts and circumstances at hand, and understood the consequences of waiver. And that is something to remember. It's not all is lost if the court doesn't go through the specific Frampton colloquy. The reviewing court is supposed to review all of the facts surrounding the waiver to determine whether it's knowing and voluntary. But your best bet is that the court actually went through the Frampton colloquy. And in both cases, the courts recommended and repeated this recommendation for trial courts to employ the full Frampton colloquy, and in particular to encourage trial courts to keep a prepared Frampton waiver of counsel colloquy script at the ready on the bench for use when the occasion arises. I would extend this recommendation to all of us as prosecutors, in your court binder or briefcase or whatever, maybe keep a printed out version of this. If the court is expressing some reservations about going through the whole thing, say, Your Honor, I have a copy right here if you'd like to use it or whatever. Because again, this is gonna save you a lot of headache, the victims, families of victims, a lot of headache. If, several months down the line, your conviction gets reversed because a judge was careless or lazy or otherwise didn't ensure that this honestly very important constitutional right was not waived properly. And back to Mike for another.
Thanks, Tanner.
Yeah.
This is a SCOTUS case, McElrath versus Georgia. And this is double jeopardy. So McElrath was diagnosed with schizophrenia. He had a number of mental health issues. He had delusions, including that he believed his mother was trying to poison him. He believed that he was a FBI agent that had traveled to Russia many times. And he had been put in a mental health facility to deal with these delusions. He was released and seemed to be doing okay. But then a week after that, he murdered his mother. He called 911 and confessed. And so in Georgia, he was charged with malice murder, which is their highest level of murder charge, felony murder, which is a lower level of murder charge, and aggravated assault. And he got a mixed verdict. So the jury returned a not guilty by reason of insanity for the highest charge. And then for felony murder and ag assault, he was found guilty but mentally ill. And in Georgia, they have a rule that mixed verdicts, if they're found to be repugnant, are just null and void. And so the Georgia Supreme Court determined that these verdicts were repugnant because you can't be found insane and then not insane for the same set of facts. And so they found it repugnant, and they sent it back for retrial on both charges, both the one for which he was found not guilty and for the felony murder charge for which he was found guilty but mentally ill. When he got back to the district court, McElrath challenged this on double jeopardy grounds, basically saying you cannot retry me for the offense that I was acquitted of. It's done. The book is closed on that one. And the Supreme Court basically said, yeah, that's absolutely true. An acquittal is an acquittal. And they said in a number of different ways, but During oral argument, Justice Gorsuch, he noted that, an acquittal is an acquittal is an acquittal. Just reinforcing the point that even if you get a mixed verdict and if you have this weird state rule where mixed verdicts just don't count at all, an acquittal is basically unchallengeable. So regardless of the reason for an acquittal, you don't get to question that, even if it's for an improper purpose, like if it was just out of lenity or some other reason. Once you get an acquittal, double jeopardy applies, and you cannot be retried for that. So that is the takeaway. So basically, just if there's an acquittal of any kind, regardless of what label applies to it, if it's somehow modified by reason of insanity, it just doesn't matter. If it's an acquittal, you're done. So that's the takeaway.
All right, the next set of cases are going to be, I hope, familiar to most of us from previous year's presentations, but I want to get us up to speed on new developments in this area of case law, which is the unanimity cases. This has been probably the single most active area of generating new law, particularly from our Court of Appeals, since about 2020, 2019. There are, by the way, a handful of unanimity cases that are trickling out of our Supreme Court. We've had one so far that we'll talk about in a minute, but there are two other sort of more important ones that are pending, so keep your eye out on this. But so to explain unanimity, I kind of want to move through a three-part outline. So first, I want to explain what is the problem of unanimity. The second is what have the recent cases been holding, and then the third is what can you do to prevent your case from being the next reversal. So first, let's take a look at what is the problem of unanimity. So this dates back to a case from our Court of Appeals called State versus Aliris. This is an opinion from then Judge, now Justice Hagan. Aliris was charged with 6 counts of aggravated sexual abuse of a child, 2 against his daughter and 4 against his daughter's friend. During closing argument, the prosecutor described a whole bunch of different prohibited touchings and said the jury could convict on whichever ones they wanted to. The jury was apparently really confused by this. The jury wasn't sure what the prosecutor meant by just listing a whole bunch of acts and then saying you can convict on whatever you want. So they send a note back to the judge expressing confusion. The judge, as judges often do, just says refer to your initial instructions. And the jury responds by convicting him of only 2 of the 6 counts, 1 for each victim, and then acquitting of all the remaining counts. So Aliris then goes on appeal and argues that his counsel was ineffective because for not ensuring that the jury was unanimous. The Court of Appeals agreed and reversed the conviction, even though there's no objection below, holding it was objectively unreasonable for trial counsel to propose instructions that did not require the jury to be unanimous as to the specific acts supporting each count of conviction. The jury should have been instructed to agree on a specific criminal act for each charge in order to convict. Without such an instruction, the jurors could have completely disagreed about which acts occurred and which acts were illegal. So let's break that down a little bit more. So for the difference between unanimity of elements and unanimity of theories, take a look at State versus Hummel. So State versus Hummel sort of gives these examples of robberies or burglaries. So so juries do not have to be unanimous as to the theory about how the crime occurred. So, for instance, if you have a robbery or a burglary, there's some evidence, there's a front door that's broken in and a back door that's broken in. Does the jury have to be unanimous about whether the defendant came in through the front door of the house or came in through the back door of the house? No, they don't. The reason is because under either circumstance, only one robbery or only one burglary is occurring. However, if, say, you have a robbery in Salt Lake City on Wednesday and then a robbery in Provo on Friday, a jury does need to be unanimous about that. And the reason is because you could charge those as 2 completely separate offenses. Same thing, say, in Aliris, if you have evidence that a defendant touches a victim 10 separate times, That's 10 separate, potentially individual criminal acts that could each be separately charged. If you only charge, say, 6 out of those 10, then the jury needs to be unanimous about which ones occurred. So specifically, this problem arises where a charge or charges encompass multiple criminal acts, any of which would be sufficient to sustain separate convictions. So quick example, imagine you have evidence presented at trial, touching of a victim's buttocks on Monday, touching of breasts on Tuesday, touching of pubic area on Wednesday. And then at trial, we charge 1 count of sexual abuse of a minor. The concern is that the jury might look at all of this evidence and say, well, maybe 4 jurors thought he touched the buttocks, 2 jurors thought he touched the breasts, 2 jurors thought he touched the pubic area. We all agree he did something, but we don't all agree unanimously about what he actually did. So that's the problem of unanimity. That's the risk that our court is concerned about. What's been concerning in Utah, and we've been fighting this battle with our Court of Appeals for years now without a lot of traction, is that, at least in most other states, as I can tell, if you don't raise this claim at trial as a defendant, then it's waived. And Aliris, the facts of that case show exactly why. Sometimes defendants benefit from jury confusion, right? Our Court of Appeals has not been receptive to that argument. Our Court of Appeals thinks, nope, the jury has to be properly instructed. If the jury to be properly instructed, it needs to be told about unanimity. And if it's not, then defense counsel is objectively unreasonable for not doing it. Okay. So that's what the general problem is. What have some of the recent cases held? First case, this is one of the first cases to come out of our Supreme Court. This is probably an easier situation than some of the cases we'll discuss later. And I'll explain why as we go through it. So in State versus Pauley, the defendant was charged with 1 count of obstruction justice. But the evidence shows that he commits 3 separate acts. So one is disposing of the gun that he used to shoot the victim. Another is disposing of his cell phone. And then the third is fleeing the jurisdiction to California. And so the suggestion from Pauley's counsel is that, well, maybe some jurors thought that he fled the jurisdiction but didn't dispose of the gun. Some thought he disposed of the gun but didn't flee the jurisdiction, and they might not have been unanimous about what precisely he did to obstruct justice. Our Supreme Court thankfully rejects this argument, and they reject it because the prosecutor clearly identified the obstruction charge at trial as the only act that they were alleging was criminal. So when the prosecutor is making the closing argument, the prosecutor is repeatedly saying obstruction. That's disposing of the gun. Now going back again to the elements of our obstruction, he disposed of the gun. That's the only way the prosecutor is describing it. Critically here, though, you'll see the prosecutor clearly identified the obstruction charge as being founded only on the gun. So our next case illustrates what happens if our courts think that the identification is not clear. So State versus McLeod, this one just came down recently from our Court of Appeals. The defendant there is charged with 2 counts of forcible sexual abuse, and the jury hears evidence of 3 prohibited touchings. The jury instructions themselves did not link any particular act to any particular charge, and then the prosecutor tried to tie the acts to the charges during closing, but the court finds that this tie was not clear or unambiguous. So as is so often the case when we're speaking extemporaneously in court, there's a little flubbing of the wording there. I think the fair import of what the prosecutor said was the prosecutor was tying specific acts to specific charges. Our Court of Appeals says that's not clear enough, and because the evidence is close, they reverse the conviction for ineffective assistance of counsel as to those counts. So if, say, you are going to try to address this problem in your closing, say you're dealing with a sexual assault where you have the example that I gave earlier, touching of buttocks on Monday, touching of breasts on Tuesday, touching of pubic area on Wednesday. You'd want to say to the jury, ladies and gentlemen of the jury, count 1 that we are alleging here is the touching of the buttocks. Count 2 is the touching of the breasts, and then be consistent about that throughout the trial. Another example of this, State versus Garcia. Garcia is charged with 1 count of aggravated sexual abuse. The jury hears evidence of 3 prohibited touchings. The jury instructions do not link any particular act to any particular charge. Here, the prosecutor ties the charges to the individual acts during closing, but doesn't do so consistently during other parts of the case. So the court finds that during opening or during questioning, there may be suggestions that these counts are not tied to specific acts. Our Court of Appeals says that defense counsel's failure to request a unanimity instruction in that case arguably amounted to deficient performance. Due to the unique facts of the case, the court finds no prejudice, but in a closer case, you could have easily come out the other way, and this one could have been reversed. Even though the prosecutor is trying to tie these elements together, the court found that it's not being done consistently. Another case, are you okay if I continue? If I cover this one? Yeah. So State versus Grenier, you have a defendant who's charged with 1 count of rape of a child and 1 count of object rape and 1 count of aggravated sexual abuse. Again, the jury instructions do not link any particular act to any particular charge. Only 1 act constituting object rape is presented, but there are multiple acts of rape and sexual abuse that are presented. So as is often the case when you have child sex cases, you have instances of episodic memory where you have someone saying, he would do this to me many different times. The court held that more than a mere mention of a specific allegation supporting a charge at some point is required. Defense counsel performed efficiently, and this prejudiced Grenier as to rape of a child and aggravated sex abuse charges, and those 2 convictions are reversed. So the takeaway from this, in other words, is our Court of Appeals is routinely reversing cases, and we see this, as this alludes to, particularly in serious sexual assault cases, for what it perceives to be ineffective assistance through failing to ensure unanimity. You might ask, well, if it's ineffective assistance, surely defense counsel are going to be alerting me to this now that the word is out. I wouldn't count on it for the reasons I've discussed. It's not necessarily in defense counsel's benefit to do this. If you hear the prosecutor elect charges but think they don't do so clearly, are you going to say, oh, wait, Judge, he should have been even clearer that my client committed multiple different acts here, each of which could be independently charged as criminal, and I want you to make clear that as a juror that he's done all these multiple different evil things separately. No, of course you're not. You're going to stay quiet and then say, well, our Court of Appeals will reverse at the drop of the hat, so let's see how the verdict goes, right? If the verdict comes out in my favor, then great, double jeopardy attaches, I take my acquittals with me. And if it doesn't, I get my automatic reversal from our Court of Appeals, or not quite automatic, but significant chance of reversal. So this is not the sort of thing that we can count on trial courts or defense counsel to bring to our attention, as is sort of a recurring theme here. Our Court of Appeals expects this to happen right, which means ultimately it's on us to ensure that these cases are properly instructed. So that, yes, Ryan.
See anything from the Court of Appeals or Supreme Court about the sort of deliberate, weaponized, ineffective assistance of counsel?
The short answer, so the question for those of you who didn't hear is, have we seen anything from our Court of Appeals or the Supreme Court about sort of deliberate, weaponized, ineffective assistance of counsel along the lines I've described? The short answer is no, but those are arguments that we at the AG's office are starting to make. So State versus McLeod, one of the cases I discussed earlier, we just filed a petition for a writ of certiorari in the Utah Supreme Court raising exactly that argument. I suppose, we're pressing those points. In the meantime, this is, for reasons I'm going to discuss in a second, I think a problem that I hope is preventable, and so I hope those efforts bear fruit, but I wouldn't count on it. The one other thing to keep in mind is that we're asking the Utah Supreme Court to correct this issue. The judge who wrote Aliris is now on the Utah Supreme Court, and Justice Hagan is a fine justice, but we know Justice Hagan's opinions on the matter. Justice Pullman was also formerly of the Court of Appeals, and so we're still sort of feeling out to the extent to which our Supreme Court, our current Supreme Court, which is composed of a lot of former Court of Appeals justices, is going to be willing to slap down the Court of Appeals on these sorts of questions. All right, so what can you do to prevent your case from becoming the next reversal? Well, when I first started giving this presentation, I had a bunch of guesses. Fortunately now, Moses has come down from the Muji Committee with our commandments. So I'm not going to read verbatim all of the new Mujis, but I would encourage you in any case that you have now to think through the unanimity Mujis. So the general unanimity Muji 216 is the sort of instruction that you'd see in every case about the jury has to be unanimous. So you should all be familiar with this. If you're not giving an instruction that your jury generally has to be unanimous, I mean, I can't help you. But the Muji Committee has put in a committee note to the general unanimity instructions saying increasingly our appellate courts are identifying circumstances where it's not clear the jury's adequately instructed about unanimity. In those cases where different alleged acts can satisfy the same element, practitioners should add or amend new jury instructions. And so those are contained in Model Instructions 430, 431, and 432. So 430 says, would deal with where you have a single offense committed in more than one way. So the defendant is charged with this crime. Evidence was introduced that it was committed in 3 different ways. So for instance, the defendant is charged with sexual abuse of a child. Evidence was introduced that the defendant may have committed the offense by touching the breasts, touching the buttocks, touching the pubic area. You may not find the defendant guilty on this unless you unanimously agree that the prosecution has proven that they committed the crime in at least one of those specific ways and specifically unanimously agree about the way in which they committed it. And then it cites to some of our case law. Number 430, this is where you have multiple offenses with identical elements. So this is a case where I say you charge 3 counts of object rape. You know, count 1, object rape, count 2, object rape, count 3, object rape. In Utah, our charging standard is typically to just list the charges and the statutory elements. We don't, you see this in some jurisdictions now where prosecutors are putting in a to-wit. You know, count 1, object wit, two-way penetration with X object. Count 2, object rape, two-wit penetration with Y object. Count 3, penetration with Z object. I do think that's better practice, by the way, because it disciplines us to think about when we may have separate acts and multiple different acts that could each independently be criminal. But even if you don't do a to-wit, this gives you, in your information, Muji 430 requires you to do it during your jury instructions. Again, I'm not going to read all of these to you. I would just commend you to take a look at them. 432 is where you have the situation of more occurrences than charges. So say 6 different prohibited touchings of the victim and only 2 counts. So the prosecution has alleged in count 1 and 2 that the defendant committed this crime. The evidence was introduced that he may have committed the crime more than the times, in a greater number of times than the charge count. And then it tells the jury to be specifically unanimous. And then we have our committee notes here. So take a look at all of these instructions. And bear in mind, the difficulty about giving specific advice about this is the way that this is going to be triggered is going to depend on what the act for your crime is, what the criminal act is, right? So if it's an act of possession, that might be a single continuing act. You might be less likely to need a specific unanimity instruction. Where we see this coming up most frequently, as these cases have probably alluded to, is in serious sexual assault cases, because you have each independent touching of the victim could be charged as a separate crime. And so if you're dealing with a case where each independent touching of the victim could be charged as a separate crime, we need to take steps to ensure the jury is unanimous. If we don't, in a lot of these cases, we are getting these convictions reversed, again, even when there is no objection from the defense. All right. If you have questions about that, we can return to it later if we get any emails. Otherwise, I'll move on to another one of my cases here. This is Counterman versus Colorado. So this is one of the most important U.S. Supreme Court cases that we had in the most recent term. So defendant Billy Counterman, he becomes obsessed with CW, who's a local singer. CW's never met him in person, never engaged with him, but that doesn't stop Counterman from being super duper duper creepy. He starts sending her hundreds of messages online. She'll remove social media accounts and he'll start tracking her down again. The opinion provides a sample of some of the messages that are being sent to her. You know, some are benign on their surface, good morning, sweetheart, but others are references to physical sightings. Oh, I just saw you drive by, or was that you in the white Jeep? And then eventually he starts getting angry. F off permanently, you are not a good human being, die. So here's Mr. Counterman. Naturally, eventually CW is really alarmed at this and starts and reports this to police. Mr. Counterman is arrested and prosecuted. So we know that these messages caused her substantial distress, anxiety, trouble sleeping. She canceled social engagements and professional engagements, which is a pretty big hit if you're a professional musician. And Counterman's prosecuted under Colorado's stalking statute and moves to dismiss on First Amendment grounds. Okay, so what's the law we're looking at here? Colorado's law made it unlawful to repeatedly make any form of communication with another person in a manner that would cause a reasonable person to suffer serious emotional distress, and does cause that person to suffer serious emotional distress. So the elements are essentially, number one, communication. Number two, the communication would cause a reasonable person emotional distress. And number three is actual harm, actual emotional distress. And the Colorado Court of Appeals, under their precedent, says this is a purely objective standard. So the state doesn't have to prove that Counterman intended to cause the victim distress, only that Counterman made statements that a reasonable person would find distressing. So yeah, only that a reasonable person would find these statements distressing. The prosecution, critically, is based solely on Counterman's communications, not on real-world stalking. So they're not saying Counterman's been physically trespassing onto her property or leaving things for her. It's based entirely on communications. And the only proposed evidence is Counterman's messages themselves, so you don't have evidence about actions that he's taking. So the Supreme Court takes up two questions here. Question number one is whether the First Amendment requires proof that a defendant has a subjective mens rea, a subjective mental state, in a true threats case, and number two, if so, what mental state is sufficient? So a little background on true threats. Right? So true threats is a doctrine under First Amendment and free speech law. For all of us who are prosecutors and rarely deal with this, cast your mind back to when you were pimply law students. So we'll remember that all speech is presumptively protected under the First Amendment, right? But there are certain categories of speech that are historically unprotected. So that's things like incitement, direct incitement to violence, defamation, that's things like slander, obscenity, and then threats of true violence. So what we're concerned about here is that last one, that threats of true violence, or true threats of violence. A true threat under Supreme Court precedent is a serious expression conveying that the speaker means to commit unlawful violence. So by true, that means it's not a joke, it's not hyperbole, it's not, Mike, if you beat me in the, Law Day 5K run, I'm totally gonna kill you. Like that sort of thing would be a joke. It's hyperbole, that doesn't convey a real possibility of violence. And a true threat under Supreme Court precedent is objective. And whether the speaker intended the threat is irrelevant to whether it is a true threat. And the rationale, in this case illustrates it right, is that true threats can cause harm regardless of the intent of the speaker. Another example you can imagine, if you imagine a couple of kids say, I'm gonna threaten to bomb my school, right? They may think that's a really, really funny joke and not intend that it's being taken seriously, but if a reasonable person could take it seriously, it could cause a lot of problems, right? So that's the sort of existing state of the law. However, even where the speech itself is unprotected, it might still merit protection to avoid self-censorship or a chilling effect. So to take an example, defamations, making false statements about somebody is not protected under the First Amendment. But in order to protect my right to free speech and to avoid a chilling effect, it's not enough to just show that the statement was false. We have to show if it's about, say, a public figure under New York Times versus Sullivan, we have to show actual malice. So the idea being we want newspapers to feel ready to report on public figures, even if they make a mistake. And so we don't want to punish them for making an innocent mistake. We only want to punish them if they acted with actual malice. In the case of incitement to violence, we have to show that the speaker actually intended to incite violence. It's not enough that there was a possibility that it could have incited violence. So even though true threats are unprotected, the Supreme Court thinks that the First Amendment may still demand a subjective mental state requirement, shielding some threats from liability. So that's the first holding in Counterman. The first holding in Counterman is that merely showing an objectively true threat, merely showing a statement that a reasonable person would find to be threatening, is not enough for criminal liability. The government must also prove a culpable mental state. So mere objective threat is not enough. The government must also prove a subjective, culpable mental state. Holding number 2, the Supreme Court says the required mental state is recklessness, meaning the speaker consciously disregarded a substantial and unjustifiable risk that the conduct would cause harm to another person. So this is similar to the actual malice standard for defamation. And the Supreme Court says we don't need a higher standard of intent because true threats are not as politically charged or as important as incitement. So the government, in other words, must show that the speaker who makes these sorts of threats is aware that others could regard the statements as threatening violence and delivers them anyway. Merely proving a reasonable person would have perceived the threat is not enough. Before continuing on with how this applies in Utah, we'll do a little cul-de-sac here for a Supreme Court writing smackdown. On the left-hand side, we have Justice Barrett versus on the right-hand side, Justice Kagan. Justice Barrett, in her dissent, says the reality is that the court's choice of recklessness is not grounded in law, but in a Goldilocks judgment. Recklessness is not too much, not too little, but instead just right. Justice Kagan, in her majority opinion, says, the dissent accuses the court of making a Goldilocks judgment in favoring the recklessness standard. But in law, as in life, there are worse things than being just right. I could take a vote, but I think we all know who wins. Justice Kagan gets the crown in this legal writing smackdown. Stay tuned next year for the next installment. Okay, so that's Counterman. What does that have to do with all of us? This decision does affect Utah. For example, our former version of the stalking statute contains a mere negligent standard. The actor commits stalking if the actor intentionally or knowingly engages in a course of conduct directed at a specific individual and knows or should know that it would cause the victim distress. The or should know is a mere negligence standard. So this portion of our stalking statute is not was not compliant with Counterman. There are other examples of this elsewhere as well, things like threatening jurors. There are statutes about threats to public figures. So Counterman is an issue in Utah. Going forward, the AG's office, Legislative Council, our friends at SWAP, all of our usual suspects, have implemented what we believe to be fixes to this problem in HB 83 and HB 350. So going forward, we think we fixed the problem. It's possible we missed something. If we did, we want to kind of keep this rattling around in the back of people's heads. But so here's how we fixed it. So the stalking statute, for instance, instead of saying the individual knows or should know, we've changed that to knows or is reckless as to whether. And that should, we hope, comply with Counterman. So then the last question may be, these fixes have only just gone into effect. What should you do if you have a case that predates these legislative fixes? What should you do if you have a stalking case, you have a threats case that predates Counterman? So a couple of suggestions here. Number one, if you can, charge conduct instead of speech or in addition to mere speech. So remember, Counterman is grounded in the First Amendment. So it only applies to speech, not to other types of conduct, like following, monitoring, observing, surveilling, interfering with property, appearing at the property or workplace. So if you have that sort of activity in a stalking case, you want to make sure that you're alleging and charging that. Suggestion number 2, make sure the AG's office is aware of all counterman challenges that you're receiving. So Rule of Criminal Procedure 12 requires the Attorney General's office to be served with notice when a defendant has raised a challenge to the constitutionality of a Utah statute. Our constitutional litigation, defense and special litigation folks will respond to these with coordination from criminal appeals. So make sure that we're being given the opportunity to intervene. So we may be able to help by providing sample languages or sample language or by intervening in our own right. Another suggestion here, Utah doesn't really doesn't define the word threatening, and so if you're trying a stalking case based on threats, consider instructing the jury on counterman's definition of true threats. That's serious expressions conveying a means to commit unlawful violence and doesn't include mere jests or hyperbole, or other statements that do not convey a real possibility that violence will follow. Number 4, if you're trying a case under the old stalking statute and all you have is speech, instruct the jury on the knowing mental state. So as I pointed out, our old stalking statute says knows or should know. What we can do is just say, well, look, Judge, the statute gives us 2 options of how to charge this, knows or should know. I'm just charging it under knows. We're not going to charge it under should know. We considered advising trial prosecutors to just instruct the jury on recklessness anyway. Our concern with that is that it might draw an objection from the defense saying that we're trying to rewrite the statute. So the safer thought, we think, was just to say if you need to charge this under the old statute before the revisions, just allege knows, not should know. In the same way that if a statute says you can be prosecuted for possession of methamphetamine or heroin, we say, well, we're just charging you with the methamphetamine part, not the heroin part. Yeah, question?
But not for conduct. So if I have a case that's set for trial that's on the old statute, and it's about a woman repeatedly showing up to someone's house.
Yes.
Then the should know could stay in.
Correct. So the question was, the question was if you have a case that's based on conduct repeatedly showing up at the victim's house, can the should know stay in? The answer should be yes, because that's no longer pure speech, that's conduct, and so you don't have the same sort of free speech protections. One last suggestion, if you're trying a case based solely on communications or not threats, just be aware that we have some risks here. If you remember, this is more than 10 years old now. There was a Supreme Court case called Snyder versus Phelps. This is from the folks at the Westboro Baptist Church who would picket military funerals with signs saying things like, your son is in hell, God hates America, those sorts of things. In that case, the U.S. Supreme Court said that the members of the church were charged with tortious infliction of emotional distress. The Supreme Court said, well, actually, even that's protected under the First Amendment, even though it was intentional, because it was being done with a political purpose. It's pure political speech. The last thing to bear in mind with these sorts of issues is there's going to be a difference here between facial and as-applied challenges. So there's an incentive in a lot of these cases for defendants to suggest that, well, even though it's not harming my speech, it might harm somebody else's. This gets into a really complicated area of law, and so rather than try to give like a big long rundown of overbreadth doctrine and facial versus as-applied challenges here, I would just recommend again that if you have a challenge under counterman, that you make sure that the defense has filed proper notice for the AG's office to get involved so we can help you guys out on that. All right, that's enough of me for a while. Do you want to take over?
All right. This next case, before I get into it, is one where David's invocation about improvement, not blame, applies especially. This is a developing case that is very disappointing and distressing obviously for the prosecutor involved, for the victim's family, and I'll get into that. But it's also a situation where the prosecutor really couldn't have done much. This is a case where the judges involved screwed up, and as a result, double jeopardy applied in a case that's pretty gruesome.
And just as a quick
Yes.
note on this one, just this week we've made a decision to seek cert in this case. So this case has important lessons, but we haven't heard the last word yet.
It is ongoing, and we'll hope for a better result for the victim and his family. So basically, I'll give some factual background first. In this case, Mr. Mitten got in a fight with his brother-in-law and pretty brutally beat him. He knocked him to the ground and choked him, and his brother-in-law was pretty severely injured. He had bleeding in his eyes and brain, a concussion, bruised vocal cords, hearing and memory loss, swelling in his face and right ear, blurry vision, and back, head, jaw, and neck pain. And so the state charged Mr. Mitten with 2 counts of aggravated assault. At the end of the first day of Mr. Mitten's trial, the trial judge realized that he had a distant, it was not a close family connection at all, a distant family connection to the wife of Mr. Mitten's victim, his brother-in-law. And so a couple hours later, Mr. Mitten moved to disqualify the judge that evening. The next morning, the presiding judge, understandably feeling kind of under the gun, granted his motion, declared a mistrial, and appointed a new judge. And then the now disqualified judge, the original judge in the case, proceeded to meet with the jury and discharge them, sent them home, and then met with the parties and informed them what he had done. This is, just as an aside, this is one of the first points where this could have been addressed. As far as we see the record, there was no reason that the motion to disqualify the judge needed to be granted in the first place. And if that had been the case, then we would have been fine. Anyway, this is what happened. So the state sought to re-prosecute Mr. Mitten, which I think the judges anticipated and didn't necessarily see a problem in that happening. However, Mr. Mitten, he filed a motion to dismiss, claiming that re-prosecution would violate his constitutional protection against double jeopardy, since the jury was impaneled and then discharged before a verdict was rendered. The new trial judge, trying to figure out what was going on, denied the motion, and Mitten filed an interlocutory appeal, which is this case. Just some legal background to understand why the ruling came down as it did. Jeopardy attaches when a jury has been sworn and impaneled. So in your case, once the jury is sworn in, that's when you need to start worrying about double jeopardy applying. And where, I'm covering this case so early in this presentation because it's procedurally really weird, but some things could have been done along the way, again, by the judges, but the prosecutor might have been able to intervene and fix or help the judge avoid some mistakes. But anyway, so once a mistrial is declared after jeopardy attaches, so after the jury has been sworn and impaneled, the double jeopardy clause of the United States Constitution and the Utah Constitution are automatically invoked. Therefore, the declaration of a mistrial before a verdict is entered generally operates as an acquittal. There are a couple exceptions to this. First is when the defendant consents to the discharge of a jury, for instance, if he moves for a mistrial or something like that. Second, legal necessity requires the discharge in the interest of justice. And this is the exception that might have applied here, but a couple of things need to be true, need to be found before legal necessity applies. So it requires two elements to be met. First, the trial judge has a duty to carefully evaluate the circumstances of the particular case and determine that legal necessity requires the discharge of the jury. This is the important point. This must include affording the parties adequate opportunity to object and consider possible alternatives to terminating the proceeding. Second, the judge must establish a record of the factual bases for its conclusion that a mistrial is necessary, as well as the reasons why there is no reasonable alternative under the circumstances. So the Court of Appeals held in this case that since the judge discharged the jury without giving either party an opportunity to object, the first element of the legal necessity exception to double jeopardy was not met. Therefore, double jeopardy was invoked and re-prosecution was barred. Again, David mentioned this. We are seeking certiorari review, and we'll see how that goes. I wanted to go through, because the actual decision, the holding from the court is pretty summary, but then they take the opportunity to provide clarification of the proper procedure in these circumstances, and that's a pretty good chunk of the latter part of their opinion. And I just want to walk you through what the Court of Appeals says in that part of their opinion. So they offer guidance to the initial judge, the presiding judge who receives and reviews the motion to disqualify, and the judge who takes over in the event that the initial judge is disqualified. So when the initial judge receives a motion to disqualify under the rules of criminal procedure, they have two options. They can grant it and disqualify themselves, or they can certify it to the reviewing judge. If they grant it, they're done. They need to do nothing else, and they should do nothing else with the trial. A new judge should be appointed and should proceed. If they certify it, then the reviewing judge can either grant or deny the motion. If they grant it, again, the initial judge should do nothing. In this case, the initial judge should not have gone and talked to the jury and discharged them when he was not even the judge presiding over the trial anymore. He had no authority to do that. If the reviewing judge, denies the motion, then trial can continue. Now, guidance to the reviewing judge. Once they receive a motion to disqualify, it's certified to them, they again can deny it or they can grant it. If they deny it, as we covered, the initial judge continues with the trial. If they grant it, then they need to assign the case to a judge who can immediately deal with the issue of whether to declare a mistrial, or temporarily assign the case to herself to make that determination. This is something that needs to happen immediately, and that makes sense. And it makes sense why, with that in mind, why the trial judges in this case acted as they did, but they did so without considering the legal consequences of doing so less than carefully. And finally, the takeaways for the assigned judge. And this is kind of where things went wrong, where this judge was hamstrung in his ability to follow the law. So if the initial judge is disqualified by himself, or the reviewing judge, a new judge may be assigned to the case with the trial ongoing. And they need to, as the Court of Appeals directs, address whether to declare a mistrial and discharge the jury. If they decide to declare a mistrial, or continue with trial, those are their two options. A quick note, if the assigned judge cannot preside over the trial in a reasonable time frame, if they decide no mistrial needs to be declared, then a new judge may be assigned, and that's, the judges can figure that out. But this, again, is where things went wrong. The assigned judge could not do either of these things. He couldn't declare a mistrial because the reviewing judge had already declared a mistrial, and he could not discharge the jury because the initial judge had already discharged the jury, again, without authority and without consulting with the parties. So if you find yourself in this admittedly kind of wacky situation, keep this case in mind and point the judge to it. They have all the power in this situation to make sure things are done correctly. But we can remind them that there is a correct way to do that. I know that's a relatively procedurally complicated case. Does anybody, I'm finished with my portion of it, but if anybody has questions, I'm happy to address those now. Okay, great. Mike.
Oh, thanks, man. Okay. I'm going to play a clip, and I'm going to ask you to identify how the judge erred.
I sent you to 18 months in the city correctional facility at Rikers Island.
Edie, she's twitching.
I'm not finished! On a more personal note, let me just go on record as saying that there's no place for fake charlatans.
Your Honor?
Shut up! Fixers like you in decent society.
Your Honor, this is important.
You play on the gullibility of innocent people.
Yes, sir.
Be quiet.
But
My hands were tied by the unalterable fetters of the law, and I would invoke the tradition of our illustrious forebears. Reach back to a purer, sterner justice, and have you burned at the stake. I sent you to 8.
All right. So there were two errors. One, you don't lose your temper in front of psychoreactive slime, obviously. The second one was that the judge did not allow the defendants to allocute. And you always have to do that. So in James, the defendant pleaded guilty to 2 charges, drugs and weapons. And both the state and the defendant were jointly recommending 36 months probation with treatment. But the court wasn't inclined to accept that joint recommendation because, as the court noted, in one case the defendant had a brick of meth and guns and money, and in the other case he had a large quantity of everything, and the judge thought, maybe not for the treatment community. So the judge asked for a PSR. PSR came back and actually also recommended 36 months probation. But the court didn't think that was appropriate and sentenced the defendant to prison. At sentencing, the defendant's lawyer, made an argument on his behalf, indicated that James was ready to put that life of guns and drugs behind him and he wanted to get treatment. And James actually submitted letters through his attorney to the court, but at no point did the judge ever give the defendant the opportunity to address the court, to say anything. He was never invited up to say, anything that he wanted before sentence was imposed, and went to prison. So on appeal, James claimed that the trial court plainly erred in not giving him the opportunity to allocute, and the Court of Appeals agreed. The right to allocution is clearly stated in Rule 22, and it's firmly established in our jurisprudence. And so in all circumstances, a defendant must be given the opportunity to allocute. And because of the importance of that right, the Court of Appeals also held that this is a situation where prejudice will be presumed unless the defendant receives the absolute most minimal sentence that is permissible. So the court, in strong language, indicated that both the defendant and counsel shall be affirmatively afforded an opportunity to make a statement, present any information of mitigation, or show any legal cause why sentence should not be imposed. And the trial court cannot be passive in that role and actually must invite the defendant to allocute if he or she wants. It's worth noting that the Supreme Court has actually granted cert in this case, so stay tuned. But as a general rule, just make sure that your district court is giving an opportunity for allocution. If the district court takes a passive role in that obligation, make sure that you jump in and ensure that the district court fulfills that obligation. Because sometimes defendants just have one more thing they need to say before they get sentenced.
guess I would add, I mean, if you may have noticed a continuing theme of our Court of Appeals being really concerned about getting things right, even if there's no objection to it. Just may be sort of helpful as a way to think about the mindset of our current Court of Appeals. I think our Court of Appeals, we have some really smart, dedicated judges, many of whom were smart, dedicated trial judges before they joined the Court of Appeals. What that can mean sometimes, though, is that when they get a case like this, they say, well, that's not how I would have done it, and it may very well be true. They may well have not done it that way. But our Court of Appeals is quite willing to reverse if they see something and say, well, that's not how I would have done it. I don't think I'll get through this entire case, but at least I hope to get through half of it. Let's talk about State versus Green from our Supreme Court. So this is a case that attracted quite a bit of media attention involving Tory Green, who was a football player at Utah State University. The Salt Lake Tribune actually won a Pulitzer Prize for reporting on campus sexual assault that included some of its reporting on this case. And the fact that the Tribune weighed in on this is going to become relevant for reasons that we'll discuss later. So basic facts of this case: Green was a student and a football player at Utah State University. While there, he raped or sexually assaulted at least 6 different women. There was a 7th who was severed from the rest of this case. Our colleagues in Cache County would be able to update you on that, but for purposes of this case, we have either rape or sexual assault charges against 6 different women. The victims all privately reported to law enforcement or to university employees, to teachers, to friends, to family, or religious figures before they came forward to the police. And then they ended up going public in response to an article in the Salt Lake Tribune where one of the victims came forward first, and then, as is sometimes the case with high-profile defendants, other people started coming forward after that. So there are 2 key questions that the Supreme Court was addressing in Green, and I think I'll get to one before our break and one after. The first is the propriety of the admission of other acts' evidence. In other words, was it okay to charge or to try this case all together with 6 different victims in one trial? And then question number 2 is the admission of prior consistent statements. So we'll take up that first point first, the admission of other acts of evidence. So just a quick background on where our rules are at. Rule of Evidence 401 says that evidence is relevant if it makes any fact of consequence more or less probable. Rule 402, all relevant evidence is admissible unless a statute, constitutional provision, or another law says otherwise. Then Rule 403 is this court may exclude relevant evidence if its probative value is substantially outweighed by a risk of unfair prejudice. So generally speaking, all relevant evidence is presumptively admissible. This should all be familiar to all of us. Rule 404B provides a limited exception to this, so evidence of a crime, wrong, or other act is not admissible to prove character in order to show that on a particular occasion the person acted in conformity with the character. However, it may be admissible for other purposes. This should also be familiar to all of us: motive, opportunity, intent, preparation, plan, or other purposes, right? These are just examples. These are not an exclusive list. So what that means is, if you think about this as sort of a chain of logical inferences, right? This is an improper inference under Rule 404. The defendant had previous fights with the victim, therefore the defendant is a violent person, therefore he was violent again. That's improper, right? Because that relies on an inference about character, the character of the defendant being a violent person, and then that he acted consistently with that character later. A permissible example might be the defendant had a previous fight with the victim, therefore he had a motive to fight with the victim again, therefore it's more likely that the defendant fought with the victim again, right? So that's the key distinction here between character and non-character inferences. So Green's argument at trial is that all these victims were just making it up. He was a high-profile athlete, they saw his name in the papers, and they wanted money and fame and attention. The state's rebuttal was, well, look, man, it's really unlikely that 6 different people would all just happen to make up sexual assault claims against you out of nowhere. There's evidence presented at trial that none of these victims knew each other, that they never met until after they came forward with their allegations. So, I mean, what are the chances of that 6 different people are all going to be able to independently fabricate in this way? So that's the state's argument at trial. And the question before the court is that a character inference or is that a non-character inference? Chief Justice Durant, writing for a unanimous court, says, no, that's not a character inference. Or put differently, the state's inference in this case was proper. The evidence was admitted for a non-character purpose, to show that the women's allegations were not recently fabricated. Green put the women's credibility at issue by claiming they were lying, and the accusations of multiple similar acts of sexual misconduct by Mr. Green corroborated each woman's story. The evidence did so by dispelling any realistic possibility of independent invention, not by attacking Green's character. So the court says that the purpose for which the state used the evidence in this case was fine because it shows it would be really unlikely that 6 different people would independently fabricate all of these claims against you. Therefore, it's unlikely that his defense, that they all independently fabricated claims, was true. In reaching this holding, the Supreme Court overruled the doctrine of chances, and this gets kind of a weird wrinkle. So historically, the doctrine of chances was what was considered a proper inference under 404, the idea being, well, if there's a really low chance of something happening and it happens multiple times over and over again, it's not likely to happen by chance. Classic example was an old-timey English case, sometimes called The Brides in the Bath, where a husband had 3 different wives, all of whom drowned in the bathtub, and the court said, well, you can introduce all of those together because it's really unlikely that that same unfortunate bathtub drowning would happen over and over and over again. That inference, that it's unlikely that a highly unlikely thing would happen over and over and over again, is still sound in my view. What was not sound is what our Supreme Court had been doing under its own doctrine of chances, where through a series of cases like Verdi and Richins, the court was introducing more and more hurdles to prevent the state from getting this in. So it was becoming, at one point, very, very difficult for prosecutors to be able to introduce this sort of evidence to rebut claims of fabrication because our Supreme Court just kept adding new common law requirements before they would admit it. So the Supreme Court says, all right, we're going to clear away all those old common law requirements that we were creating. Those requirements and hurdles have proven to be more confusing than helpful, and we've strayed from the plain text of our rules. So we overrule our old doctrine of chances and emphasize it's the rules of evidence that are the primary law of the admission of evidence. So if we're arguing these cases, we're not arguing primarily under cases like Verdi or Richins anymore. We're arguing under the plain text of the rules of evidence, 401, 402, 403, and 404. So that's why I say right here it's sort of important to distinguish when you're reading Green between the sort of traditional common law doctrine of chances, which is good. We like that inference, and what Utah courts did with it, which was create a whole bunch of artificial barriers to the introduction of this sort of evidence. So a quick overview then. Is this inference permissible? Multiple victims have accused the defendant of rape. Therefore, it is more likely the victims are telling the truth about the rape. Therefore, it's more likely that he's guilty of rape. I'll ask, quick, who's not sure if this is permissible or not? Okay, good. So only one person's not sure, so everyone's going to raise their hands now. Who thinks this is permissible? All right, and who thinks it's not permissible? I think some of you are not sure, right? Actually, those of you who are not sure, I think, are correct. It's not clear whether this inference is permissible. The defendant is accused of multiple victims accused the defendant of rape, therefore it's more likely that they're telling the truth. Why is it not clear? Because the chain of reasoning I've laid out here doesn't make clear whether we're relying on a character inference or not. So if we say, look, ladies and gentlemen of the jury, multiple victims have accused the defendant of rape, It would be very unlikely that they'd all be able to independently fabricate similar claims. Therefore, it's more likely that they're telling the truth. That's good. That's the inference that Green approves of. We say, ladies and gentlemen of the jury, multiple victims have accused the defendant of rape. Therefore, he's clearly a rapist. Therefore, it's more likely they're telling the truth about rape. That's not proper, right? Both of these inferences are ending up in the same place. They're both ending up with, it's more likely the victim is telling the truth about rape. One is proper, one is not, because it relies on a character inference. So it's sort of not enough to look at Green and just say, now it's open season on introducing prior acts. We need to have a cogent non-character theory for why we're doing that. So takeaway number one, it's not open season on character arguments. We still need to articulate a legitimate non-character purpose. If you have a thorny case, particularly like a sexual assault case like this one, and you want to brainstorm non-character purposes, give me a call. Green is my case, and I have all sorts of ideas about various permissible non-character purposes and sort of sources I can point you to help you frame those sorts of arguments. So it's not open season. We still can't make character arguments. But Green does mean that it should be considerably easier to admit this sort of evidence of prior claims to rebut recent charges of fabrication. So if you have a case involving a serial offender who's just saying people are making it up, consider using Green to try to get that evidence in. You might see this as not just in sexual assault cases, but like serial public masturbation cases. What are the chances that 5 different strangers, none of whom know each other, would have all fabricated the idea that this person was exposing themselves in public? The next point of Green is admission of prior consistent statements, but I see we are bang on at 10 for our break, so we'll pick up with the second half of Green in 15 minutes. See you all then.
Hey, Tyson, will you go tell those people in the hallway we're going to start, please? Thank you. Oh, wait, we don't have presenters. Oh, there's Mike. It's the Mike show now. Yeah. A couple things is at the registration desk, I went down to the front desk and got this little city center map. There's not enough for one per person, but if you're going together, like as a group for lunch, it has 81 places that you can get some either food or beverage listed on here. I got some recommendations from some Utah folks that work here in Provo that I can give you, but Joe Vera's Mexican is number 5 on this. They've got some really good lunch specials, I've been told. Two Jack's Pizza. There's a Korean place. There's a Native American food, Black Sheep Cafe, Kay's Kitchen, Japanese. Basically, you can't go wrong on the food. For those of you that parked in the garage, we also have the parking validation. If you are driving somewhere for lunch, make sure you pick up one of these yellow validation cards and you'll just drop it. There's a little slot as you're leaving the parking lot. And certainly at the end of the day. So with that, we will go until 11:45, at which point we will take a break until 1 o'clock. So we'll turn it back over to David Tanner and Mike.
All right, thank you, everybody. Welcome back. I'll just a minute or two to get settled. All right, so we were talking about State versus Green. This is a case, again, where you had multiple different rape and sexual assault victims come forward and tell their stories after these stories had been reported in the Salt Lake Tribune. So that brings us to the second major point of Green, which is the admission of prior consistent statements. So just a little bit of background here. Rule 801C obviously provides the definition for hearsay, the general definition, and then 801D1B provides an exception. So a statement is not hearsay if the declarant testifies and is subject to cross-examination, and the statement is consistent with the declarant's testimony and is offered to rebut an express or implied charge that the declarant recently fabricated or acted from a recent improper influence or motive in so testifying. This is often shorthanded to prior consistent statements to rebut a claim of recent fabrication. So this does not mean that a party can argue someone should be believed merely because they repeated themselves. You can't just say, well, not only did the victim testify credibly on the stand, but look at this video interview where the victim says all the same things. Look how credible the victim is in this interview, therefore you should really, really believe her. That would be improper. The prior consistent statement exception applies only when the consistent statement predated the motive to fabricate. So the theory here would be, an improper theory here would be the rape victim testified about being raped and she told the same story to police. Therefore, she's credible. That's improper under the prior consistent statements rule. A proper theory would be the defendant claims the rape victim made it up because she was angry at the defendant slept with her friend. But the victim told police the same story before the defendant slept with her friend, right? So that's if you have that's a prior consistent statement that precedes the claimed motive to fabricate. So that's just an abstract example. Let's look at what actually happens in Green. So Green's theory at trial is that these victims are fabricating their sexual assault allegations, at least in part, because they want money and attention after reading articles about him in the Salt Lake Tribune. And the state rebuts that suggestion by introducing evidence that the victims described the crimes to friends and family members, to teachers and religious counselors before the articles were published. So the inference being, no, they didn't make it up just in response to the Salt Lake Tribune articles. They were telling the same story before that alleged motive to fabricate or that alleged means of fabrication arose. So Green's claim on appeal is, well, that's improper because the victims might have had other motives to fabricate too. Maybe they were upset they didn't get a second date. You know, I'm sure it would be very upsetting if you didn't get a second date with your rapist. Wanting to avoid embarrassment or wanting to receive academic accommodations, right? And we see all sorts of these types of claims in sexual assault cases. You know, several of these victims suffer real serious trauma as a result of what they've gone through, and that results in them starting to struggle in school or needing special accommodations in school. One of them writes about her sexual assault for a school assignment, and Green says, aha, well, in addition to fabricating based on the newspaper articles, they also fabricated because they wanted to get a good grade or because they wanted to get special accommodations in school. So the question that appears, as far as I can tell, to have been a question of first impression in Utah is, must a prior consistent statement rebut all motives to fabricate, or must it only rebut one potential motive to fabricate? So Green has raised a whole bunch of different potential motives to fabricate here. The prior consistent statements rebut some of them, such as the Tribune articles, but they don't rebut all of them. So is one enough, or do you need to rebut all of them? Courts have gone both ways on this nationwide, but Utah sides with the overwhelming majority approach. Said, well, the plain text of the rule merely requires that the prior consistent statement rebut an express or implied charge of fabrication. It does not require it to rebut every potential motive to fabricate. So if you have one of your cases and you want to introduce a prior consistent statement, it doesn't need to rebut every potential claim of fabrication, it just needs to rebut one. The one caveat is just remember that Rule 403 applies, right? So if there's a potential claim of fabrication that isn't really raised or that's really, really minor to the case, and the prior consistent statements are really, really prejudicial, then you might still have it excluded under Rule 403, even despite Green. But the general rule is going to be that as long as it rebuts one significant motive to fabricate, it's admissible under the prior consistent statements exception. We'll return, by the way, to the prior consistent statements exception a little later and see sort of some of the limitations of that exception. Okay, here I am. So this next case presented a couple of different issues that might come up for you as prosecutors and that are important to be aware of. So State v. Centeno. Centeno was convicted of rape, aggravated assault, and domestic violence in the presence of a child after he beat and raped his girlfriend in the presence of their children, of their two children. At trial, one of the children present during the assault began to testify for the state, but became so emotionally distraught that the court took a recess, and after the recess, the state decided not to continue to examine the child for her own sake. Centeno did not cross-examine or otherwise question the child or later call them to testify. And on appeal, he claimed that this violated his Sixth Amendment right to confrontation and should have entitled him to a new trial. A separate claim involved a couple of items of video evidence that were allowed to go back with the jury into deliberations. He made a couple of different claims related to these, including that they placed undue influence on certain parts of the case. And in particular, he took issue with one item of evidence that was admitted but not played in full in open court, but that the jury did take with them into jury deliberations and perhaps saw in full. The court didn't buy either of Centeno's arguments, thankfully. On the child testifying issue, it held that although the state elected not to resume its examination,
after child victim became emotionally distraught, Centeno had every opportunity to call child back to the stand for cross-examination and elected not to. His confrontation rights were merely not exercised. They were not infringed. And on its face, this claim makes sense. It's like, hey, like, this victim did testify to an extent, and I'm not going to be the bad guy who, makes this emotionally distraught child come back up and testify. But that's not enough to claim or to show that his confrontation rights were violated, right? And so that's, sadly, there are all too many child sexual abuse cases out there, and so this is a situation that you probably already have encountered or might encounter in the future, where you have a child witness who's going to struggle like this. And so it's best to be prepared for such a situation and for the arguments that a defendant is going to raise when that happens. In terms of the jury deliberations and taking exhibits back with them, we thankfully have a quite permissive rule of criminal procedure 17K, which allows all exhibits to go back with the jury, presumptively all of them. And let's see, let me find the language here. The rule expressly allows the jury to take all exhibits back to deliberations, except those which the court decides in its discretion the jury should not have. And this is some serious discretion for the trial court, as the court holds here. And a court abuses its discretion only when allowing the exhibit in the jury room would, quote, create a likelihood of injustice, such as when the court is motivated by bias, prejudice, or malice, or when its decision was against the logic of the circumstances and so arbitrary and unreasonable as to shock one's sense of justice. So a trial court's got to do a pretty bad job to show that it abused its discretion in allowing all exhibits, again, which are presumptively allowed to go back. I wanted to cover this in particular because of this footnote that the court dropped in relation to Rule 17K. I'll read it out loud for us. In Wyatt v. State, we referred Rule 17K to our advisory committee on the rules of criminal procedure for direction on whether the rule itself should include additional guidelines for district court in determining whether an exhibit should be withheld from the jury. The committee currently has the issue under consideration, and we look forward to receiving its report. I wanted to include this just so that we're all aware of it. Right now, we as prosecutors have a lot of leeway in what the jury gets to receive or gets to review in its deliberations. That might change in the near future based on this footnote. I don't know the details of the Committee on the Rules of Criminal Procedures debates or proceedings on this rule. I can look into that in future, and those records are public, and so we can all look into those as well. But just be aware that might be a development in the rules and then in case law as we go forward.
Cool. Thanks. Yeah. Okay. This is State v. Tuinman. This is a minivan. That's a baseball bat. So Tuinman and her relatives had a nephew who reported that he had been sexually abused by a family friend when he was younger, and went to the police, reported that, and then nothing happened. And so Tuinman and her family, including the nephew, were hanging out one night. Some of them were drinking heavily, and they started talking about the nephew's abuse allegations, and they basically decided that the police weren't going to do anything and they needed to take justice into their own hands. So they piled into the minivan, and by some reports there were some other vehicles, and they caravanned over to the alleged abuser's home where he was just finishing dinner with his wife, and they broke in. A bunch of family members beat the man really severely, and then Tuinman, with a baseball bat, attacked the wife, and she beat her savagely, and the woman succumbed to her injuries a few days later. So Tuinman was charged with murder, and other crimes. Initially, it was charged as a capital offense, and so that becomes pertinent in just a minute. So let's see. Okay, here's a timeline. So Tuinman is charged on April 9th, 2018, and on November of 2018, the capital charge was dropped. And so that's pertinent because, as you know, if it's a capital crime, the requirements for appointed counsel are more stringent, and they were having difficulty in the small jurisdiction locating an attorney that they could appoint to represent Tuinman in a capital case. So you'll notice that's April 9th, 2018 through November of 2018. January of 2019, at prelim, Tuinman invokes orally her speedy trial rights. They have the prelim, the court asks for a briefing, and after all of that's completed, the court issues its bind-over order in May of 2019. And then between May 2019 and March 2020, Tuinman and her lawyers filed 16 motions. Many of them were motions in limine, some of them were motions to dismiss, but in any event, 16 motions, all of which required responses, and some of which required oral argument. And then March 2020, pandemic, and the Supreme Court issued its orders saying that all non-essential functions are to cease, and then the later orders putting a halt to all jury trials, and that went on for a while. And during that time, Tuinman is asserting her speedy trial rights, and finally, in March of 2021, Tuinman gets to trial. So she goes to trial, she's convicted, sentenced. Oh, I'll just populate that really quickly. And also, going back here, between April 2020 and December 2020, the district court tried very, very hard to get Tuinman her trial. The district court at one point, when it appeared that trials were going to resume, said that, you know, the court would put its entire calendar on hold to prioritize this case, even if it meant postponing everything else on its docket for weeks. So on appeal, Tuinman she claims speedy trial violation. It was 1,072 days between the time charges were filed to the time it finally got to trial. And so on appeal, when looking at speedy trial claims, the court looks at the four-factor test from Barker v. Wingo: length of delay, reason for delay, defendant's assertion of the right, and whether the delay resulted in prejudice. So in the Court of Appeals analyzed all these factors. The most important oftentimes is the reason for delay. And in looking at that, the Court of Appeals determined that 641 days was attributable to Tuinman, either because of her counsel's unavailability for certain trial dates that the trial court had proposed, or because of motions that were filed that needed to be litigated. So over half of the delay was attributable to the defendant. 233 days were attributable either to the state or to the district court, but the court found that those delays were not intentional. And in this case, Tuinman also claimed that, you know, COVID should weigh against the state, because even though the district court worked very diligently to try to get the case to trial or to set a trial date, you know, the delay was just too long for speedy trial purposes. And the Court of Appeals said the delays associated with a once-in-a-century worldwide pandemic should not, in fairness, be held against the state in a Sixth Amendment speedy trial analysis. So if you are still dealing with any cases that, you know, were holdovers from COVID, delays associated or caused by COVID itself should not be held against the state. Tuinman also made some other claims, one of which I just want to highlight because it may come up occasionally. Tuinman had an alibi. She had a number of family members who she said were going to say that she wasn't even at the house when the raiding party went to the victim's house. She noticed up her sister, But then at trial, she also wanted to call her mother, but she never gave notice under 7614 or 7714, I believe, that the mother was going to be an alibi witness. And so the district court did not allow the mother to testify. On appeal, the Court of Appeal said, these types of procedural rules, including alibi notice statutes, are exactly the type of legitimate interest that can permissibly impact a defendant's right to present a defense. And so just good to keep that in mind.
Uh-oh. We've drawn Judge Snyder.
Is that bad?
Well, he's had it in for me ever since I kinda ran over his dog.
You did?
Well, replace the word kinda with the word repeatedly, and the word dog with son.
So let's talk about judicial bias. All right, State versus Samudio. So the state moves to revoke the defendant's probation, and the revocation hearing is held in front of a judge who represented this same defendant as a defense attorney. 4 prior occasions, and under 2 of those occasions, the attorney, later judge, actually withdrew from the representation. At the hearing, the judge says the court has seen Mr. Samudio in more than one jurisdiction, and the court's consistent experience with him is that he's been a moving target of medical conditions that arise at convenient times when either a warrant has been issued or something is required of him. So he's not impressed with this guy. Worth noting, by the way, that the judge has seen the defendant here both as a client and as a judge at this point. So the defense doesn't actually express any concerns about the judge's impartiality. And the court actually notes that that may have even been because he expected his former attorney to be more sympathetic than another judge would be. But later, without having objected at trial for the first time on appeal, are we sensing a theme here? He challenged the trial judge, raising plain error claims under the Due Process Clause and under the Code of Judicial Conduct. So just a quick reminder for those of you who aren't as immersed in appellate procedures we are, plain error has 3 elements. There must be an error, it must be obvious, meaning plain, and it must be prejudicial. So the court holds there's no prejudice here under the plain error test because pretty much any judge would have revoked Samudio's probation based on how extensive his criminal record was. So state dodges a bullet here. The revocation of probation stands. But the rest of the opinion very strongly suggests that the Court of Appeals thinks this district court judge should have recused. Although it's actually surprisingly confusing about whether that's a holding or whether it's dicta. So, parts of it say, we agree the judge should have recused himself. The recusal of the judge plainly should have happened. Other parts say it would have been prudent to recuse. It appears that the rules were violated. Out of an abundance of caution, the judge should have recused. Even assuming these violations occurred, he wasn't entitled to relief. Recusal would have been prudent or even required. I've read this opinion multiple times. I have no idea whether this is a holding or not. Riddle me this. If you figured out this riddle, let me know. But this does tie into the theme that I was alluding to earlier of our Court of Appeals is very likely to say, well, if I wouldn't have done that when I was a district judge, so we're really, really concerned about what we think are lax standards among district judges. So even though the Court of Appeals here is really concerned about judicial bias, even when the defendant himself has not complained, even when there may be reasons the defendant may have not wanted to complain, and even though there's an inadequate record on the question, right? We don't know in this case why the defendant never objected on the grounds of judicial bias. The Court of Appeals has also actually reversed a conviction for ineffective assistance regarding judicial bias in a case from earlier in 2023, State versus Elkface. Again, that's a case where the defendant didn't object. There may have been good reasons why the defendant didn't object, but there may have also been reasons calling for recusal. In that case, where the evidence was closer, the Court of Appeals reversed for ineffective assistance of counsel for not raising a judicial bias claim. So the takeaway for all of us here as prosecutors is if you're aware of any possible grounds for disqualification, make a record and consider maybe even moving or suggesting disqualification yourself, even if the defendant hasn't raised it. That way you can at least get it all out on the record. The lack of an objection will not necessarily save your case. That's, in this case, we dodged a bullet just because of the overwhelming strength of the evidence. I think Smudio had something like 38 different violations or something like that, but in a closer case, this easily could have been reversed. And in another case like Elkface, it actually was. Another really quick case here, and another Simpsons clip.
It's my job to be repetitive. My job. My job. Repetitiveness is my job.
All right, so State versus Meyer. Meyer's ex-husband discovered bruises on their daughters. A child abuse case. Meyer is charged with child abuse. At the preliminary hearing, Meyer's new boyfriend, Glenn, gave really hostile, reluctant testimony during which he denied causing the daughter's injuries. So Glenn is sort of the alternative suspect here. Rather than it being mom who does the abuse, the theory is, well, it's mom's new boyfriend who did it. Glenn testifies at the preliminary hearing, but Glenn later gets married to the defendant, and so he's unavailable by reasons of marital immunity from testimony, and then he's also unavailable due to medical issues. So Glenn doesn't testify at trial. So because Glenn is unavailable at trial, the state introduces his preliminary hearing testimony under Rule 804B1, which is the hearsay exception for former testimony. All right, so we'll take a step back and remind ourselves of what 804B1 says. So this is the hearsay exclusion for former testimony. It applies to testimony that was given as a witness at trial, hearing, or lawful deposition during a prior hearing, and is now offered against a party who had an opportunity and similar motive to develop it by direct, cross, or redirect examination. So in this case, there's no question, preliminary hearing testimony is testimony given by a witness at a prior lawful hearing. So the question is, did the defendant have, at the preliminary hearing, an opportunity and similar motive to develop cross-examination? On appeal, our Court of Appeals says no, he didn't have or she, in this case, didn't have an adequate opportunity to develop cross-examination and reverses the conviction. So just a quick background here. Article 1, Section 12 of the Utah Constitution says the only function of a preliminary hearing is to determine whether probable cause exists. This is actually something that prosecutors and in particular victims advocates really pressed for, because previously defense attorneys were using preliminary hearings not just to determine whether probable cause exists, but also as an opportunity for a discovery tool to sort of probe at what the victim's story might be. And in practice, they would use it to attack and harass the victim's testimony and credibility. So, we since adopted a constitutional amendment that says, no, the only thing we're doing at a preliminary hearing is determining whether probable cause exists. So as a result, the Court of Appeals says this places most credibility determinations outside the reach of a magistrate at the preliminary hearing. At the preliminary hearing, it's not the trial court's job to resolve credibility disputes. Right? And again, we like this rule. We generally like this rule because it prevents defendants from using preliminary hearings to harass victims or to intimidate witnesses. Okay, so that's the rule. We generally like it. But because most credibility determinations are outside the scope of the preliminary hearings generally don't offer the same opportunity to cross-examine and attack motive or to attack credibility that you would have during trial. And as a result, as a general rule, preliminary hearing testimony is not going to be admissible as prior testimony under Rule 804B1. So defense counsel, according to the court, could have reasonably expected the court to limit the questioning that's strictly necessary to address probable cause and to prepare it accordingly. And so as a result, the admission of the hearsay testimony in this case, because Glenn never testified and he's a primary alternative suspect, is prejudicial. The court reverses the conviction. So takeaway here for admission of prior testimony from the preliminary hearing. The door is not completely closed, but it's just barely cracked. So my takeaway and my advice would be don't introduce preliminary hearing testimony under the prior testimony exception unless you absolutely have to. The court says, although there may be scenarios where for whatever reason defense counsel possesses the same motive and opportunity to cross-examine at the preliminary hearing, they specifically have said that those sorts of scenarios are going to be rare. So the door isn't completely closed, but using this evidence is going to carry a significant risk of reversal. So if you're going to introduce preliminary hearing testimony under the prior testimony exception, think really long and hard about it because it could lead to a reversal.
So next is State v. Herrera. This is another case where, thankfully, almost the judge could have caused a reversal. So the facts here, Herrera was charged with assault after he threw a lamp at his girlfriend. The important points to note for our purposes are at least once and pretty much several times, the trial judge told Herrera, if you go to preliminary hearing, you're going to trial on the original charges. I won't allow plea negotiations after that. Thank you. On appeal, he claimed this coerced him into waiving his preliminary hearing. Thankfully, from the record, it was clear that this was not true. It was clear that he had already rejected the state's best offer and waived preliminary hearing for other reasons. Therefore, the Court of Appeals did not buy his argument. However, this is another footnote case. The court did, quote, condemn any improper insertion by the trial court into the plea bargaining process, singling out the possibility that a court may condition the permissibility of plea bargaining on waiver of a preliminary hearing. I don't need to belabor the point on this, but this is another instance where judges need to do a better job, and where we as prosecutors can step in and say, Your Honor, you're really not supposed to be inserting yourself into this process. You can point them to Utah Rule of Criminal Procedure 11 and just kind of, they should know that's not their job. So just be aware. Thankfully, not an instance where this caused a problem or a reversal, but troubling nevertheless.
State v. Jessup. Okay, so Jessup threatened his girlfriend with an unloaded gun. He put it to her head and dry fired it. He did the same to himself. After that, he loaded 2 guns, fired a shot into the ground outside. The girlfriend was able to get out of there, and Jessup told her that if she called the police, there would be a bloodbath. And then he fled into the neighborhood and started walking around. The police were able to ping his phone and identify a couple possible locations where Jessup might be. 2 officers were following those pings. They went to one, no luck. They were on their way to the second ping location, and they saw Jessup walking on a dark path close to the neighborhood. And so they jumped out of their car as soon as they saw him, neglected to activate their body cams because they jumped right into action. They started giving Jessup commands he had a cell phone in one hand and a gun in the other hand. So instead of following those commands, he pointed the gun at the police officers, and the police opened fire. So Jessup was injured, but made a full recovery. Medical came and got him to a hospital. He was very briefly handcuffed right after the shooting occurred, but then handcuffs were removed so that Jessup could get to the hospital and have surgery. 15 hours after surgery, 2 detectives go to visit Jessup in the hospital to get his side of the story. And the detectives, when they arrived, were very clear with hospital staff. They said, he's not a suspect, there's no need for security, he's a free man. And then they went in and were able to talk to Jessup, who one of his injuries was to his face, and so he wasn't able to speak very well, but he was able to answer questions by writing them down on a notepad. And detectives talked to him extensively, and nurses were allowed to come in and out while they were talking to him. And then afterwards, the detectives left. Jessup was not arrested after he recovered. He wasn't arrested for weeks afterwards. And then he went to trial and was convicted. On appeal, Jessup claimed that his due process rights under Tiedemann were violated because the detectives never activated their body cam. So the footage that was never created was destroyed in his argument. And so that was one of his arguments. The other was that his interrogation in the hospital room was in violation of Miranda because he argued in custody during that time. So the court held that Tiedemann does not apply to evidence that never existed in the first place. Tiedemann concerns the due process rights regarding the state's loss or destruction of possible exculpatory evidence. And so for Tiedemann to have applied, deputies would have had to have activated their body cameras, generated the footage, and then lost it. And that didn't happen. So pretty clear holding about the limitations of Tiedemann. And then regarding the Miranda claim, the court pretty easily dispensed with the notion that Jessup was in custody. All of the factors indicated that the only thing that was keeping him in the hospital bed was not that he was in police custody. He wasn't. He was just attached to some medical devices, and it was clear from all of the facts that he could have not talked to detectives. In large part, that determination was based on what detectives told Jessup and hospital staff, that he was under no obligation to talk to them. So, and the notion that, he also argued that being shot was a type of seizure. That could be true, but in this situation, he wasn't shot to be apprehended. He was shot primarily for public safety reasons. And so the court dispensed with that claim as well.
And that's something, if you remember from Torres versus Madrid a couple years ago. This was a case that came out of the U.S. Supreme Court that says if you shoot somebody, that's seizing them for purposes of the Fourth Amendment. And there's a whole common law about that, where back in the day, like magistrates used to carry around maces, and the way that they would arrest people is like tap you with the mace, and that counted as an arrest. There's an example where they say the Countess of Rutland was arrested by someone touching her with a mace and saying, "I arrest you, madam." So any sort of physical touching like that counts as an arrest for purposes of the Fourth Amendment, but for purposes of Miranda custody, just because someone's been seized doesn't mean they're in Miranda custody. I commend Torres versus Madrid to you because it's a silly case. It's just such a funny, weird set of facts, although maybe that's just the appellate attorney and me talking. Okay, another case relating to body cameras. This is State versus Alvarado.
This is Agent Johnson from the FBI. Be on the lookout for a 1936 maroon Stutz Bearcat.
That really was more of a burgundy.
All right, so facts for State versus Alvarado. An officer was downtown in the middle of the night. This is like 2 in the morning. Sees a truck that's registered to Alvarado go speeding through town in the middle of the night. The officer activates lights and sirens and the truck keeps going. It speeds away. It starts taking wild turns. Eventually, it gets cornered down a cul-de-sac. The subject gets out of the truck and runs away. So Alvarado is then found a short distance away. Again, this is his truck. It's registered to him. And he's charged with 2 counts, basically. One is fleeing in the vehicle, and then the other is fleeing by foot. All right, so the officer's version of events is that there's only one person in the truck. He sees only one person gets out. Someone gets out of the passenger seat and runs away. Or sorry, gets out of the driver's seat. This is critical. One person in the truck, they get out of the driver's seat and run away. Alvarado, though, has a friend in the neighborhood who lives nearby, and he gets this friend to testify that there were actually 2 people in the truck. She just happened to see all of this happen. There were 2 people in the truck, and Alvarado was only the passenger. He got out of the passenger side, not the driver's side. Some unknown one-armed man was the actual driver. The difficulty is there is no video evidence to resolve this dispute because the officer did not activate their body camera. A quick review of our body camera statute. So generally speaking, and this is a complex statute, so if you have a body camera issue, I would encourage you to read it in whole, but I'm just going to give a quick overview now. Generally speaking, officers in Utah are required to activate their body-worn cameras prior to any law enforcement encounter or as soon as reasonably possible. If an officer intentionally or recklessly fails to comply with this requirement, a court can provide an adverse inference instruction, basically saying, yeah, you can hold it against this officer and their credibility from the fact that they didn't turn on their body camera and may give rise to an adverse inference. If an instruction like this is given, the law actually also requires the officer's employing agency to be informed that the instruction has been given and the result in the case. The idea being that we want police agencies to know if these instructions are being given because their officers aren't following the rules, and we want them to know if they're losing convictions because of this. So, defense counsel, their primary argument on the facts at trial is that the officer shouldn't be believed because he didn't activate his body camera. But defense counsel doesn't ask for an adverse inference instruction. So they have this theory of the case. Their clear theory of the case is those officers shouldn't be believed because they didn't activate their camera, but they don't ask for the instruction for not the instruction that would have supported that theory. And so on appeal, Alvarado argues ineffective assistance of counsel for not requesting the instruction. The state, by the way, defended this largely on technical grounds, basically saying, well, this is right around the time at which the new body camera statute was going into effect, and so it would have been unclear to counsel whether they would have even been entitled to the instruction yet, because it might not have the statute might not have gone into effect yet. But the Court of Appeals disagrees. The Court of Appeals says that counsel was ineffective for not requesting the adverse inference instruction. And because the case as to whether he's the driver or not boils down to a credibility contest between the police officer and Alvarado's friend, they find this error is prejudicial and they reverse the fleeing by vehicle charge. So takeaways for Alvarado. Defendants are not always entitled to an adverse inference instruction. Make sure to check the statute first. As I alluded to before, the mere fact that a body camera isn't turned on doesn't necessarily mean you're entitled to the adverse inference instruction. In the circumstance that Mike was just describing, they didn't turn on their cameras, but that's because they needed to act really, really quickly, right? And so you may have an argument there that that's not reckless or an intentional violation of the statute. But if the defense is arguing that an officer shouldn't be believed because they didn't turn on their camera, then consider raising the issue of the adverse inference instruction. Again, even if the defense hasn't raised it. If you, in a case like this one, the defense didn't ask for the instruction, that didn't stop the Court of Appeals from reversing. The Court of Appeals has once again signaled a willingness to reverse for ineffective assistance of counsel for lack of an instruction, even if the issue isn't raised. So if this is an issue in your case, consider, and you think this is going to be a defense that officers shouldn't be believed because they didn't activate their cameras, consider raising this and getting it on the record yourself, because if you don't, the fact that it's not been raised by defense counsel is not going to save you. You might end up getting reversed for ineffective assistance on appeal.
All right. So this next case, State v. Rollison, deals primarily with Rule 412 and its prohibition against evidence of previous sexual behavior. So Mr. Rollison owned and operated a restaurant that had a, depending on who you talk to, toxic or just kind of sexually permissive environment. There was lots of sharing of sexually explicit materials. There was lots of touching of other people's bodies in sexual and non-sexual ways. And Mr. Rollison, kind of a creepy guy based on the record, took this as license to kind of take advantage of his employees. And so there were 5 servers at his restaurant who accused him of physically and sexually assaulting them at various times. One in particular that the record focuses on, where one day after work she was walking to her car and Mr. Rollison followed her and kind of assaulted her pretty violently, pulling on her breasts and nipples and causing her to bleed. At trial, the state motion in limine to exclude around 17 items of evidence under Rule 412. The court excluded almost all of those, and Mr. Rollison objected, arguing that several of those should not have been excluded under Rule 412. And I'm going to focus on, there were about, I'm trying to remember, I think there were 6 or 7 at issue in the case. I'm just going to focus on this one because it presents a good example of what we're dealing with here. This is a text exchange of the victim I was mentioning just before. This is the same night that assault on her took place. She's having this text exchange with a friend of hers, basically, kind of complaining about her work environment and her boss, Mr. Rollison. And as you can see, I won't read it out loud, but they're talking about a hypothetical sexual encounter with Mr. Rollison. Not in any way that, this is what she wants. She's, she's making it pretty clear that, she's kind of feeling under attack by Mr. Rollison. Nevertheless, describing some hypothetical sexual behavior with the defendant. This is one of the pieces of evidence that the court does exclude under Rule 412. On appeal, Mr. Rollison is arguing that, no, this should come in and all this other evidence for various reasons. Some because he says it's sexually innocuous, and so Rule 412 doesn't apply. Some because he says it falls under one of Rule 412's exceptions. There are 3 exceptions to the exclusion of evidence under Rule 412, only 2 of which are at issue here. But you're all familiar with the rule. The following evidence is not admissible in a criminal proceeding involving alleged sexual misconduct, including evidence offered to prove that a victim engaged in other sexual behavior. As you are also aware, this rule is often called the rape shield rule, to protect victims who have been sexually victimized multiple times from the embarrassment, the prejudice that comes with having that revealed at trial when it's really not relevant. And including evidence offered to prove a victim's sexual predisposition. Again, these exceptions, the court may admit the following evidence if the evidence is otherwise admissible, and that generally involves a Rule 403 analysis, and the evidence, one of the exceptions, again, is for physical evidence, semen or other things that are relevant to proving or disproving the defendant's culpability. But the 2 at issue here are evidence of specific instances of a victim's sexual behavior with respect to the person accused of the sexual misconduct if offered to prove consent, and evidence where exclusion would violate the defendant's constitutional rights. In my experience, it's pretty rare for a defendant to be able to argue that last one, but the second one is more relevant here. On appeal, the Court of Appeals did decide that the trial court erred in excluding some of the evidence that it excluded. For instance, some of the evidence didn't involve the victims at all, so it didn't fall under Rule 412's prohibition. Some of the evidence, anyway, that covers that. Some of the evidence should have come in, the court said, under the exception for evidence of specific instances of a victim's sexual behavior with respect to the person accused, if offered to prove consent. And they found that some of this evidence was otherwise dismissible, or otherwise admissible, excuse me. So it was kind of a mixed holding. The holding I mostly wanted to focus on was that text exchange. The court ruled that that should have come in, both because it was otherwise admissible, it was probative enough, there were enough indicia of, not being too embarrassing to the victim, partly because she was talking about how kind of a creep her boss was, et cetera, but also because it dealt with evidence of specific instances of a victim's sexual behavior with respect to the person accused of the sexual misconduct if offered to prove consent. As you could see from that text exchange, this was all hypothetical. This was all, kind of complaining about the boss, talking about how this was not desired sexual conduct. Nevertheless, the Court of Appeals held that the plain language of the rule does not require the person accused of the sexual misconduct to be aware of the episodes. So Rollison didn't need to know that, that he was being talked about in this way. And the text exchange clearly discusses specific instances of hypothetical sexual behavior between the victim and Rollison, as well as victim's thoughts, even if made in jest and even if negative, about potential sexual behavior with Rollison. So the main takeaway for me from this case was to kind of be cautious about evidence that you are planning on asking to be excluded under Rule 412, or how you address those with your victims or witnesses. Because you might be surprised by, especially under this ruling, what the trial court chooses to exclude and what they choose to allow. And as we know, that can have a profound impact on the victims that we were hoping the rule was going to protect, and might affect our ability to present their evidence. I also want to point out another footnote that I think the Court of Appeals kind of overstepped in writing. This is note 7 in the case, where they, quote, acknowledge that our Supreme Court has stated that when applying Rule 403 to the admissibility of a rape victim's past sexual conduct, there is a presumption of inadmissibility. The Court of Appeals, and that's a 20-plus-year-old case from the Supreme Court that has never really been challenged and has been built on repeatedly about that presumption of inadmissibility of otherwise excludable Rule 412 evidence. They cite our Supreme Court's recent repetitions of that eschewed extratextual or contratextual judicial glosses on the rules of evidence, and say that an application of Rule 403 that presumes inadmissibility for Rule 412 evidence is not indicated in the plain language of Rule 403. Accordingly, they were uncertain whether this presumption continues to be applicable and wait for the Supreme Court to weigh in on this issue. I just want to take issue with the Court of Appeals reasoning there for a couple of reasons, and make you aware of that in case you come across a defense attorney who cites to this footnote and say, oh, that's an improper presumption or whatever. I think the proper way to understand that presumption of inadmissibility of evidence, of a victim's prior sexual behavior or sexual victimization, is not an extratextual gloss on Rule 403, because Rule 412 exists for the very reason that we all understand that evidence of that kind is just inherently prejudicial, or confusing to the jury, or confuses the issue at hand. It's not like other evidence, and we can see that just from the existence of Rule 412 itself. So I'd encourage you to be familiar with the facts of this case. It's not one that we sought review on, and so we'll see how it affects future Rule 412 rulings. But that's where you all come in dealing with the fallout of maybe some poorly thought out footnotes or some less than correct rulings from our Court of Appeals.
Before we move on to the next case, just to piggyback on two things here. One, there is authority from the Utah Supreme Court prior to the adoption of 412 just saying, look, as a general rule, a victim's prior sexual activity just isn't particularly relevant, right? So it's not, for the same reasons you discussed, it's not anti-textual, it's just recognizing it's just not relevant. Again, more mischief from our Court of Appeals. I did get a question about the body camera statute while we were discussing earlier, and the question was, would officers routinely turning off the audio of their body cam during the investigation warrant an adverse inference instruction? And the answer is potentially yes. So there is a specific provision in the body camera statute, subsection 9, that deals with the circumstances under which an officer may deactivate their body camera. And so that includes, periods of activity, consulting with the supervisor, conversations with sensitive crime victims, but then there are sort of specific steps you have to look at there about, the officer believes that it's necessary to get the victim to speak honestly. So there are specific provisions under which officers can turn off their body cameras, but you can't just presume that you can turn it off as a matter of course in every investigation. I read the statute to require a more particularized inquiry there.
It's 11:11. We're going to play a quick game called Is This Capable of Causing Death or Serious Bodily Injury? So, show of hands, death or serious bodily injury? Yep. Chain and a padlock? Big old axe? How about a turkey hook? Potentially. All right. So Ames was a Category 1 restricted person. He was diagnosed with schizophrenia, and he stopped taking his meds, but he was taking meth, so he had that going. His mother was worried about his increasingly erratic behavior. He lived at home with his mother and a bunch of other people. In days leading up to the mother's call, he stored an axe near his room for protection. He was swinging a chain and a padlock around. He was actually hitting it against the outside of the house. And he mentioned that he was doing it because he was thinking about cracking somebody's head open. And he was swinging a turkey hook around. Turkey hook is like basically one of these things that you might use to deep fry a turkey or smoke a turkey. I'm not entirely sure. So the mother called 911, and she actually first tried to call the defendant's probation officer, and he said, just call 911. And so the police arrived. Ames was excitable, ended up getting arrested, and police found an axe, the padlock with the chain with the padlock, and the turkey hook. And he was charged with 3 counts of possession of a dangerous weapon by a restricted person. At trial, the jury was instructed on the definition of a dangerous weapon. So it's either a firearm or an object that can cause death or serious bodily injury. But the jury was not given an instruction on serious bodily injury. And this was problematic because those definitions are not intuitive. Serious bodily injury, substantial bodily injury, serious and substantial are basically synonyms, and so unless you know the legal definition, you're not going to easily be able to differentiate between those. And so the court held that it was error to not give an instruction defining serious bodily injury. For the axe and the padlock count, though, the court did not find prejudice because there's no reasonable likelihood that a jury would have disagreed that either of those objects could cause death or permanent disfigurement. But for the turkey hook, it was more subtle. It's not as big, it's not an obvious weapon. You would really have to work hard to cause serious bodily injury, which again means permanent disfigurement or likely to cause or capable of causing death. And so the court found there was a reasonable probability that had the jury been instructed, they may not have convicted on the turkey hook count. So the takeaway is, if you have any cases involving serious bodily injury, substantial bodily injury, make sure that a jury instruction is included defining those terms.
Okay, State versus Valdez. This is a recent case from our Supreme Court that is really, really interesting, but I'm not going to delve too deeply into it now for two reasons. One, I kind of think going really deep onto the nitty-gritty of this is not going to be particularly helpful for you as trial prosecutors, and two, because we may not have heard the last word on this. So, basic facts about State versus Valdez. Valdez was arrested for kidnapping and assaulting his ex-girlfriend. Officers received a warrant to search his cell phone. So we have probable cause, we have a warrant issued saying, all right, you no longer have an interest in privacy in your cell phone. But they couldn't access it without his passcode. So they go to Valdez and say, give us the passcode, and Valdez says, no, just destroy the phone. The state then elicits testimony about this refusal at trial and argues that it undermines Valdez's defense. So the question then becomes, was his refusal to provide his cell phone passcode protected under the Fifth Amendment privilege against self-incrimination? The Supreme Court, our Utah Supreme Court holds that it was. They say the Fifth Amendment's protection against compelled self-incrimination gave Valdez a right not to disclose his passcode. And thus, as a result, once he's said something in violation of his Fifth Amendment rights, the state shouldn't have been allowed to comment about that at trial. That would be a violation of his exercise of his rights. So the primary takeaway here is that if a defendant refuses to provide a passcode for their computer or for their cell phone, we cannot use that fact against them. The rationale for the opinion is really, really complex. It's not particularly helpful from a trial attorney's perspective, so I'm not going to go too deep into it. The other reason, as I alluded to, that I'm not going to go too deeply into this is this may be going to the U.S. Supreme Court. The AG's office has filed a petition for writ of certiorari in the U.S. Supreme Court. That is currently pending. Yesterday, we received an amicus brief from 16 states in support of our petition. And the defense, an appearance has been filed for the defendant in the U.S. Supreme Court by Lisa Blatt, who is one of the foremost Supreme Court advocates in the country as a member of the U.S. Supreme Court bar. So never a guarantee, but this one is sort of lurking in the background. This is probably as good a chance as we're going to get to see a U.S. Supreme Court case from Utah for quite some time. So because of that, I also kind of don't want to talk about its analysis in too much detail because we're playing our cards close to the chest. But stay tuned. In the meantime, read it. It's an interesting opinion. And for now, at least, if someone refuses to provide a cell phone or a computer passcode, you can't use that against them. Yeah, question? With implications for Very complicated question. So the question was is this going to matter if someone refuses a field sobriety test or refuses the warrant? Maybe. The reason this gets really complicated is because the Supreme Court or the U.S. Supreme Court and the Utah Supreme Court draws really fine distinctions based on whether the state is asking for something from someone's own mind. So if it's like, say, refusing a physical blood draw, there's no problem there because that's not testimonial under the Fifth Amendment. You know, refusing to provide a blood draw isn't giving testimony against yourself. Same thing about, like, say, refusing to provide a voice exemplar or refusing to answer booking questions. Or even, you know, under the current law, there may be a distinction between, all right, you're allowed to refuse to give me your numerical code, but you're not allowed to refuse if I hold the phone up to your face for biometric ID. Like the Utah Supreme Court's opinion, to some extent hemmed in by the U.S. Supreme Court, draws a distinction between those two acts because one requires the defendant to produce something from the contents of their mind while the other doesn't. Another analogy you see in some of the case law is an analogy between asking someone to give a key to a safe and asking someone to provide the combination to a combination lock on a safe. Under current precedent, there's a difference between those two. You know, for those of us, I see some, you know, I've seen ICAC people here, right? From our practical perspective, there may not be a practical difference between those two. And, at the time the court thought up that analogy, you could always just drill the lock out of the safe, right? Now we might not be able to with modern encryption, so it really does matter whether you think that this is producing the phone code is testimonial or non-testimonial. All right, well, that's actually a great segue to the next case I want to talk about. Let's get nerdy. I want to get nerdy. I want to talk about appellate procedure, my favorite area of law, right? All right, high five. Nobody? All right, there's one. All right. I'm talking about appellate procedure here. We've got our wigs, we've got our Lord Cook, we've got our institutes, old-timey spellings. I won't belabor this too much, but there is a practical point in all of this. So, State versus Matagian, this is a short, quick little opinion. Matagian files a motion to clarify a district court's order. So on February 9th, the motion is denied, but due to an error in the district court's clerk's office, the defense isn't served with the order denying the motion. So the deadline for Matagian to seek an interlocutory appeal from this order would have expired right around March 2nd. March 7th, the district court kind of realizes it messed up and goes, oh, crud, we issued this order, but we didn't serve defense counsel. So you know what, I'll go ahead and reissue the same order again so that we can reset the deadline and give the defendant a chance to seek interlocutory review. Finally, March 27th, Matagian files his petition for interlocutory appeal. All right, this is the rule before the court is Rule of Appellate Procedure 5A. The petition for interlocutory appeal must be filed within 21 days after the court's order is entered and served on all other parties to the action. So the first question that the court asks is, does the deadline run from issuance of the order or from service of the order? So is it within 21 days after the trial court's order is entered, period, and then it must be served? Or is it 21 days after the issue is entered and served? And then the second question is, all right, well, if we assume that it's within 21 days of when it's ordered, when the order is entered and not served, can you reset the deadline by reissuing the same order again? So holding number one, under the plain language of the rule, the interlocutory appeal runs 21 days after the trial court's order is entered, not after when it's served. The lack of service of the order does not excuse the failure to comply with this deadline. Even without service, counsel had noticed that a ruling was forthcoming. They could have monitored the docket, and particularly if they wanted to file a petition for interlocutory appeal. And failure to check the docket for orders does not constitute excusable neglect that would relieve them from this jurisdictional time frame. So, takeaway sort of number one here is that the deadline runs from when the order is entered. Even if you don't get notice, the deadline is still running, so we have to keep an eye on our dockets. Takeaway number two is the district court's reissuing of the same order again did not excuse the late filing. The district court lacked the authority to restart or otherwise extend the time to file a petition for interlocutory appeal. So as a result, his petition for permission to file an interlocutory appeal was dismissed for lack of jurisdiction. Done. He cannot take that issue up on interlocutory appeal. Now, he may be able to take it up at the end of the case, right? He may be able to take it up as an appeal from a final order, but for interlocutory purposes, he's done. So my takeaway for trial practitioners is for what all this means is that timing matters a lot when it comes to appellate deadlines. In the appellate world, appellate deadlines tend to be jurisdictional, which means we have very little flexibility. So if you think you might want to seek an interlocutory appeal, number one, keep an eye on the docket, right? The fact that you haven't received notice, if it's still on the docket, that might mean the order's been issued and your clock is running. And number two, let the Criminal Appeals Division know immediately if you think you might want to seek an interlocutory appeal, as soon as you possibly can. Appellate deadlines are not flexible, they are jurisdictional, we don't get to extend them. I would also add, by the way, for those of you, I pretty regularly consult with people around the state about interlocutory appeals, but for those who aren't familiar, if we're going to appeal an interlocutory order, it's not just a matter of filing like a one-page notice of appeal. We actually have to file a reasoned petition. It's really more like a brief. And so If you come to us on day 20 of the 21 deadline and say, we want to file an interlocutory appeal, we're going to tell you no, because we can't we can't draft a petition that quickly, right? And so the sooner you can provide us notice, the better. That way we can take a look at the record, we can process whether we think it's, in our judgment, it's appropriate for a candidate for interlocutory appeal, and then we can draft the petition. So the sooner you can let us know about these things, the better.
All right, State v. Morgan and State v. Ambo also present a couple of, or an important appellate procedural consideration for us to remember. The facts of the cases aren't particularly important, but these are both cases where the state did not file a brief. We can choose to do that for a variety of reasons. The case is not a particularly big one. We simply do not have time to file a brief. We understand that if the case is reversed, the consequences are less serious than other cases because it's a victimless crime, it's not a particularly big time offense, etc. But the reasons that, but when we make that decision, it's important to keep in mind that just by the standard of review, or the standard that applies there, it's more likely to be reversed. I'll just show, or these are just the holdings relevant here. In Morgan, the Court of Appeals noted that because we conclude that Morgan has satisfied the lower burden at issue in this appeal, we reverse on that basis alone. That lower burden being that the appellant need only establish a prima facie case showing a plausible basis for reversal. That's all they have to do. If the AG's office or if your office decides not to file a brief, be aware that that's all the appellant needs to do. Same exact holding in Ambo. In sum, in the absence of any appellate opposition, Ambo has satisfied the lower burden of making a prima facie showing of a plausible basis for reversal. We accordingly reverse her conviction. So yeah, as you're considering whether to file a brief, or as you're consulting with the AG's office on whether we are going to file a brief, just understand some of those considerations. What is your workload? Is it reasonable for you to draft and file a brief in the time that you have to do it with all of your very substantial caseloads? Is there a victim that would be affected by a reversal? How serious was the underlying crime? There are lots of things to consider in making this decision, and one of them is to understand that if you do not file a brief, it is more likely that the conviction is going to be reversed.
All right, restitution. State v. Garcia. The victim was out of town, and Garcia and some others broke into the house and squatted in there for a little bit. They stole some things, broke some things. When the victim got back, he submitted a claim to his insurance company, and insurance company paid out whatever they did. The victim had to pay $1,000 for his deductible. So Garcia was initially charged with second-degree felony burglary, but he was able to plead to a Class A misdemeanor. And in the plea agreement, he admitted only that he entered the building with the intent to commit a theft. There were no other facts alleging that he actually stole anything or damaged anything. So a few months after, and in the plea agreement, Garcia agreed to pay the $1,000 that the victim put up to pay for the insurance premium. But a few months after that, the state submitted a request for additional restitution in the amount of $20,000 to pay for everything that the victim's insurance company paid out. So Garcia objected, and he argued that the state failed to explain what the funds were for and how Garcia's criminal conduct was the proximate cause of the loss. Basically, Garcia said, there were a lot of people there. How do you know it was me? It could have been any one of the co-defendants. So at the restitution hearing, the state put on evidence showing what the $20,000 went for, what items were stolen or damaged, but no evidence was put on that showed what Garcia actually did to cause the loss, other than all we knew from the plea agreement was that he entered the home with the intent to commit theft, but without actually admitting to committing any theft. So the Court of Appeals vacated the restitution order and held that the state failed to prove that the defendant proximately caused the victim's loss. He only admitted to entering the building with the intent to commit theft, and that just wasn't enough to tie Garcia to the actual loss. So the takeaway, whenever possible in plea agreements, and I fully understand that it's not always possible, but try to include the restitution amount if it's known. It really prevents a lot of issues later on. If that's not possible, try to be as specific as possible when describing the defendant's conduct, and think about proximate cause when you're doing that, because the standard is that you have to show, that the defendant actually did something to cause that loss. And then if you end up at a restitution hearing, keep those principles in mind as well. A lot of development there's other restitution cases that we'll get into this a little more in detail later, but the proximate cause standard has been developed and refined in recent cases. Keep those in mind when you have a restitution hearing so that you could check all your boxes and get the restitution that you need for your victims.
Okay, a couple of questions have come in. One, someone said they're shocked to see that Frampton Alive was from 1976. He played the Eccles Theater recently. Yeah, I didn't know if Peter Frampton was still touring. He had also asked if we have a list of Frampton questions that could be provided. I have a truncated list that's in the slideshow that's been circulated. The questions themselves, the original text, are in footnote 10 of Frampton himself. And I will also, once we're done, I'll see if I can just cut and paste a whole list of the Bob Church is already nodding in the back. He sees where I'm going with this. We'll post or circulate a list of all of the Frampton questions. Had another question about if the office decides if the AG's office decides not to file a brief, will we contact the trial prosecutor and allow them to file one? I thought that was the current policy, but if not, I'm going to double check as soon as we get back. For whatever it's worth, it's extremely rare that the AG's office wouldn't file a brief. The only time that I'm aware of that we haven't is in victimless cases involving what we consider to be largely frivolous challenges to the sentence. But as soon as I get back to the office, I'm going to make sure that that's our policy, because certainly if we don't have the resources to file a brief in a particular rare case, it does seem to me to be appropriate for us to be able to run that by the trial prosecutors and give you guys a chance to do it under our supervision. Okay, next case up, State versus Barnett. Let's talk about bail. Bail. Utah Constitution, Article 1, Section 8 says that all persons charged with a crime shall be bailable except, and then it lays out 3 categories for which people, the exceptions to the general rule that all people are bailable. Number 1, broadly speaking, is when someone's charged with a capital offense and there's substantial evidence. Number 2 is if the person was on felony bail, probation, or parole, and there's substantial evidence of the new crime. And number 3 is where there's a substantial danger to the community or the person is likely to flee. So those are your sort of general rule. In general, all defendants are bailable. These are your exceptions. The state argued in Barnett that the historical understanding of these exceptions was that people who fell within one of these exceptions were forbidden from receiving bail. So that if you're, say, charged with a capital offense, you're forbidden to receive bail no matter what. If you've committed a new felony while on probation for a felony, you're forbidden to receive bail. That was the state's argument, but our Supreme Court rejects that argument. The Supreme Court says that the plain language provides that the district court may still grant bail even where a defendant doesn't have a categorical right to it. So the basic takeaway in this case is even in capital cases, even in cases of repeat felons, even in cases involving a danger or a risk of flight, district courts don't have to grant bail in those cases, but they have the discretion to grant bail.
Okay. So State v. Forbush, unfortunately another child sex abuse case. Forbush was convicted of 2 counts of sodomy on a child and 1 count of dealing in material harmful to a child or to a minor after he sexually abused his nephew. On appeal, Forbush argued that the trial court improperly allowed the child victim to testify remotely and barred Forbush from being present for that testimony. And he claimed that the judge had insufficient evidence to make that determination and that expert testimony was required to do so. I bring this up because if you come across a frivolous claim like this, you have a case to back up your arguments. So the governing rule here is Utah Rule of Criminal Procedure 15.5b. It allows a child sex abuse victim to testify remotely upon motion of a party and for good cause shown. That's the requirement for a child sex abuse victim to be able to testify remotely. There's no evidence, or there's no mention of the particular kind of evidence that needs to be presented to back up that good cause showing. There's certainly no mention of an expert testimony being required to support that holding. A further provision of this rule holds that a defendant may be in the room but hidden unless the court determines that the child will suffer serious emotional or mental strain if required to testify in the defendant's presence, or that the child's testimony will be inherently unreliable if required to testify in the defendant's presence. Again, no specific provision of the rule telling the courts what kind of evidence is allowed or required for the court to make that finding. However, on appeal, Mr. Forbush argued that no, the court didn't rely on expert testimony to make this holding, and they needed to, based on all these cases where expert testimony was presented that supported that holding, and he argued that there simply wasn't enough evidence. The court disagreed, thankfully, and held that though experts and expert testimony are perhaps helpful, the rule itself doesn't require expert testimony. And we've been pointed to no authority in which any court has held that expert testimony must be offered before a court can make such a determination. Further, the court pointed out that the determinations that it needed to make aren't inherently those that require expert testimony. In this case, Forbush's victim was in the custody of his grandmother at this time, and she testified about what she saw as the likely effects that testifying in Forbush's presence would have on his victim and so on. And the court found that that was plenty. As the court held, we can certainly envision situations in which a lay witness who is personally familiar with a child and the surrounding circumstances could offer meaningful testimony about the likely effects on the child, which may, and in fact, I'd say in lots, if not most cases, this testimony may prove to be more probative than testimony from an outside expert. And so that's just something to keep in mind. Again, I hope you don't have to deal with this kind of claim from a defense attorney, especially when it comes to dealing with vulnerable children who've been victims of sex crimes. But if you do, then you have holdings like this, thankfully, to support you that you can rely on.
State v. Tran, this is a case that involves the emergency aid doctrine. So police did a welfare check after a grandmother didn't pick up her grandchild from school. They tried to get in touch with the grandmother in a variety of ways. They called a family member. They were trying to call her on her cell phone. Ultimately, they ended up at the grandmother's home where she lived with Tran and some other individuals. And police, when they looked in through the window, they got no answer at the door, got no answer on the cell phone, but they could see what looked like a body under a tarp. And so obviously hackles go up. They're very concerned about the welfare of the grandmother. There was also an infant that lived in the home, and police debated what to do, basically. They wanted to jump in, but they were concerned that if they didn't have the emergency aid exception applying, then all the evidence that they obtained would be suppressed if this ended up being a homicide. So they called their supervisor, they called for backup. In all, it took about 20 minutes for the police to enter the home. When they did, they found 3 bodies, including the grandmother, an infant, and another male. They found Tran in there as well. They were able to arrest him, and he went to trial. And Tran, this is a interlock appeal from the court granting the motion to suppress, for the court denying Tran's motion to suppress the evidence. Tran filed a motion to suppress, state argued emergency aid doctrine, the police went in because they objectively believed that it was necessary to protect the grandmother and the infant. On appeal, Tran argued emergency aid should not have applied. The police waited 20 minutes, and that demonstrated that this really wasn't an exigent circumstance. The police didn't feel that it was. And so that was one argument. Tran also argued that Article I, Section 14 of the Utah Constitution provides substantially more protections than the Fourth Amendment in this context. Tran argued that there basically are no exceptions to the warrant requirement for a home search under the Utah Constitution. And I won't go into this too much. It really doesn't matter for the ultimate holding or for trial purposes. But there is an interesting discussion in the oral argument and in the briefing about these 2 different approaches to interpreting state and federal constitutions. The approach that Tran was arguing for is called primacy, and it involves looking first to the state constitution to answer constitutional questions, and then, if necessary, the federal constitution. The approach that the state advocated is the interstitial approach, which means that you look first to federal controlling law under the Constitution, and then if that does not resolve the issue, then you continue to look at the state constitution. Ultimately, the court declined to adopt either one of those formal modes of analysis, and it basically said it will just do it on a case-by-case basis. If there is a case where there's an actual good argument for deviating from this approach, they will. But otherwise, they're going to, in cases where there's significant overlap between the 2 analyses, they're going to start with the federal first approach, and that's what they did here. Ultimately, they held that the emergency aid doctrine did apply in this situation, and they reaffirmed that the test is not a subjective one. So regardless of what the officers were thinking at the time, subjectively, whether they truly believed it was exigent or not, the test is objective. And so if an officer objectively, reasonably believes that it's necessary to protect others, then the emergency aid doctrine will apply. And the court rejected the notion that Article 1, Section 14 has no warrant exceptions, and basically held that the 2 significantly overlap, and that the emergency aid doctrine applies to both in the same way. State v. Blumel. This is an appellate procedure case, and the defendant was sentenced in 1999 for murder. He was not advised at sentencing that he had the right to appeal. His plea paperwork actually incorrectly advised the defendant that he was waiving his right to appeal his sentence by pleading guilty. But Blumel, he didn't file a direct appeal. In the 20 years between his conviction and 2020, he filed 5 successive post-conviction petitions. And then 21 years after sentencing, Blumel moved to reinstate his time for appeal under Utah Rule of Appellate Procedure 4F, which allows for reinstatement if a defendant has been deprived of the right to appeal and if the defendant could actually show that he or she would have appealed. There's a 4F hearing, and at the hearing, Blumel testified, but he presented no evidence that he actually asked his attorneys to file an appeal at any time. The district court denied the 4F motion. They found that the 4F motion was untimely, and if you read Rule 4F, there is no time limitation on it, but that's what the district court found. And then the court found that Blumel was not harmed by the failure the failure of the district court to advise him of his right to appeal, but it didn't elaborate on the standards that it applied in that context. So on appeal, Blumel argued that 4F, you can't deny a 4F motion as untimely, and the Court of Appeals agreed 4F does not have a time limitation. So that's one important takeaway. They could come up at any time. And second, Blumel argued that 4F, the court wrongly denied his motion because he claimed he was deprived of his right to appeal when he asked his counsel to file an appeal, but counsel did not. The Court of Appeals said that the district court was correct in rejecting that claim because there was no evidence presented that Blumel actually asked his attorney to file an appeal. Third argument, though, was that Blumel said that neither the trial court nor his counsel properly informed him of his right to appeal. It's true that the court never advised him of that, but there was no finding below about whether he was advised by his attorney. And the Court of Appeals remanded that case to make findings on that point because, that's okay. I know, it's over, okay, I'm done. All right, 4F, I'm fine, we're good. So anyway, that's under one of the ways that you could be deprived of your right to appeal is if either the court or your counsel fail to advise you. If one or the other does advise you, you're fine. In this case, we only know that the court didn't advise Blumel, and it was sent back to make findings about whether he was advised by his counsel at the time. So, thank you.
Okay, back to 1 o'clock. Thank you, guys.
I know, nobody cares about 4F.
Did you bring one? You want me to grab you something?
They'll be trickling in. So turn it back over to the trio.
Nearly 500 years ago, in the town of Autun, France, a young lawyer named Bartholomew Chassenet took on a case defending a group of young troublemakers against erroneous criminal charges brought forward by the Catholic Church. Facing off against the church was a really big deal, especially for a young, ambitious lawyer. And after a series of clever legal tricks, he prevailed. Oh yeah, also, his clients were a bunch of rats. Let me explain. Autun's barley crop had been decimated by a rat infestation. Affected farmers asked the church to intervene, and the church, in turn, charged the rats with destruction of property in their ecclesiastical court. Chassenet was looking to make a name for himself, and decided that defending the rats would be a high-profile way to kickstart his career. On the first day of proceedings, when Chassenet showed up to the courthouse, the rats were nowhere to be seen. This was to be expected, of course, but the judge's first move was to take this as an indication of their guilt. Thinking quickly, Chassenet informed the judge that the notice to appear in court had been posted exclusively inside the town of Autun. The supposed crime had taken place outside of town, so it was reasonable to assume that that's where the defendants lived as well. Chassenet argued that the court had an obligation to provide adequate notice to his clients, even though they were, rats. The judge reluctantly agreed and issued an order instructing every rat in the diocese to appear in court. This time, notices would be posted everywhere. Several days later, Chassenet showed up to court for a second time, and again, his clients were nowhere to be seen. The judge was prepared to call it quits right there, but Chassenet came back with another argument. He said that whenever farmers appeared in court, they were usually given several weeks to get their affairs in order. His clients were farmers of a different sort, so why weren't they being shown the same respect? Chassenet was being annoying, but he kinda had a point. The judge delayed proceedings for several weeks so that the rats could get their affairs in order. Whatever that means. Weeks later, they met for a third time. Surprise, no rats. Chassenet burst in there full of beans. He informed the judge that of course his clients had every intention of coming in today. However, he had only now discovered, to his dismay, that the streets of Autun were absolutely crawling with cats. His clients, Chassenet said, were afraid for their lives. The judge was allowing assassins to hang around outside the courthouse. This was unacceptable. He told the judge that it would be impossible for his clients to appear in court until every cat in Autun had been moved indoors. An extremely annoyed judge issued a notice for people to pretty please with sugar on top move your cats indoors. Proceedings were adjourned until a future date, TBD. No date was ever set. People moved on with their lives, and the matter was set aside. Chassenet had successfully badgered the church into dropping the case.
Point of this is just, it can be worse. Whatever you're dealing with, it could be worse. Also, I wanted to wake everybody else up after lunch. All right, let's get right back into it. State versus Platzola. This is another case about prior consistent statements. So we talked a little bit about that rule before, and how prior consistent statements are admissible to rebut a claim of recent fabrication, but not just to reinforce the declarant's testimony on its own. So basic facts of this case. This is a sexual assault case in which the victim reported sexual abuse and gave a 40-minute long CJC interview. So if those of you who try these sorts of cases may be familiar, Rule 15.5 allows the state to introduce CJC interviews if the witness is younger than 14 years of age at the time, but by the time of the trial in this case, the victim is too old. So in case you're wondering, the CJC interview is not admissible as a matter of course under Criminal Rule of Procedure 15.5. So the state didn't introduce it initially, but it later introduced the entire 40-minute long interview as a prior consistent statement after defense counsel had impugned the credibility of the victim. The Court of Appeals gets this on appeal and says that admitting the entire 40-minute interview was plain error and reverses for a new trial. Again, plain error, no objection in this case, they're reversing anyway. The court finds that the prior consistent statements did not make the entire interview admissible, and its introduction was also prejudicial because the case turned on the victim's credibility, and the state commented during closing on how credible the victim appeared during the CJC interview. So again, we'll sort of break this back down again. Remember Rule 801D1B, the prior consistent statements rule, says a statement is admissible if the declarant testifies, is subject to cross-examination, and if it rebuts a claim of recent fabrication. So there's your text of the rule right here. The claim must be a recently fabricated or acted from a recent improper motive. So the rule, according to our Court of Appeals, only applies to pre-motive consistent out-of-court statements, which directly rebut the charges of fabrication. It can't be used just to bolster a statement already uttered at trial by mere repetition, or in this case, by pointing to the content of the statement itself to show that it looks credible. So even if the testimony has been offered for rehabilitative purposes, the court finds that its admission is limited to direct rebuttal and it's inappropriate to admit the entirety of the testimony. So to give an example, what would be proper here? The defense argues the victim fabricated a report based on something they read in the newspaper. This is State versus Green. The state can rebut that by saying they told the same story even before the newspaper article was published. Improper, the defendant's story is fabricated. The defendant claims the victim's story is fabricated, and the state offers in rebuttal, well, she should be believed because she seemed credible when she told the same story before. That's an improper hearsay purpose that doesn't fall within the exception for prior consistent statements to rebut a recent claim of fabrication. So why does the court think that the rule is not triggered? So here the defense asserts during opening statements that the victim will testify about things that just couldn't happen. Right? They're attacking the victim's credibility. But that's an assertion, according to our Court of Appeals, that the victim's not believable, not a claim of recent fabrication. The defense then goes on at trial and they highlight differences between the victim's trial testimony and the preliminary hearing testimony. The Court of Appeals finds that is actually a claim of recent fabrication, right? The idea is, oh, you've changed your story recently after the preliminary hearing, now you've come into trial and changed your story. The Court of Appeals finds you could admit some prior consistent statements to rebut that, but you couldn't go beyond what was absolutely necessary to rebut it. So for instance, if the victim said at prelim that it happened on a Thursday, and then she says during trial that it happened on a Friday, you could go back and show, well, at the during initial statements, she in the CJC, she said the same thing that she said at trial, that it happened on a Friday. But you can't go beyond that to encompass more information than is necessary to rebut the specific claim of fabrication. Doing so was reversible plain error, again, even though the defense did not object. This is another example of a case where maybe there's stuff in that interview, maybe there's a good reason why defense counsel doesn't object. Right? Maybe there's something in that interview that defense counsel wants to make something out of, and they had a good reason for not objecting. Again, our Court of Appeals, they want things done right, and if there's not an explanation on the record for why there's no objection, they're just going to assume defense counsel was an idiot. They're not going to assume there's a strategic reason for it. So once again, as a sort of a continuing theme, they want to see things done right in the first case. So another, this comes up in the context of CJC interviews, but another area in which this might come up that we see quite a bit in our cases is course of investigation testimony, where you have a victim who will come in and testify, and then a police officer who will come in and repeat the entire statement that the victim gave. That's generally improper. We don't see as many reversals for it because it's generally harmless. But you got to be careful because in a close case, it might make the difference. So takeaways from Platzola: first, beware of prior consistent statements, particularly if the case turns on credibility. And if the prior consistent statement contains facts or details that were not included in the trial testimony. Like if we're going to find it prejudicial, it's going to be because it offers something beyond what the jury was already aware of at trial. In this case, the additional fact that's offered sort of beyond what the jury was already aware of is they can watch and see the victim's credibility during the CJC interview, and the prosecutor says, look how credible she appears, look how innocent she appears in this interview. And the court finds that that's introducing new prejudicial information that's not within the purpose of the hearsay exception. As I alluded to, this can also arise with statements to police, particularly if it's admitted to explain their later investigation. The general thinking should be, yes, you can introduce hearsay to explain why officers did what they did. You know, the jury shouldn't be put in the situation of just thinking that the officers showed up somewhere for no reason and started kicking down doors and taking names, but it should be limited to what's necessary for that particular purpose. Finally, then, use particular care in arguing that a witness is credible merely because they had said the same thing before. Next case is also mine, State versus Arce, and I have another Simpsons
Did you
clip.
hold a grudge against Montgomery Burns?
No. All right, maybe I did, but I didn't shoot him.
Checks out. Okay, sir, you're free to go.
Good, because I got a hot date tonight. Odd date. Dinner with friends. Dinner alone. Watching TV alone. All right. I'm gonna sit at home and ogle the ladies in the Victoria's Secret catalog. Sears catalog. Now, would you unhook this already, please? I don't deserve this kind of shabby treatment.
All right, State versus Arce is a case about human lie detectors. Not actual physical lie detectors, but human lie detectors. So this is a case in which a police officer testified that he believed the victim based on the story that the victim gave and that she appeared honest and genuine. And then the state and its witnesses referred to the victim multiple times as the victim, not the alleged victim, not the complaining witness, referred to the victim as the victim in front of the jury. And the defendant, in a continuing theme here, did not object. The Court of Appeals, state dodges a bullet here. The Court of Appeals affirms for lack of prejudice. But in its discussion of the merits of the claim, it goes out of its way to speak in really strong terms about its concern about these two aspects of evidence. So they go out of their way to reaffirm that the use of law enforcement officers' testimony for bolstering and vouching in this manner is inappropriate, and it could perceive no strategic reason that defendant's counsel would reasonably fail to object to it. Similarly, they say referring to the complaining witness as the victim by anyone in front of the jury is also inappropriate, and it could perceive no strategic reason defendant's counsel could reasonably fail to object. This last one, by the way, we need to be careful about this, right? Because victim, the word victim has two meanings, right? It means someone who's been the victim of, we know who's been the victim of a crime, and it also means complaining witness, right? Anyone who's ever watched like Law and Order, SVU, you know, you watch SVU and you don't think the SVU exists only to investigate crimes where people have already been proven guilty beyond a reasonable doubt and they just reinvestigate them again, right? It's not the special complaining witnesses unit, it's the special victims unit. So police officers and prosecutors, we use terms like this all the time. We'll say victim to mean complaining witness. You'll see this in, you know, we brought them into the victim interview room, right? We put them in touch with a victim advocate, right? Those sorts of things. Our appellate courts have become increasingly concerned about this. And in particular, they are concerned about it in cases where there is a dispute about whether there's a victim in the first place. So to give you an example, you know, if you find someone who's shot dead in the street, and the defense at trial is, well, yeah, somebody shot him, but it wasn't me, then it might be okay to refer to that person as a victim, right? Because the defendant is not disputing that there's a victim here. But as in, say, a sexual assault case, where the argument is consent, or the argument is that the sexual activity never took place, there's a dispute about whether the complaining witness is actually a victim. And so we want to, in those cases, make sure that we are policing that not just in sort of what comes out of our own mouths, but also what comes out of the mouths of our witnesses. Some of the case law on this is actually gives a little bit more leeway to prosecutors because courts generally tend to think that, well, yeah, obviously the jury is going to think that the prosecutor believes the defendant is guilty, right? Otherwise, why are we here? But they're less solicitous when it involves law enforcement witnesses. The concern is that by saying victim, that might subliminally plant in the juror's mind that this person is in fact a victim based on evidence outside the record. How persuasive is that? I'm not sure it's all that persuasive. I doubt that there's any juror out there who's saying, well, I'm pretty sure this guy didn't do it, but that police officer said that they interviewed the victim, so that must mean he did it, right? So I'm not sure this is persuasive as a matter of first principles, but you know, we're not in a land of first principles. We're in a land where our Court of Appeals is giving increasingly strongly worded guidance on this. So the one other thing I would point out here is you'll note for both of these, the court says it could perceive no strategic reason that counsel would fail to object either to law enforcement vouching testimony or referring to a victim as the victim. So what that strongly suggests is that in a closer case, our appellate court's going to find it to be ineffective assistance of counsel and is going to be willing to reverse even if the defendant has not objected, right? So, easy thing to do here is don't ever ask a witness to directly opine on another witness's credibility, right? That's an easy thing. There should never be a good reason why a police officer should be saying, oh yes, I totally believed her. I saw how she looked when she testified and I believe that she was persuasive. Like that's easy to prevent. We don't ever let one witness directly opine on the credibility of another. You can look at, say, objective factors. She seemed upset, she seemed angry, but not she seemed credible. The harder one is dealing with victim, right? Because this comes out naturally for a lot of us. I mean, even in this presentation, right, I'm saying alleged victim now. I'll go back to saying victim later because that's just what comes naturally. Our Court of Appeals wants us to push against that. So make sure that we're using terms like alleged victim or complaining witness rather than victim, and to correct our witnesses, to step in and correct our witnesses if they do otherwise. Again, if we don't, even if there's no objection, even if defense counsel thinks they're fine with it, our Court of Appeals, it's not going to stop them from reversing in a case where they think it's close and it might have made a difference.
This was a case out of Utah County. The facts are really horrific. A 16-year-old victim confided in probation that she wanted to commit suicide, and probation didn't talk her out of it. He did everything he could to help her, including tying the noose around her neck, setting up the platform for her to stand on, getting all the materials, and he recorded it. He recorded the victim's death, narrated it, and he left the scene. It was in a secluded location in Utah County, and he returned when police arrived to investigate, and he made admissions. He was charged with a number of crimes, but he was ultimately allowed to plead to child abuse homicide, and at sentencing, he was informed about his right to appeal his sentence if he chose to, but he didn't do that until nearly 2 years after his conviction. And this is another case arising under Utah Rule of Appellate Procedure 4F. 2 years after his sentence, probation sought to reinstate his time for appeal. And basically, his argument on appeal ended up being that he acknowledged at an evidentiary hearing that he was informed about his right to appeal during his plea negotiations at sentencing by both his counsel and by the trial court, but he claims that he should have been further informed about his right to appeal after he was sentenced to decide if he wanted to appeal his sentence. And so his claim was under Rule 4F, but really what he was arguing is that his trial counsel was ineffective for not meeting with him after sentencing to further discuss the possibility of appeal. And in making that argument, there's basically three ways that under State v. Manning, you could have your right to appeal reinstated. You could, if you tell your attorney that you want to appeal and your attorney fails to do that, that's one way. If you show that you earnestly tried to appeal but were prevented from doing so by no fault of your own, that's another. Or you could show that you weren't advised of your right to appeal by either the trial court or by your counsel. And Prohibition argued basically that there should be an additional category, which is that if you're not informed of your right after sentencing to decide if you, to be consulted to decide if you really want to seek an appeal on your sentence. The Court of Appeals rejected that notion. Not necessarily, they didn't say that you could never be deficient for not having a discussion with the client after sentencing to decide if they want to appeal, because there are many cases where that might be appropriate. But under the facts of this case, it was apparent that the defendant received a sentence that he should have expected. He went to prison on concurrent sentences. He didn't get probation like he wanted, but the court said, you know, most reasonable defendants would recognize that that is a sentence that you could expect to get, and rejected that claim that further consultation was necessary. This was also, it was important that the defendant pled, and so he waived all non-jurisdictional claims, and all he had left was a challenge to his sentence. So this is, in many ways, a fact-specific ineffective assistance claim, but these issues may come up again where, you know, a similar 4F claim might be made if, and so look out for that. If you get a 4F claim, you may want to contact our office to talk about it and discuss, you know, how to proceed at any evidentiary hearing that you might have. State v. Carter, this is another ineffective assistance case. The facts are not super important, and I don't raise this just to have a discussion about ineffective assistance, because that may not be very helpful to a lot of trial attorneys. But the court in this case did a very faithful Strickland analysis, and in doing that, they stayed true to the first principles of Strickland. And so this case is just another example of our Supreme Court insisting that whenever there is a claim under federal law or a constitutional claim, that you go to first principles first and don't use a shorthand for, you know, in this case, the ineffective assistance test. Instead of, you know, looking to decide if a particular defense attorney was ineffective because a motion was futile or for some other shorthand way of explaining what deficient performance looks like, you should always go to the original test from Strickland, which is an objective analysis of whether counsel's performance was reasonable at the time, given all the factors that counsel was facing. So again, I bring this case here not because it's of particular interest from the ineffective assistance view, but just because it demonstrates the Supreme Court's desire to you know, go to the original text of any test that, that we have on a constitutional claim.
And I suppose I would add just on this, the Strickland point, right? I think that's the Utah Supreme Court. If we can get a case to the Utah Supreme Court, we're more confident that they're going to be applying Strickland and ineffective assistance in a proper and properly contained way. With our Court of Appeals, as I think has been sort of a consistent theme of this presentation, we have really significant concerns with our Court of Appeals about the way that they apply Strickland, and that poses lots of threats for all of us in sort of making sure things go right, even if there's no objection to what's going on.
Yeah. Okay. Is this you?
Okay, So we covered State v. Grenier earlier in our unanimity cases. I wanted to bring up a further point. This is another example of a criminal defendant trying to make a silly argument to basically stop a child sex abuse victim from testifying. In Grenier's case, he tried to argue that because his child victim had substantial memory issues and an inability to recall and articulate the alleged events, and was therefore incompetent to testify under Rule 602 of the Rules of Evidence, which is, pretty lame to argue that. But thankfully, there was already Supreme Court case law that the Court of Appeals relied on in rejecting this argument that, again, we can rely on in protecting our child victims and vindicating their right to testify. They specifically held that Rule 602 is not a means of rendering child sexual assault victims' testimony inadmissible for lapses in memory. However, those lapses in memory are appropriately dealt with under Rule 403. So that's what we have to kind of adjust to. It's pretty much anybody is competent to testify as long as they can testify to the events as they were. But it's still important to keep in mind that Rule 403 can do some work in these cases that we should be prepared for in preparing our witnesses and making sure they can say what they want to say.
All right. How many of you have tried cases with multiple co-defendants at the same time? And just keep your hands up if you have. Keep your hand raised if they involved at least one confession. We have a couple. This actually comes up more rarely in Utah, but it does come up. So Samia versus United States, this is a recent US Supreme Court opinion. This is a case about the elephant in the room. A little bit of background here on sort of what the problem is we're thinking about in a case where you have multiple defendants, one of whom has confessed. So if you imagine that Mike and I here are both co-defendants, right? If I've given a statement to police during the course of the investigation, that's admissible against me, right? That's a statement of a prior party opponent, right? But if then I invoke the Fifth and decide not to testify at trial, it's not admissible against Mike, right? Because it's not Mike's not the same opponent, and he doesn't have the opportunity to cross-examine me, right? So that's the tension that we're dealing with here. Is you might have in a co-defendant case, you might have a statement that's critical against one defendant because it confesses their involvement, but inadmissible against another because otherwise it would violate their right to confrontation. So the leading Supreme Court case on this is Burton versus United States. So a defendant is deprived of his rights under the Confrontation Clause when his non-testifying co-defendant's confession naming him as a participant in the crime is introduced at their joint trial, even if the jury is instructed to consider that confession only against the co-defendant. So the rationale is this denies the right to cross-examination. So we admit my prior confession saying, yeah, Mike and I went and robbed the 7-Eleven, right? And we tell, ladies and gentlemen of the jury, the confession that Dave and Mike just robbed the 7-Eleven is admissible only against David. You are to disregard it as in your considerations as to whether Mike also robbed the 7-Eleven, right? Bruton says there's no way a jury is going to be able to sort of ignore the elephant in the room there. So that slide's just another example of that same sort of issue. Later case, Gray versus Maryland, the same rule applies if the confession doesn't expressly name the defendant, but uses an obvious substitution like deleted or redacted or deletion, right? So, my confession is, beep, and I went and robbed the 7-Eleven, and the only other person sitting here is Mike, right? Gray versus Maryland says that's not enough. So the detective in that case read the confession with Gray's name replaced by deleted, and then he immediately testified that after hearing the confession, he was able to arrest Gray. Oh, okay. So obviously that's too much, right? So what we have here is sort of a battle between the Fifth Amendment right to remain silent for one defendant against the Sixth Amendment right to cross-examination by the co-defendant, right? Okay, so that's the sort of background for Bruton and testifying co-defendants. So let's talk about the facts of this particular case. So petitioner Adam Samia traveled to the Philippines in 2012 to work for crime lord Paul LaRue. Because I'm an appellate attorney, I assume this is what crime lords dress like. Organized crime people, am I right about that? Right, these are, okay, good. All right, so Adam Samia, he goes to work for crime lord Paul LaRue. LaRue ordered 3 people, including Samia, to kill a real estate broker. The broker is then found dead a short while later, shot twice in the face at close range. So LaRue, the crime lord, is arrested and becomes a cooperating witness. Another one of the assassins was also arrested and confessed, claiming he was the driver and Samia is the shooter, right? So the statement is, yes, I drove the car and Samia was the guy who did the shooting. All 3 assassins are tried jointly in a single trial. 2 of them admit to participating in the murder, but Samia maintains his innocence. All right, so that's the background here. What the federal district court does is it admits a redacted confession read by another witness because the full confession would have implicated Samia. And so rather than just say deleted, what the court does is it refers to another person. So instead of saying, you know, I was the driver and Samia was the trigger person, it describes a crime where the other person pulled the trigger. Another person is the one who the driver lived with and carried a particular gun. And then you have an instruction from the district court that this confession is only admissible against the driver and couldn't be considered against Samia. And so Samia, along the lines of Gray versus Maryland, did I just lose my... Did we lose our connection? I'm still up on my end. Anybody have show tunes requests? Or? Mike's great at that. He'd be happy to. Perfect. All right, I think we're good. Thank you, thank you. All right, so Samia says, all right, in this case, instead of replacing my name with deleted, you just replaced it with the other person. That's awfully similar to Gray versus Maryland. So even with the redaction and the instructions, this confession violated my rights because the evidence would have immediately caused them to suspect that it was me, Samia, who was the other person involved. U.S. Supreme Court, in an opinion from Justice Thomas, perhaps a little surprisingly, says there's no constitutional violation here. This is totally fine. So according to Justice Thomas, historically, redaction and jury instructions were considered sufficient to eliminate this confrontation clause problem. The court, sort of revisiting the Bruton-Gray line of cases, says Bruton's just a narrow exception and applies only when the confession of the co-defendant directly implicates the defendant at issue. A mere indirect implication is not enough. So long as the redacted confession is not obviously redacted, so it says something like the other person rather than deleted, and merely contains neutral references to some other person, that's enough. A different rule would essentially require severance in every multi-defendant case with a confession, and the court doesn't want to do that. Joint trials, the court says, have long played an important role in our criminal justice system, and they encourage consistent verdicts, and they help encourage consistently by making sure that, the defendants are all convicted or acquitted as a group. By the way, if you ever have to have a dispute with the judge about whether to hold a joint trial or a separate trial, there's a lot of good language in Samia about the usefulness and historical roots of joint trials of multiple co-defendants. But all right, so here's the big takeaway. If you have one of these cases yourself, let everybody make sure to write that down before I continue on. All right, so the takeaway to survive under Bruton, first you have to redact the confession, but not just redact it with redacted or deleted, but to replace the names with references to something generic, like another person, and then you have to instruct the jury to consider the confession only against the testifying co-defendant. Next case is also mine, Smith versus United States. This has my favorite cluster of words of any case from the recent U.S. Supreme Court term. You'll see what I mean in a second. So Smith is a fisherman in Alabama who's angry at a company that sells coordinates for privately created fishing reefs. So Smith, what he does, because he's angry that this company is selling these coordinates to privately created fishing reefs, he hacks their system. He gets in and posts some of their data and says, I'll only remove it if you give me the coordinates to your secret deep grouper spots. The Supreme Court's opinion repeats the phrase deep grouper spots several times. I think whoever wrote it was whichever clerk was the one who did the first draft was as amused as I was at deep grouper spots. The ensuing negotiations over grouper coordinates eventually failed. Smith is charged with theft of trade secrets. As in so many federal cases, problems happen when you involve Florida. So Smith is charged with federal crimes in the Northern District of Florida, the federal District Court for the Northern District of Florida. He moves to dismiss the case for lack of venue, arguing that the data that he accessed were in Southern District of Alabama, or he accessed the data from the Southern District of Alabama, and the company's servers were in the Middle District of Florida. So the Northern District of Florida is an improper venue. The district court denies his motion to dismiss for lack of venue and vicinage, but the 11th Circuit reverses on appeal and sends it back down. So the question is, does double jeopardy bar retrial following a venue or vicinage error? If you try somebody in the wrong venue and the conviction gets thrown out, can you try them again? Just a little background here for those of us who are not con law nerds. So the venue clause of Article 3 of the Constitution says trial of all crimes shall be held in the state where the crimes have been committed. And the vicinage clause of the Sixth Amendment says the defendants have a right to an impartial jury of the state and district wherein the crime shall have been committed. So you need to draw, the venue refers to where the crime happened, and vicinage talks about where you draw the jury pool. So that's the right that was violated here. It gets reversed on appeal in the 11th Circuit. The question is, can you retry him again when the case goes back down? Supreme Court unanimously says yes, does double jeopardy bar it? No. Or put differently, yes, you can retry him again. The appropriate remedy for prejudicial error in almost all circumstances is simply the award of a new trial, not judgment barring reprosecution. It says federal venue and vicinage errors are no different. So it's totally fine to retry a defendant after their prior conviction has been reversed for a venue or vicinage error. The rationale for this goes all the way back into the common law history. You know, the leading decision is Arundel's case from 1593, and Sir Edward Cook's 17th century treatise discusses a mistrial spelled in this cool, old-timey common law sort of way. This is fun for people like me. Here's a picture of me from my office the other day. Again, maybe not so much for the rest of you, so I won't go into depth on that. But the basic takeaway is double jeopardy does not bar reprosecution after reversal under the federal venue and vicinage clauses. Now, this is a federal prosecution, right? So the venue and vicinage are federal issues. In theory, though, you could get a similar issue in Utah, right? We have proper venue by county in Utah. As far as I could tell when I looked this up, there's no Utah case on point about this. There is no Utah court has decided whether you can retry someone in Utah if you tried them in the wrong county the first time around. It's a case of first impression. But if it ever does come up, there's a good chance that our courts would find this to be persuasive. And so if you want to engage in a retrial after getting something thrown out for improper venue in Utah, this would be your leading case to argue that it's okay.
Sorry, thank you. This is a man named Billy Joel. He had a song called Uptown Girl. State v. Uptain is a case about a man named Billy Uptain who was in jail and confessed to a crime. So Uptain invaded a 17-year-old widow's home in the middle of the night. He assaulted her, stole her purse, and he wore a face mask and gloves. Police had no leads whatsoever. But it was a small town. This happened in Green River. And so there were the usual suspects. Uptain was among them, but he was by no means singled out as a primary suspect. He was just one potential person who might have known about this case. A few weeks after this crime occurred, Uptain ended up in jail in a different county, and he got a visit from two drug interdiction detectives who knew that Uptain was a drug user and basically just wanted to see if he'd be willing to provide some information, maybe be a CI. That's kind of what the conversation was all about. So two detectives visited Uptain in jail. They recorded the conversation, but the very beginning of the recording was not captured. That's important. At least we think so. So the meeting took place in the jail, in the booking area. We don't really know what the booking area of this particular jail looked like, and there's nothing in the record that really tells us that. I'm telling you things we don't know because it matters for the case that came later, but none of this stuff was in the record. For example, we don't know if Uptain was restrained. We don't know what the detectives were wearing or what they said leading up to the interview. But during the interview, Uptain was really helpful. He said that he was done with drugs, he wanted to get out, and he really just wanted to help the police in any way he could. So he gave them names of drug dealers, he told them where they might look for information about drugs. And then after that conversation kind of concluded with Billy Uptain agreeing to be a CI if the police ever needed him, the detective said, there's one other thing I wanted to ask you about. There was this home invasion, and he just mentioned the address of where it took place, and Mr. Uptain said, yeah, and I regret it so much, I know I need help. And the detective, he said, I was waiting for you to ask me about that. The truth shall set you free. At that point, the detective said, oh, let me read you your Miranda rights. He did that, and then Uptain gave a much more detailed confession about what was going on at the time and about him committing the crime. So Uptain was charged with aggravated burglary and robbery. The main evidence at trial, really, I wouldn't say the only evidence, but the main evidence was Uptain's confession. He was convicted and sentenced to prison. On appeal, Uptain claimed that his counsel was ineffective for not seeking to suppress his confession. He claimed that it was obtained in violation of Miranda, and the fact that he was in jail and interviewed meant that he was entitled to Miranda warnings. But custody isn't determined by whether or not someone is in jail or not. It's much more fact-intensive than that. And this is law that came out of Howe v. Fields, a Supreme Court case that talked about this exact issue. And in particular, Howe v. Fields involved a defendant who was in prison and was interrogated for like 7 hours in the middle of the night and confessed to a crime. And in Howe v. Fields, the court looked at the totality of circumstances and determined that Howe was not in custody for Miranda purposes. And so his pre-Miranda confession was admissible. So custody for Miranda is not synonymous with supervision or control. And to determine custody, you have to look at whether a reasonable person would feel that he or she was at liberty to terminate the interrogation and leave. Obviously, if someone is incarcerated, that analysis looks a little different. And so if a person's freedom of movement is curtailed, the focus turns to whether the relevant environment presents the same inherently coercive pressures as the type of station house questioning at issue in Miranda. And relevant factors that the Supreme Court identified in Howe were the location of the questioning, its duration, statements made during the interview, the presence or absence of physical restraints, and the release of the interviewee at the end of the end of questioning. Another very important factor is whether or not a suspect is told that they're free to end the interview at any time. In Howe, that factor was present, but in other cases, that factor was not present. And again, weighing the totality of circumstances, suspects have found to be not in custody, even if they're not told that they're free to terminate the interview. So, as I mentioned, there were a lot of things that we didn't. So, at trial, counsel never moved to suppress, and so the record was never developed to know a lot of those factors that the Howe court identified as pertinent to deciding whether someone is in custody or not. And on appeal, Uptain did not seek remand to develop that record at all. So we just don't know a lot of those things. The Court of Appeals found that counsel was ineffective for not seeking to suppress the interview. According to the Court of Appeals, the facts that are in the record were sufficient that all reasonable counsel would have decided that Uptain was in custody and would have sought to suppress the confession, and that motion would have likely succeeded. The problem is, well, I'll get to the problem with that in a second. That's what the court held, okay? So ineffective for not seeking to suppress Uptain's interview. And very important to the Court of Appeals determination was that there's no evidence in the record that Uptain was ever told that he did not have to speak to police. So that is what the Court of Appeals decided. We have sought cert on this case basically because the Court of Appeals analysis under ineffective assistance looks to the absence of key factors in the evidence and assumes that they would have supported a motion to suppress. But that's contrary to what is required under Strickland, where the presumption is that things that we don't know from the record, we presume that they would have supported counsel's decision to not seek to suppress. And so that is, we filed our cert petition. The Supreme Court has requested a response from defense, so we'll see where that goes. But as of right now, this case is out there. So if you have a confession case and it takes place in a jail or some kind of restrictive setting, be advised that the Court of Appeals decision in this case Basically, if the suspect in your case was not told that they were free to terminate the interview at any time, it's going to be a really uphill battle for you.
And this is an example of something, we try to give people advice on what you can do to prevent this. It's really hard for me to think of what a trial prosecutor could have done differently. If the defense hasn't asked for a Miranda hearing, and then the Court of Appeals is just going to assume, we're pretty sure nothing else would have come in at the hearing anyway and reverse. So it's difficult to see what else you could have done other than maybe try to get on the record that the defense has looked at the possibility of a Miranda hearing and declined to do it, that they did so intentionally, but that's pretty clear on the record in Uptain, as I recall correctly as well. So, this is maybe an unfortunate example of something where, we think the Court of Appeals is flat wrong. I wish I could tell you what you could have done to prevent this, and it's not clear to me what there is to be done.
Right. Though I do think the message it sends to defense counsel is that file a motion to suppress even if you don't think it, even if you truly don't think that the facts support it. I mean, that's kind of one potential takeaway. So there might be an uptick in suppression motions, even if they're closer calls than they should be, or if there's a valid basis not to file a motion to suppress.
And Mike, I got a question as well, if I can, is now a good time before you start on Murray?
Yeah, totally.
So I got a question about commenting and vouching for witnesses' credibility. So the question is, regarding a witness commenting on the credibility of another witness, can you ask a testifying defendant whether the testimony of another witness is a lie? You can obviously ask the defendant about the things other witnesses said, if he says the conduct or event didn't happen or are different. But can you ask him if the accusations are a lie? You don't have the same prejudice as with bolstering or with the prosecutor need to get the defendant's position. So the short answer to this question is I'm not 100% sure off the top of my head. My recollection is that there are cases suggesting that can be, that saying, all right, so you're saying you weren't there on Friday. So so-and-so who said you were, they're lying, right? That can, under certain circumstances, be prosecutorial misconduct, particularly where the idea being that it presents a false dichotomy to the witness, that it suggests that the only option is that the other witness is lying and fails to acknowledge the possibility that they're mistaken or misremembering or those sorts of other innocent explanations. I don't recall exactly where our courts have come down on that, but before, and I mean, I know I've seen those arguments made before. I would be cautious about them, and if you have worries about it, it would be worth digging into the case law, because I seem to remember courts having expressed concerns about the sort of, does that mean so-and-so is lying, as possibly being unduly argumentative, particularly if there's another possible reasonable explanation that doesn't involve lying. You want to take the next one?
Yeah. Okay. Another restitution case. So Murray was charged in two separate cases. One was a rape case. He was accused of raping his wife in her sleep. And then in a second case of violating a protective order that she got as a result of that rape. The rape charge was ultimately dropped, and Murray pled to violation of the protective order. The victim missed a bunch of work as a result of the trauma associated with this, and she was also, in a later divorce proceeding, required to sell her home. And so the district court ordered Murray to pay restitution for lost wages and for moving expenses. But remember that he only pled to the violation of the protective order. The rape charge was dismissed. So on appeal, Murray argued that the court should not have considered the rape in determining causation for either lost wages or moving expenses. The district court, in its restitution finding, indicated, that it was considering all of the circumstances that led up to the protective order in making the restitution finding. So on appeal, the state conceded that the victim's moving expenses were not proximately caused by the protective order violation. The facts just didn't totally support that or didn't show proximate cause. But the district court was correct in considering the rape to inform its decision about whether the protective order violation proximately caused lost wages, because violations of protective orders don't happen in a vacuum. Something has led up to the fact that there's a protective order, and those types of facts are perfectly appropriate for a court to consider when deciding, how did the defendant's conduct proximately cause this loss? Obviously, it's going to be highly fact-specific, and understanding, why the protective order was necessary is one reason why, is one factor that may support a restitution finding. So this is just an opportunity to give a little reminder on some restitution black letter law. So in order to obtain restitution, the burden is on the state to prove that the harm was proximately caused by the crime, and proximate cause requires a showing that the crime in a natural and continuous sequence, unbroken by any new cause, produced the injury, and that the injury would not have occurred absent the crime. This requires proof of two elements: but-for causation and foreseeable harm. So I use this case just to give you a quick reminder of the proximate cause standard and what you need to prove when you have a disputed restitution order. Okay, State v. Miller. So Miller was accused of digitally penetrating the victim. The victim resisted, but Miller continued his assault. After the assault, the victim drove Miller home and then went to the hospital where she was examined by a nurse. And she told the nurse what happened. She reported the crime to the nurse, much of it for the purpose of obtaining medical treatment. But in addition to that, there were other things that she told the nurse that weren't necessarily for receiving medical treatment, but nevertheless, she told the whole story to the nurse. Miller was ultimately convicted of object rape, but he was acquitted of other charges. And on appeal, Miller claimed, among other things, that the court erred by allowing the nurse to testify about facts that were not for purposes of medical diagnosis or treatment. So Miller was claiming that, the parts of the nurse's testimony that didn't relate directly to for medical diagnosis should have been excluded. And at trial, Miller's counsel did object to the nurse's testimony on those grounds, claiming that some of the nurse's testimony did not fit the hearsay exception for receiving a medical diagnosis, but he never identified which statements he was talking about. It was just a broad, generalized hearsay objection to the nurse's entire testimony. So the court held that the district court did not err in overruling that objection because it was just too broad. There were plenty of parts of the nurse's testimony that did meet that hearsay exception, and the burden is on the moving party to explain how the objection would keep out particular statements, not just someone's testimony as a whole. So that's also useful because if the state is making the objection, make sure that you're specific about what you're objecting to, and try to make a very good record of that so that if it gets challenged, you'll be in a good spot.
All right. So this is another restitution case, and Kevin McAllister sums up my feelings about it pretty well. Mr. Mooring is the defendant here. He pled guilty to a couple financial fraud cases and entered into a plea in abeyance in 2012. At the time, one of the terms of his plea in abeyance was that he would pay ultimately $50,000 in restitution to the state. And when the court set that restitution amount and ordered that restitution amount, it then entered a payment schedule whereby Mr. Mooring was to pay $100 a month until the $50,000 was paid off. According to my lawyer math, that meant that he had almost 42 years to pay off that amount. I assume he was probably not going to do that. I imagine some of us feel the same way about student debt. So yeah, for about 10 years, that's what he paid, $100 a month. Completed most of the terms of his plea in abeyance. Again, about 10 years later, this is in 2022, the state moved the court to reassess Mooring's ability to pay his restitution. Hopefully so that he would pay more and pay off his restitution sooner. Upon which they learned that Mooring was now making about $13,000 a month and still paying $100 a month in his restitution. The court accordingly ordered Mooring to begin paying $1,100 a month instead of $100 a month. And Mr. Mooring appealed this decision. He argued he argued various things challenging this decision, among them that this adjustment was a time-barred adjustment to his restitution order, and that it violated his protection against double jeopardy. Basically, that it was a change in his sentence long after it had been imposed. The Court of Appeals was not convinced. Firstly, it went through the statutory scheme governing restitution, reminding us that first the court enters a restitution order. It then does two things. It creates a trust account and then establishes the payment schedule. By this, it was clear to the Court of Appeals that the payment schedule is a different thing from the restitution order. And so modifying the restitution order, modifying the payment schedule is not the same thing as modifying the restitution order, therefore not time barred. Same reasoning applies for Mooring's double jeopardy argument. His original sentence, or his original restitution amount, was not changed. He was still ordered to pay $50,000 in total. That he was ordered to pay more did not interfere with his, quote, legitimate expectation of finality in his original sentence. That's what would have triggered double jeopardy, and in this case, not what happened. Honestly, I kind of just included this case, just in case this happens, but also just kind of felt like justice was done. But anyway, next one.
Another question that we just got, following up on Ryan's question earlier about defense attorneys intentionally being ineffective as a hedge against a guilty verdict. Does that give rise to an argument for the state under Strickland that the reason the defense did whatever stupid thing the defense did was a tactical decision as a hedge to get the verdict overturned on appeal? In theory, although I would be very, very careful about saying someone's clever like a fox rather than just having made a mistake, right? It's probably more likely that defense counsel is making a mistake. To the extent that this is an argument that we are raising in our division, we're raising it less in terms of saying this particular defense attorney here was sandbagging and scheming, and more in terms of incentives, right? We don't want to give defense attorneys an incentive where the best thing they can do for their client is not to object, right? Because if you do that, then that puts them in a position where they have no incentive to object, right? So if you had, say if we had a rule that said, anytime the prosecutor wears a purple tie instead of a blue tie, that's automatic reversal, right? There would be no incentive for a defense attorney to object in those circumstances, right? Because the color of the tie you're wearing is not particularly important, but, if you get a free do-over, you're going to use that free do-over, right? So this is the sort of argument about defense attorneys sort of offering a strategically failing to object to things that could be objectionable, really sort of goes more to the way we're structuring incentives. I would say unless you have really clear evidence of sandbagging, I would discourage you from sort of making that charge in sort of an individual case, right?
What if you have the defense attorneys, as they do now, that in open court threaten, a particular request, they'll threaten the judge, if you don't give me this will be let me absolve myself of this expert filing deadline. If you don't, it'll be ineffective assistance counsel. We're going to have to do this case over again.
Yeah, so the question there is what happens if you have a defense attorney who violates a deadline and says, well, yeah, judge, I violated the deadline, but you have to let me redo it anyway because if you don't, then two thoughts on that. One, that doesn't, even if they're declaring that, or maybe three thoughts on that. One, Strickland has two elements, right? So Strickland still has a prejudice element. Two, if it's ineffective assistance for having failed the deadline, that doesn't mean you're not going to get reversed for ineffective assistance for having failed to meet the deadline. So there's a definite risk in doing that. One sort of lingering issue that we see is that our courts are very quick to find ineffective assistance by defense attorneys in Utah. So far as I know, they're not in the practice of reporting it to the bar, right? It does seem to me that if you look at the standard for what effective performance is under Strickland, it's to be deficient under Strickland, you need to be objectively unreasonable under prevailing professional norms. In other words, someone who's saying, I've been ineffective in that way, is essentially admitting they violated their duty of competence to their client. It would seem to me that in a circumstance like that, at the very least, they should be disclosing openly to their client that they've been objectively incompetent, right? If you're admitting that in open court, you should be telling your client, oh, by the way, if it's a paid client, if your client's paying for this, yeah, oh, by the way, I've been objectively incompetent, I'm admitting it now, right? The concern always with that is that, it's an ugly look for the state to look like we can't use bar complaints as a strategic lever, right? Like, not only is that a bad look, but it's expressly forbidden by the ethical rules. You're not allowed to use the threat of a bar complaint to try to influence the outcome of the litigation. You're only allowed to do it because there's a genuine basis for a bar complaint or for reporting to the bar. So I would sort of leave that to sort of your independent ethical judgment, but bearing in mind that ethically speaking, you can only report things to the bar if you think it merits reporting to the bar, not because you want to stop chicanery in a particular case. The sad matter of fact is that if someone blows a deadline and that deadline is case determinative, and had they not blown a deadline, the trial might have gone out the different way, they are entitled to a redo, right? Like that's the nature of it, and they're entitled to the fair trial. The concern that we have is not necessarily that we have concerns about that general principle. We're concerned that our courts seem to be way too quick to reverse, even where there may be good strategic reasons for what counsel did as they did, right? So if you take Mike's Uptain case, for instance, where there's no hearing under Miranda, right? Now, if you suppose you're a defense attorney and you say, hey, look, there may be a Miranda violation, you go talk to your client and say, were you ever told you were free to leave? I said, well, yeah, before they turned the body camera on, they told me I was free to leave and they gave me my Miranda rights, right? The concern is, like, if you were a defense attorney in that circumstance, you'd have every reason not to present a Miranda claim, right? It would be frivolous for you to do so, right? But if the Court of Appeals gets it, what's the record going to look like? It's going to look exactly like it did in Mike's case in Uptain. It's going to look like, well, no motion was filed, right? And we have nothing on the record that shows us why no motion was filed. So, I mean, that's our concern. And again, like, that's sort of a big policy level concern. What can you guys do? In some of these cases, it's really difficult to see what we can do. We can't demand to have a Miranda hearing if they haven't filed the Miranda motion, but to the extent we can clarify things on the record about why counsel, or that even just counsel are saying, I've made a decision not to file it, maybe that gives us something so that if we get it on appeal, we can say, well, look, counsel said on the record they made a decision not to file it. They haven't explained what that decision was, and that may set us up better as opposed to a simply silent record where our Court of Appeals is inclined to find if the record's silent, we'll just assume defense counsel was an idiot, right?
Speaking of ineffective, this is another ineffective assistance case. State v. Naranjo. Naranjo was stealing envelopes from a pay box at a marina, and police got a report, came to check it out, and the defendant led the police on a ridiculous slow-speed chase through an enclosed parking lot while throwing drugs out the window. So, just, come on. So on appeal, Naranjo, he made a number of claims. I'm just going to highlight one here. This is kind of a holdover from the unanimity discussion. This is a different flavor of unanimity. The court found no prejudice in this case, and I'll explain why. So on appeal, Naranjo was claiming that his counsel should have sought a unanimity instruction to identify which particular acts of the officer's actions constituted the signal to stop and which acts constituted the defendant's failure to stop. The defendant was charged with failure to stop. Naranjo claimed that it could have been approaching the car with his hands out, or it could have been activating the light bar, approaching the car the second time, or approaching the car with a gun drawn. Any of those Naranjo claims could have supported the first factor, which was what constituted the signal to stop, and then what constituted the failure to stop. Naranjo claimed it could have been driving away when officer first approached, or continuing to drive away after officer activated the light bar, or driving away again after temporarily parking, or still driving after officer returned a second time. So a couple different acts could have supported any of those. The court basically said it wouldn't have mattered in this case because even if counsel had requested a unanimity instruction, there's really no question on these facts that there was a reasonable probability that the jury couldn't have coalesced on one of those theories. Like, there was evidence of all of them, and so to say that, the jury couldn't have decided on which one, it was just not enough to show prejudice here.
Did they address performance in that case?
I think they just said, assuming.
For whatever it's worth, I mean, in talking about whether a unanimity instruction is necessary, remember I said the distinguishing factor is whether you're talking about different ways of committing the same one crime or different potential crimes. The facts of that case sound a lot more like one continuing crime. Like if someone presses the gas 5 separate times while running on their slow speed chase away from police, that doesn't sound like 5 counts of fleeing, that sounds like 1 to me. And so my gut is that's probably one where you wouldn't need a unanimity instruction, but I don't, I'm not 100% sure on that, but just as sort of an illustrative example. All right, another U.S. Supreme Court case, Dubin versus the United States. This is a case about a psychologist, but not any psychologist. It's about an evil criminal psychologist. Dubin and his father ran a psychological services company, and what they would do is they had a scheme to defraud Medicare. So they would arrange to have tests done by a psychological associate, which is sort of a lower level paraprofessional, and then build Medicaid as if it had been done by a licensed psychologist, which is reimbursed at a significantly higher rate. So they're overbilling for each test they're giving. And so they're charged with 2 basic sets of crimes. One is healthcare fraud. Yes, good, this sounds like healthcare fraud to me. And the second is aggravated identity theft. Now, why would they be charged with aggravated identity theft in a case where they're just overbilling Medicare? Well, so the federal identity theft statute says an actor commits identity theft if during and in relation to any predicate offense, they knowingly transfer, possess, use without lawful authority a means of identification. And so what the prosecution says is, well, in order to do this fraudulent billing, they had to, if I'm giving, Mike a psychological examination and then billing it to Medicare, I have to use Mike's Medicare number in order to submit the bill, right? Well, and when I've submitted the bill, that's a means, his Medicare number is a means of identification, and when I've submitted it, I've used it to commit the crime. So under the plain language of the statute, anytime I use someone else's identifying information, I'm committing aggravated identity theft. The district court, to its credit, says, that doesn't really seem like identity theft to me. That just seems like using personal information, but not really stealing someone's identity. But it lets the conviction stand under controlling circuit precedent. So apparently at the time, federal prosecutors had sought similar identity theft convictions in a lot of similar cases. So some examples. So making a counterfeit handgun permit by using someone's real name and at that person's request. So Mike wants to use wants a handgun permit, I use Mike's name because Mike asks me to. Unlicensed doctors issuing actual prescriptions. So I'm not a doctor, I'm pretending to be one. I stayed at a Holiday Inn Express last night, and I write the patient's name. Well now you've just used the patient's identifying characteristics on the prescription. Misbilling ambulance services, billing massages as physical therapy. Those sorts of activities. And so the question before the U.S. Supreme Court is, what does it mean that an offender must knowingly use a means of identification in relation to an offense? So the government says that a means of identification merely must facilitate or further the offense. Here, using the Medicaid number facilitated the completion of the offense, that's enough. What the defense says is, no, that's not identity theft. To be identity theft, the means of identification must be at the crux of the offense and not merely ancillary. The U.S. Supreme Court agrees with the defendant here. In a holding written by Justice Sotomayor, it says the identity theft statute only targets situations where the identification itself plays a key role or was the crux of the crime. So both sides here are offering plausible readings of the statute, but the statute's title, aggravated identity theft, suggests a narrower reading. And the prosecution's reading would transform lots of crimes into identity theft, including any crime where you use somebody else's name or any crime using common billing methods. Those would all be transformed into aggravated identity theft under the federal statute. So what's the relevance for us here? Well, Utah, so this is the federal identity theft statute. The federal identity theft statute says a person knowingly uses a means of identification during and in relation to a predicate offense. Utah's identity theft statute is similarly worded. So our identity fraud statute, an actor knowingly or intentionally uses or attempts to use the personal identifying information of another person with fraudulent intent, including to obtain or attempt to obtain things of value or information. So analogous wording here. What's my takeaway here? Dubin talks about being at the crux of the offense. What do I really mean here? The best advice I can give you if you're charging something under identity fraud in Utah is don't be cute, right? Don't be too cute about trying to define something as identity theft. The Supreme Court's jurisprudence on this area isn't strictly binding because it's interpreting a federal statute, but I suspect it would be persuasive in Utah. And so if you find, if you charge Utah identity fraud, stick to situations that feel like identity theft rather than ones that feel like you're trying to crowbar it in. I mean, to the extent that there's an enforceable rule, that's the one I draw from Dubin. All right, next case I have is State versus Swearingen. This is a case about informants. Oh shoot, sorry, that's not correct. Hold on. Okay, there, that's better. All right, I fixed it. All right, so facts of this case. A detective would recruit drug dealers as confidential informants by agreeing to help them reduce their drug charges. In this case, the informant in question had been, as far as I can gather, had been recruited in this way, but then they no longer had any pending drug charges, so the defendant agreed to pay the informant $100 for each undercover buy that they carried out. The informant then wore a wire during several undercover buys with the defendant here. The law enforcement observed the informant entering and leaving the defendant's house, but didn't see the actual drug buys, and the audio recordings were sometimes unclear or didn't contain clear discussion of the drugs. So what the upshot of that is that the state's case, to at least some extent, significant extent, turns on the perceived credibility of this informant, right? Because we don't, for some of these, we're sort of trusting the informant's version of events in order to get to guilt. So after the defendant is arrested, but before the defendant goes to trial, this informant is arrested on new drug charges. The informant's not charged with the new drug charges, but they're arrested. And the defendant argues, all right, well, that evidence of the new arrest is admissible under Rule 404B, because the fact that this informant got a new arrest just recently gives them an incentive to curry favor with the prosecutors and a motive to testify favorably for the state so that he's not going to catch those new drug charges. You know, he's been arrested but not charged, but they might charge him any minute if he doesn't curry favor with the state. So that's the 404B theory that this defendant is arguing. District court disagrees and says, no, I'm excluding the evidence that this informant has been arrested again. Swearing's and appeals. So gets in front of our Court of Appeals. The Court of Appeals reverses the conviction and remands for a new trial. The evidence our court finds was highly probative to a jury weighing the informant's potential for bias. And because the state's case depended heavily on the informant's credibility, the exclusion of the evidence our court finds was prejudicial. So takeaway here, short takeaway is an informant's known criminal activities, even if they occur after the crime was committed, if the new criminal activities occur before trial, those are very likely to be relevant and admissible under Rule 404B. Don't fight it. You're just going to have to sort of give the classic thing about, we would love to have all of our witnesses be a bunch of priests and nuns, but we don't have that. We have to deal with bad people sometimes. Thanks.
Okay, State v. Prettyman. This is a case involving UHP officers and an officer's testimony about drug quantities and what that is indicative of, personal use or distribution. So a UHP trooper pulled Prettyman over because he was erratically driving, failed FSTs, and was arrested. They found 50 grams each of meth and heroin, and he was convicted of possessing controlled substances with intent to distribute. At trial, both the UHP trooper and an officer who assisted in the search testified that based on their training and experience, the quantities of drugs that Prettyman had were greater than what a typical user would have for personal use. And trooper also testified that the presence of cash, numerous small baggies, the large quantity overall, led him to believe that it was likely for distribution. On appeal, Prettyman claimed that his counsel was ineffective for not challenging that testimony. In part, it was because both the UHP officer, the trooper and the officer both were relatively new. The trooper had been on the road for about, I think, a year at the time he arrested Prettyman, and officer had been an officer for about 2 years. And the claim was twofold. One, that the testimony was improper because those two officers lacked the expertise to be able to opine on those things. And then secondly, that opining on the quantity of drugs that users typically used is improper under Rommel. And the court rejected both of those claims. They found that the trooper and officer's testimony were appropriate based on their training and experience. Even though they didn't have a ton of experience in the field, they'd still, gone through post, gone through drug training, and reported in testimony that they had, dozens or many dozens of arrests related to drug use and distribution, and so they had a valid basis from which to opine on. And then it's helpful, in Rommel, the issue was testimony about truthfulness, and that's an unquantifiable thing. It's not subject to verification in any way. Drug quantities is just obviously different because it is literally about numbers, and it is verifiable and subject to statistical analysis. Let's see. Simonelli versus United States. This was a Supreme Court case, U.S. Supreme Court. Simonelli, this was related to Governor Cuomo, former Governor Cuomo. There were a number of public corruption prosecutions that came after investigations into his his time as governor. This is one of them. This related to a program called Buffalo Billions that was like a incentive program to build up the Buffalo area. And Simonelli really wanted to get in on that. There was a lot of lucrative contracts, and so he was charged with wire fraud, which federal wire fraud prohibits using a scheme or artifice to defraud. And there's a particular theory of wire fraud called the right to control, and that basically involves using your influence to deprive a decision maker of potentially valuable economic information necessary to make discretionary economic decisions. And in a unanimous opinion by Judge Thomas, the court rejected this right to control theory of wire fraud, and they held that this type of wire fraud is not the type of property interest that existed at the time of the wire fraud statute was enacted. And so it is just not a viable theory under wire fraud. Probably not a lot of impact for Utah cases. I was trying to think of similar cases or similar statutes that, and there's communications fraud, but communications fraud, it has to be tied to obtaining something of value or to obtaining personal information. So it's not just this more amorphous theory of the right to control. So I don't know that this would necessarily be very impactful for a lot of Utah prosecutors, but Supreme Court precedent. Let's see. Got a question. Were the officers in Prettyman noticed as experts or just testified as fact witnesses and then gave non-expert opinion testimony? They were not noticed up as experts, but the Court of Appeals determined that even if they had been, it's likely that they would have been qualified to give the opinion that they testified to, and so it was not unreasonable for defense counsel to forego that objection.
All right, State versus Camarra. This case poses the important question of, does dragging a struggling victim at night across a busy 5-lane road expose the victim to a risk of bodily injury? The district court in this case said no, but I have a compelling argument to the contrary.
Why did the frog cross the road? He didn't. We've rebuilt one of the greatest video game heroes of all time, and now he's back. Frogger on CD-ROM. The classic arcade game is back and better than ever with more graphics, more worlds, more enemies, more superpowers, and is more addictive than ever. The hardest part is turning it off. Frogger on CD-ROM for PC and PlayStation game console. Revived, rebuilt, and ready to hop.
Hey, buddy, you okay?
My former colleague, who many of you may remember from these presentations in years past, John Nielsen, handled this case. And he actually cited Frogger in the brief, which please don't laugh because it will only encourage him. He could very well be listening to this. And John, if you are listening, that was awesome, and I hate it. And I hate it so much, and it was great, and don't you ever do it again. No, it's actually one of the only times I would have thought a video game reference would be appropriate in a brief, but it worked. Basic facts. This is actually, I mean, I kind of kid about the circumstances. The actual facts of this case are quite scary. So a victim was walking down Redwood Road in Salt Lake City when a stranger grabbed her from behind, struck her in the face, knocked her to the ground, said he had a gun, and dragged her across the street. And when they got to the other side, several bystanders thankfully intervened, and the victim was able to escape and call police. So Camarra is charged with first-degree aggravated kidnapping. And so this crime is a first-degree felony if it's predicated on a kidnapping, but only a third-degree felony if it's predicated on an unlawful detention. So the difference between kidnapping and unlawful detention, then, is whether the restraint or detention was done under circumstances exposing the victim to a risk of bodily injury. So in other words, the felony offense level turns on whether Camarra exposed the victim to a risk of bodily injury. The jury convicted of felony 1, and Camarra moved to rest judgment saying there's no evidence of a risk of substantial bodily injury here. District Court agrees, says there's no risk because Camaro was trying to dodge the cars and avoid the passing traffic, and that's enough, right? The state appealed, and the Court of Appeals thankfully reversed. Although waiting for traffic may have mitigated the risk, a reasonable jury could conclude beyond a reasonable doubt that Camaro exposed the victim to an actual risk of injury. The victim was exposed to actual risk by trying to escape her attacker in the middle of multiple lanes of traffic late at night, despite not actually being hit by a car, right? So a risk can still be a risk even if it doesn't actually happen, and even if you're taking steps to avoid the risk, right? Basic common sense. Little footnote here, if you have a case involving a risk-based standard, the court also says in a footnote that the jury could reasonably conclude that Camaro's ability to safely identify and avoid vehicles wasn't diminished because he was under the influence of narcotics at the time. And so if you have a defendant who's high and you need to show that there's a risk, that the defendant's posing a risk, this case can help be a good citation to say, look, the court says that if somebody's high, they're more likely to pose a risk. So, victim can be exposed to a risk even if it doesn't occur, and the risks increase if the defendant is intoxicated. I see I'm out of time, but I'm going to try to do one more real quick because this is, I think, a helpful message and I can get it done fast. UOVC versus Hembry, this is about who and what can bind who and what. So Hembry pleads guilty to several felonies. The plea agreement doesn't specifically mention restitution, but it doesn't preclude it either, right? So the plea agreement's basically silent on restitution. The UOVC later moves for restitution at sentencing, and for this is the Utah Office of Victims of Crime, right? The district court denies restitution because it says, restitution wasn't in the plea agreement, and it says, and the UOVC is an arm of the state, and so it was bound by the state's plea agreement as a state agency. I saw Ryan shaking his head, just, oh, no, yeah, you're right, no. Court of Appeals reversed here. The prosecutors in the UOVC are state agents, but they are separate entities. The UOVC is not bound by the prosecutor because the UOVC, for purposes of restitution, is a victim. And absent special circumstances, prosecutors don't represent and can't bind the victim. This is helpful for a couple of contexts. One, in the restitution context, right? But it's also just helpful to remember in general that although we often seek to vindicate the rights of victims, we do not represent them. And then we generally can't bind them without specific authority to do so. So, there are specific provisions of the Utah Code that on occasion, after we've consulted with victims, they allow us to bind the victims. But those are limited and constrained by statute. And so this is important to remember, not just in the context of plea agreements, but also in the context of other important rights where victims may have distinct interests. So like evidentiary privileges, for instance. If a defendant is requesting a victim's therapy records, as we've seen in some recent Utah Supreme Court cases, we can't turn those over, right? Because we don't hold the privilege, the victim does. And so we need to go through the victim, and the victim has an independent right to litigate that if they disagree and don't want to disclose. With that, we are, I think, out of our time. We always order these in order of importance, so hopefully the last couple of cases are not as important as the initial 4.5-hour presentation. As always, feel free to reach out to us if you have questions. I will be hanging around, obviously, for the rest of the day today. I'll be back again tomorrow. Feel free to come by and chat or shoot us an email, give us a call. We're always happy to talk. Thank you so much. Thanks. And I just have to show this slide because I really like this.
Okay, if we can have you start coming in and finding your seats again.
Sit up here.
It's up to you. Because your mic, I mean, if you want to roam, just understand that my camera guy, he won't want you roaming too far. Yeah, but you don't want to have I think it should be all.
Okay. Try test. Test, test.
All right, everyone. One announcement on your CLE is if your office did not get us a check until, say, yesterday, you are not, and you can't complete your CLE online form, that would be why, is we haven't recorded you. Marilyn is actually back at the office. She tells me she's making a deposit today, $40,000, y'all. Thank you for sending in your checks. We appreciate it if you would send them in a little bit earlier. But if you're having problem completing your CLE, that's why she will be working on it throughout the evening, and hopefully tomorrow you'll be able to get in if that's what's keeping you out. Okay, our next presentation is on justification hearings, and Josh Graves from the Salt Lake County DA's office is here. Josh, where are you, is currently the division director with the DA's office, where he oversees all homicide, gang, and juvenile prosecutions, as well as manages multiple trial teams. He's been a prosecutor for over 16 years and has worked on nearly every type of criminal case, ranging from misdemeanors to aggravated felonies. He's conducted 4 homicide trials and continues to carry an active homicide caseload in addition to his admin duties. In his free time, he coaches his twin sons' baseball teams, plays guitar, skis, and bikes depending upon the season. Josh was at our Train the Trainer a couple of weeks ago, and I can testify to his guitar skills, and I still remember 3 chords and a truth. 3 chords and a truth. So with that, we'll turn it over to Josh.
Thanks, Bob. Can everyone hear me all right? Yeah. Okay. A second. Gotta do something here. All right. And just so we're all clear, I'm only in my position because I've lasted as long as I've had at the district attorney's office. I see a lot of my former colleagues here. I know a lot of them are online. Miss you guys. We're still battling. I'm here today to talk about justification hearings. And I'm trying to be clever with my subtitle here by calling it an unreasonable and unnecessary use of process with the imminent threat of dismissal. Because you will get cases dismissed if you do not approach these cases or these hearings with full preparation. How many in the room have participated in a justification hearing? And how many have had their cases tossed after a justification hearing? Okay. I'll be talking about one of our cases, which was a homicide that was dismissed in January this year by one of our 3rd District Court judges. It was a close call. When we screened it, you'll see why when I talk about it. So what to expect in today's presentation. I'm sure a lot of you here are familiar with self-defense laws, but since that is the crux of what a justification hearing is, we will walk through our use of force, justification statutes, just so you understand these are the elements that we have to disprove by clear and convincing evidence at a justification hearing or show that the defense has failed to make a prima facie case. I will try to get through those fast because I'm sure a lot of you are familiar with them, and that's kind of the boring aspect of this presentation. We'll then talk about the justification hearing statute, talk about the process that we think is the process. I think that's still a work in progress. And then State versus Clara. I don't know if that case was covered in the case law review. It just came out last month, but that was a case that directly addressed the justification hearing statute. Interesting ruling that came out of that case. I'll show you some of the video from that case, some of
the facts, and you can decide if you think the Supreme Court got it right. It's a tough one. Then we'll talk about some practice pointers, some suggestions on ways to improve your investigation so that you can block a justification hearing from even coming forward, or be in a position where you feel prepared to appropriately litigate that when it inevitably comes, as well as some things you should do during the hearing. And then I'll get to the fun stuff. I got several case studies from cases our office is currently prosecuting and has prosecuted that will, I hope, elicit some thoughts and analysis in your own minds on how justification will apply in those cases. So let's first turn to the justification statutes. So you have two primary ones. You have self-defense or defense of others, and then you have defensive habitation. Defensive habitation, I'm going to tell you right now, has been the bane of my existence on a couple of cases. It is a very difficult defense to defeat if it is applicable, and the case that I'll talk about will highlight some of that. But you should have got handouts. I tried to summarize this, the statute with just the key words, because I'm trying not to commit PowerPoint felonies based on my train-the-trainer training. But the operative words here for serious bodily injury, you have to reasonably believe that deadly force is necessary to prevent serious bodily injury or death from the imminent use of unlawful force or to prevent a forcible felony, right? So if you are going to use deadly force against someone else, you must be faced with the imminent threat of force that could cause you serious bodily injury or death, and you have to reasonably believe that that threat exists. And if that can be accomplished, you are justified in using force against another person. Defensive habitation is a little bit more nuanced. It requires that someone violently, tumultuously, surreptitiously, or with stealth enter or attack a habitation where someone lives. We had a fascinating case a while ago where a transient was living in a cardboard box house, and the court determined that that was a habitation, basically anywhere someone can live. They're doing that entry for the purpose of offering personal violence upon that person, or to assault a person in that habitation, or to commit a felony in the habitation. Now, those can be established, but self-defense doesn't apply in several situations. How many of you guys seen that video? You guys recognize that one? The more you, I'll tame it down, but the more you mess around, the more you find out, right? I got a trial coming up in June that this is going to be my theme, because I think the defendant messed around a little too much and he found out. Then he tried to use that as an excuse to kill someone. So if you are the initial provoker of violence, if you initially provoke the use of force, you do not get to claim self-defense. So this case I'm talking to you about, I got in June. There was a Halloween party going on downtown. A bunch of 20-year-olds kind of took custody of a warehouse that one of their dads owned. I don't think they had permission to use it. They're throwing a Halloween party, and our defendant shows up, decidingly not to participate in the costume theme. He just shows up with athletic shorts, t-shirt, backwards hat, and a 9mm on full display in his waistband. So I don't know, maybe his costume is irresponsible jackass. I don't know what he's doing, okay? But he's walking around the party, everyone sees the gun, and he's just trash-talking people. He's trying to goad people into fights, and everyone's trying to have a good time. And right before a shooting occurs, we got cell phone footage. And in that cell phone footage, you see him walk up behind a girl with a ponytail. And he grabs the girl's ponytail and he pulls her to the ground, and she falls to the ground. 3 guys are standing by, see that, don't take too kind to a dude pulling a woman by her hair down to the ground, and they jump on him. And they start punching him, and they start kicking him. And as they are trying to restrain him, he's able to pull his gun out, puts it point blank on the person's chest, and shoots them and kills them. Runs away. Now, that case, there's not going to be a justification hearing in that case. Just I know that kind of departs from the point of this presentation, but that particular defense attorney does not believe in justification hearings. He thinks that why would I show the prosecution my cards before trial? I'm just going to ambush them and sandbag them and see if they can adapt. That's kind of his approach. But thankfully, we filed some reverse discovery requests, and by the time the final pretrial came, he finally gave us his list of witnesses. And granted, this was a party with like 30 people, and they all dispersed. Some of them are gang affiliated. The police tried to identify as many people as they could. We found the people that were involved in punching him. We found the girl that had her hair pulled, but other people were not identified. Well, of course, the defense attorney has identified several people now who want to come and talk. And so we go out and interview them. We get the trial continued. They really don't have much to add to the case, but it was nice to file the reverse discovery and get them locked in on statements so they can't come in on the stand and just make up a bunch of nonsense, which is what they tend to do. But my argument simply to the jury is going to be, you walk around with a gun on display, you're trying to goad people into fighting, you pull someone's hair, you're messing around, and now you're finding out because these guys are going to dispel that use of force. Now, had he not pulled the girl's hair down and just got attacked, I would be a lot more concerned. Because 3, 4 guys surrounding you, punching and kicking you, could cause you serious bodily injury and fear of injury, so you might need to defend yourself. I don't know how a jury is going to look at that. We'll see. But that is the argument there. We don't think he's going to get self-defense because we think the evidence shows provoked the situation. The other defense that's applicable is engaging in felonious conduct. And sorry, I'm not trying to be rude, folks. Okay, I was just making sure something's happening here. Okay. Engaging in felonious conduct. You cannot be engaged in a felony and then claim self-defense. One of the hardest conversations I had to have with a family last year, they were a family of a young 21-year-old man who was hanging out with his friends, and they thought it'd be fun to go kick in some drug dealer's door and rob him. And so they do that, and they kick in the door. One of their friends has the gun. He pulls the gun out. The guys inside realize what's happening. They wrestle the gun away, and then they shoot and kill. And they shoot to kill one of the burglars. And the family of one of the burglars was very upset that we're not charging murder. And I have to sit down and tell them, like, I'm sorry, but you engage in felonious conduct, you engage in aggravated robbery, you engage in aggravated burglary, you are not entitled to self-defense. And it sucks, made a poor decision, lost his life, but that's, again, mess around, find out, right? And then combat by agreement, mutual combat. I'm hoping if we have time, I'll show you an example from the prison, what I think is combat by agreement. Even though the public defender is telling me they're going to try to set a justification hearing under the theory of defense of others, which that'll be fun. So we'll see if we have time to get to that. Where did my clicker go? Let's do that. There it is. So a little bit more on self-defense. Self-defense is also an issue of proportionality. Reasonable force must end once the threat ends. You can't spike the football once you're justified. There will be a point where you've done your job and you've terminated the threat, and it's not an invitation just to go ape on someone else because you're angry. The responsive force also must be strictly necessary. You must have an objectively reasonable fear that serious bodily injury or death may occur. And it doesn't have to be factual either. We've done a lot of officer-involved shooting investigations, and this comes up often. An officer sees a furtive movement into a pocket. An item is pulled out. It's dark. It looks like a gun. It turns out to be a cell phone. If they objectively believe, though, that was a weapon, even if it factually wasn't, then self-defense it could still be applicable. Same goes with like airsoft guns. Someone pulls an airsoft gun, it looks real, factually not real, but you believe it is, that's objective. And the individual must subjectively have fear too. You know, some of us might be tougher than others, and we could pretend like something spooked us, but we actually have to have the fear to act in self-defense. So that's my basic summary of the self-defense laws. Let's get into the justification hearing. This is the only GIF I have in my entire presentation. I apologize. But back in the good old days, before the justification hearing, it was very simple. It was just went to trial. It was a jury question. It would be raised at trial. The defense would have no burden of proof. They had no notice obligations. It would allow us to be sandbagged if you didn't do your proper discovery practices. They could raise it at any time. We have to disprove it beyond a reasonable doubt. All this stuff still applies, by the way. This is all we had to do before the statute. Must disprove beyond a reasonable doubt. And as long as they present some evidence of each element of self-defense, they're going to get the instruction. And so if you get a whiff that that's going to happen, you just need to prepare your case for that. By the way, I want to thank Andrew Peterson at the AG's office. I borrowed some of his slides to make this presentation easier. And I also want to just thank the appeals division at the AG's office, because I know that our office, you know, we give them a lot of work. We got a lot of young attorneys and challenging LDAs and public and judges, and it's a street fight sometimes. It ain't pretty. And so I really appreciate them going to bat for some of the issues that we're bringing to the court. I feel like we're kind of a petri dish sometimes of legal issues. And someone's got to help to find the line somewhere. And so hopefully we're doing that. Okay. Utah Code 762309, the justified use of force. This is the justification hearing statute. I failed to look up before today's hearing why this bill was presented, what occurred, who complained to the legislature that this was needed. Will, do you happen to remember?
Gary originally said we needed it
Because Florida had it? Nice. That's a very good reason to make our jobs more difficult. Like, we gotta be like Florida, right? Okay, so let's talk about how this works. First of all, there are instances where the use of the justification hearing is not applicable. Sorry, I got a timer here, you guys, 15 minutes. Hold on, bear with me for a second. Let's see. What time is it, guys? 16:45? 16:45 to 1700, teaching prosecutors about unnecessary law concerning justification hearings, documenting my time in preparation for unnecessary law, requiring me to document my time. I'm just going to do see above for the rest. I won't be doing that again. Okay? And I do want to thank everyone in this room and all of their respective county attorneys for drafting that letter to Governor Cox, asking him to veto the bill. I can just tell you on behalf of the attorneys on the ground in Salt Lake that are grinding every day, it was very comforting and reassuring to know that our fellow jurisdictions had our back and could see how ridiculous, in my opinion, respectfully, that law is. We got attorneys working 50, 60 hours a week, carrying 400 cases. We don't need to be billing our time on each case, right? We're doing everything we can to fight the grind. And it's just a bit ridiculous, so. But if anyone's from Layton, it was like a representative from Layton that brought the bill. And I didn't realize Layton, the people of Layton cared so much about how Salt Lake County prosecutors use their time. So thanks for their concern. I hope it doesn't pass down to you all. We will do our best to give whatever data is needed. So where was I? Okay. Justified use of force does not apply if it involves a law enforcement officer. If you're assaulting a law enforcement officer, you don't get a justification hearing. If you are a law enforcement officer that used force on someone else, you don't get a justification hearing. If it is a Class B misdemeanor, a Class C misdemeanor infraction, you do not get a justification hearing. And if it is a crime of domestic violence, you do not get a justification hearing. All right? Everything else, fair game. So the way it works is upon a motion of the defendant, the court shall hear evidence on the issue of justification. And after the defendant makes a prima facie, I don't know how you say that, it's a prima facie claim of justification, the state then has the burden to prove by clear and convincing evidence that the defendant's use or threatened use of force was not justified. If the court determines that the state has not met the state's burden, the court shall dismiss the case with prejudice. That is a big deal, right? You have to treat these hearings as if they are trials. You could lose your case entirely out. One judge can knock your entire case out. If the state has met the state's burden, luckily for the defendant, they could still raise it at jury trial, and the state still has the burden to disprove it beyond a reasonable doubt. So everything that applied before still applies now. They just get a bite of the apple before we get to the box. So how the statute works, we file our case, the defendant files a motion, and this is a big part of this. Rule 12 requires certain things, okay? I wish, and maybe this is for a discussion down the road with our Rules of Procedure committee, but these motions need to have some particularity. They can't just say, I want a hearing because I felt like I was in danger. How are you as a prosecutor going to know or anticipate what to put on if you don't know what they're going to say? So if they file a very bland, non-detailed motion, I would move to strike under Rule 12 and insist that they give you some more particular facts in support of this motion. Because you need to be ready for this. You might lose your entire case. There's other requirements under 12C3. They have to do it 28 days before trial, and it has to be in writing. They can't just make it orally. So hold them to those requirements. The court grants a justification hearing if the motion is compliant. The defendant must make the showing at the hearing. And this is, we'll talk about this when we go through State v. Clara, because this issue didn't come up on that appeal, because the parties from my office and the defense just agreed on the procedure. I would challenge everyone to think, like, once a justification hearing starts and the defense stops and they say, we've made our prima facie claim, and you're like, I need some time here to respond to this because this is all stuff, a lot of this stuff will probably be new, not reported to the police, whatever the defense investigation came up with. I think it's well within reason to say, Judge, we're going to take a continuance here because now the burden's shifted to us and we need to go be prepared. Yeah.
Despite the judge, I heard good practice before not ruling in our favor very often at justification hearings. That is one thing that he does do. We do it on 2 separate days always. This is how it's scheduled.
That's perfect.
First defendant comes and they have to present their prima facie case, and then we come back in a couple of weeks where the burden shifts to us.
Which jurisdiction are you in?
4th District.
So for those on WebEx, 4th District, and I think that this is a great practice, if you can persuade your judges to do this. They have 2 separate hearings whenever a justification hearing is requested. The first being the prima facie showing, and then the second one being our clear and convincing response. So if you can persuade a court to do that, it'll take some stress off you. It'll buy you time to do some further investigation to respond. I think that that is the way we need to do it. That's not what we did in State v. Clara, but to defend my folks, this was one of the first ones teed up, and it was foreign territory for a lot of us. So I think that that would be the practice I would suggest everyone employ when faced with these. So let's talk about State v. Clara. I feel like I'm not with you on the slides. There we go. Okay. Now, it's always fun for me to read an appellate opinion and how they describe the facts of a case and compare it to like what I understood the facts of a case to be. And now I might be, my conception of this might be wrong, but let me read to you before you watch this video how the Supreme Court describes the facts of this case, okay? Clare was driving northbound on 900 West, and suddenly his vehicle was rear-ended by the driver of a pickup truck that had a snowplow attached to its front. Thinking this was just an accident, Clara moved his vehicle to the side of the road. But the snowplow struck Clara's vehicle again, this time with more intensity. The snowplow then hit Clara's vehicle a third time. The third strike caused Clara's SUV to spin around and face oncoming traffic. Finally, the snowplow hit the SUV a fourth time, T-boning it on the passenger side and causing some airbags to deploy. At this point, the snowplow began driving away, and Clara got out of his SUV. Based on the damage caused by the contact, Clara believed that the vehicle was inoperable. And due to the final blow to the passenger side, Clara believed that his passenger might be injured and trapped in the vehicle. Once outside the vehicle, he noticed the snowplow's brake lights were on, and then he heard the snowplow skid on the street approximately 50 feet away. Then, to his dismay, he saw the snowplow begin to turn right into some business or driveway to make a U-turn. And once the snowplow began this maneuver, Clara believed it was turning around to hit him or his passenger, with the passenger still inside. And fearing for his safety and his passengers' lives, Clara pulled out a gun and fired 7 rounds in the direction of the snowplow. According to the video timestamps taken from the dash cam, only about 6 seconds passed between the final strike and when Clara began shooting. Now, it took me a while to read all that, certainly more than 6 seconds, but for him to go through all these thought processes, I think is interesting. Like, I got to, where was it? It being T-boned, worried about his passenger, thinking his vehicle's inoperable. Now I got to get out and pull out a gun and start firing at this vehicle because I think it's going to turn around. Like, all that's apparently happening. According to 6 seconds, I think it's a lot faster when you watch the video. And it's also interesting that this dude is running around with a dash cam on his car. That's kind of weird. And he's got apparently a firearm on his person, locked, loaded, ready to roll. I mean, it's not like, I mean, I have guns, but I'm not like, it's not in my car where I can just reach it and it's like ready to fire out the bat. This is irresponsible, I think. So let's just watch that. And I think this can be subject to everyone's own interpretation. But I wanted you all to see it. One hit.
What is... Shit. What the hell? Yes.
You can see him come out in front here. Yeah, all of our witnesses are leaving now.
900 West and 100 South.
You guys want to watch that again?
80145. Oh, what the hell? What is... Shit.
It's a beater. That truck's a beater.
What the hell? Yes.
So, a couple things. I mean, does this seem unreasonable for me to suggest that he got out of that car pretty fast and was ripping off shots really fast? And did that seem, I mean, he's getting bumped. Like, I would be really pissed off if a snow plow was bumping my car like that, but like, did it seem like it was over the top, like, power going on there? Not really, okay? That, one of those shots was literally inches from going through a 7-year-old's head. Not in the snowplow, but in the car on the other side of the direction he was shooting. He wasn't checking his backstop. He wasn't being a good gun owner. And what do you think shooting a snowplow is going to accomplish in this situation? Okay? So, from the investigation, we were not able to locate the driver of the snowplow. In fact, the snowplow was found around the corner, abandoned shortly after this, and it was reported stolen. So if you want my guess, it was probably some meth head doing his best ludicrous move, B, get out the way impression. I'm glad some people laughed at that. That's a throwback, you know, but I'm glad some people caught it. So that would be what I think would happen. And you see the damage on the car. Did I have that slide up? I mean, it's notable. I'm not seeing the T-bone thing, though, that the Supreme Court's talking about. I don't know where they're getting the T-bone thing from. I see damage to the fender, which probably caused the car to rotate. And then I see this is the other vehicle not involved. The bullet goes through the driver's side, right above his head, to exit the rear side where the girl was seated. So this could have been a tragedy. Thankfully, it wasn't. So we go to the justification hearing. Now, the Supreme Court, in their summation, said that the state did not present any evidence. I'm going to defend my prosecutor here. We subpoenaed 4 people. We subpoenaed, well, 3. The passenger in Clara's car and the 2 officers that were involved in the scene reconstruction. And the defense brought Clara. But remember, they got to show the prima facie case first, okay? So all 4 witnesses were called by the defense, and we cross-examined them. So the notion that we didn't present evidence, I think, was a little unfair. We did through our cross-examination in the prima facie case piece. Clara testified. And to his credit, he did stay on scene. He did speak to the police. He wasn't like running away and then coming up with some excuse later. But he says, you know, I can hear him skid on the street. Then he starts turning right, like, you know, into like some business or driveway to make a U-turn. He's going to go up on the sidewalk and the driveway and turn back around. I was just aiming to let him know if you come back this way, you know, you're going to get shot. So that's kind of the case there. The things that we get from Clara is some clarity on what it means to show a prima facie case. They cite to Black's Law. Prima facie case is sufficient to establish a fact or raise a presumption unless disproved or rebutted based on what seems to be true on first examination, even though it may be later proven to be untrue. So if you got a guy testifying saying, I thought he was going to come back and ram me, I think that it's hard to dispute that that's, at least in his mind, a reasonable belief, I guess, that he's facing imminent threat of serious bodily injury or death. One thing that came up in the trial court, because our legislature did not give us any guidance with this statute, was what's the standard for prima facie case? And the parties agreed, and the court suggested, and it seems sensible, I think, that it's similar to a directed verdict standard, requiring a party to clear a low bar by adducing at least some evidence on each of a claim. And I think that's hard for us to say it should be a different standard, because if this was a trial, that's all they got to show to get the instruction, right? So that could stand. Now, whether any of that is proper, it still may be unresolved. I thought footnote 2 in the opinion was interesting. If I can turn to that. They basically said, I'm just going to read it to you guys, I'm sorry. In their briefing, the parties provided extensive argument regarding the procedure required for a defendant to make a prima facie claim of justification. But these issues were not preserved in the district court. The district court explained to the parties how it would proceed, and the parties agreed. Clara then went first at the evidentiary hearing and put on evidence of his version of events. There was no debate or discussion about whether this was the correct way to proceed. His counsel agreed to this procedure, stating, "Great, that's all I needed to know." Then after the hearing, when the district court asked for a briefing from the parties, it explained its understanding of the term prima facie claim. Again, neither party objected to the court's explanation or directives. Accordingly, we do not address unpreserved issues raised by the parties. So if for some reason this proposal seems unreasonable, it seems like they're leaving an opening if you wanted to preserve an issue for appeal in one of your own hearings down the road. The court went through an imminence analysis. And I just think this is where reasonable minds disagree. I mean, this is why I think these questions are for juries. I saw faces out here watching this video, and I could tell some people probably viewed it the same way I felt. That Burial case distinguishes lawful defensive force from two forms of unlawful force, that which comes too soon and that which comes too late. Did Clara fire his weapon too soon and the car's driving away, is not actively ramming him? Now, I'm not expecting him to wait for it to start gunning towards him, but you saw how slow it kind of shifted off. It really looks like it's just moving him out of the way, and it's going to go on, okay? With respect to the imminence analysis and Clara's subjective belief, and belief must be objectively reasonable, the subjective component does not turn on the quality of the defendant's decision-making. So this is we all can't sit here and Monday morning quarterback this guy. If he subjectively believed that, we gotta live with that, even if it was a poor choice, if he had other options. That's a rough one to swallow for prosecution, I think. Objective standard, reasonable person in the same position is not an infallible individual who has the benefit or of hindsight or plentiful time to contemplate the imminence of a given threat of harm in a moment. Detached reflection cannot be demanded in the presence of an uplifted knife. I get it. We apply that to our law enforcement officers all the time. Like, you got to make split-second decisions. Everyone gets it. When you're facing a threat, you don't have the opportunity to reflect. But when they're recounting what he did, they made it certainly sound like he had the opportunity to reflect to justify their finding that he was objectively reasonable. When you look at the video, though, it seems like this was he was angry. He just goes out, I'm going to pop some rounds off because how dare this guy like hit my car. And even his voice, what is going on? What is happening? And then if you saw him outside, I didn't play it, this is like 8-minute video, he's just standing around. It does not look like a person who just escaped serious bodily injury or death. It looks like a person who's like, what the hell just happened? And he made a dumb decision in firing his weapon. And so, again, I feel like a jury should decide that. Now, Clara did not, how much time do I have, Bob? Sorry. I mean, I'm talking too long, I'm sorry. Clara only addressed the prima facie claim. Okay, I see it, okay. It did not address clear and convincing evidence. I want to touch upon that real quick. Clear and convincing, I don't know, we never deal with this in our field, really. The only time I hear clear and convincing evidence is when I'm in closing argument, and an LDA is like, probable cause, clear and convincing, they could take the kids away. They make it sound like a big deal. I mean, reasonable doubt's way up here. So I pulled the Muji. A party must persuade you by the evidence to the point that there remains no serious or substantial doubt as to the truth of the fact. Requires a greater degree of persuasion than proof by preponderance of evidence, but less than proof beyond a reasonable doubt. I mean, a judge having to do that distinction versus, I'm not saying clear and convincing and reasonable doubt are the same, but it's really hard to like say, this is what makes this clear and convincing versus reasonable doubt. I mean, it seems very arbitrary. I mean, especially when you consider the defense burden when it comes to special mitigation or when it comes to extreme emotional distress is a preponderance of evidence. But the prosecutor's got to do clear and convincing if they're going to keep their case alive. All right, real quick, pre-file investigation. If a suspect talks, validate everything, make them reenact, get as many details as possible. You've got to lock people into statements. Anyone there, lock them in because the defense investigator is going to find them and they're going to get a statement and you're not going to know about it until your justification hearing comes up. You've got to send cases back when they're presented to you. Go lock this person into a statement. I don't care if it's BS, just lock them into something so I know what to do, okay? Thorough scene documentation. Consider the post-incident behavior. Are they fleeing? What are their phone communications? Are they destroying evidence? And like I said, interview every potential witness, but don't tip them off that you're asking questions about self-defense. Just, you know what self-defense requires, ask them questions related to that. This is what I tell all my prosecutors. This is not a prelim. This is a real hearing. I think like when this first came on, it was like, oh, it's just another hearing. I'll just subpoena some people, throw them on the stand. No, this is the real deal. Dismissal with prejudice. Okay? You have to be prepared as if it's a trial. Hold them to that Rule 12 standard. Hold them to reverse discovery requests. The moment they file that, I would be filing a motion for discovery saying who your witness is going to be for this hearing. Don't hesitate to ask for continuance, kind of what we were talking about from the 4th District there, and prepare for cross-examination. One of my favorite things to do on cross-examination when a defendant's testifying that didn't speak to the police is point out the fact that during this course of time, they've had all this opportunity to review discovery, they've had all this opportunity to look at what other witnesses have said, and now they're giving their story. You can't comment on their silence, but you can point out the fact that they came to this thing completely prepared. I had one attempted murder case I lost that drove me nuts because this guy at the scene was talking about like weird stuff. He didn't say anything, okay? Comes to trial, and he's got a point on every particular thing that my victim said that he could respond to because he studied that thoroughly, and it was just aggravating. All right, real quick, and I hope I can get through this. This is the case we lost on the defensive habitation. So this is Dimitri. He's a professional bull rider, or was a professional bull rider, and he was here last fall, the Utah State Fair, in a bull riding competition. And I'm assuming, as a lot of young bull riders out there in his particular field, he had a special lady friend locally. I'm sure they have them in every place that they go participate in. And so he hooks up with his friend, LaShawn. They go watch the race, and he didn't have a particularly good performance. He goes back to LaShawn's house, showers, and LaShawn, her friend Diamond, and Dimitri decide to go to a bar. They go to the bar. Dimitri starts taking more of an interest in Diamond. This upsets LaShawn. So LaShawn storms out of the bar angry. Dimitri has to get on a flight the next day, and all of his stuff is still at LaShawn's house. Classic love triangle problem here, okay? So we download phones, and at 11:21 at night, Dimitri texts LaShawn, I'm pulling up to your house, I have nowhere else to go, and you have all my shit. Let me get my shit, and I will leave no problem. You can be in your feelings all you want, I'll leave you be. Now, if that's an issue, me and the police will pull up to get my shit. Sean, you know I haven't been nothing but for you since you told me you mad. I didn't trip, so why are you flipping on me? LaShawn texts him back at 11:26, please, and then good night, whatever she was trying to, she was very intoxicated. Then there was an audio text that's sent to her from Dimitri. He does call her the B word, but he's just complaining about being able to get his stuff. He has all of his belt buckles in there, all of his gear. He needs to get his bag because he's got a rodeo the next day. Then he texts her 11:31, I got you, I haven't disrespected you like you've done me. I just want my shit with no issues. She left with someone referring to Diamond, and I just want my shit and I'll leave you be. Then LaShawn tries to call him. He doesn't pick up. I don't know why. Then he texts her 11:41. I swear to God, if I don't have my bags in the morning, you're going to regret everything. Then 11:48, he gets a lift, and he tries to call her twice while he's going over to her house. Now, he made some poor choices. We're not going to dispute that. He gets out of the lift. He starts pounding on the door. He gets a rock. He starts hitting the window because he's trying to get inside to get his stuff. And at 12:07, this is the 911 call that comes in from LaShawn.
911, what is your emergency? Hello?
I have a emergency at 965 South Central. They're beating on my window, and I'm in 202.
Okay, tell me your address again.
965 South Central, 202.
That's not her address. She's too drunk to remember her
what?
address.
That's
West.
not a, okay, that's not a,
900 South, 200 West.
so 96
South, 965 South and 200 West?
Mm-hmm.
And what apartment are you in?
105.
Okay, you told me a different one.
202.
Okay, so what apartment are you in?
202.
Okay, what is your name?
Autumn.
What is your name?
Autumn.
I can't hear you. What is your phone number?
385 685 125.
Okay, that's not a good phone number.
He's pounding on the door.
Try telling me it again. What's that noise?
I'm shooting.
What? You're shooting? Where are you shooting? Hello?
You get the gist.
They're banging in my window.
What's that?
Hurry up. Hurry up, they're banging in my window. Hurry up right now.
Okay, what is your name?
Oh, listen.
Who, are you firing a gun?
Hurry up. They're coming.
Ma'am, what is going on? Are you firing a gun? Yes or no? Yes. Okay, who are you shooting at?
Shut the fuck up. They're coming in my house.
Who are you firing at?
Shut the fuck up. They're coming in my house.
Who is?
Right. So there's a lot of evidence. I'm trying to be as general as I can, but the picture on your left, she shot through her living room window. The blinds are drawn. She doesn't see who's outside. She shoots through there. And then multiple shots are fired through that door. Now there was a set of blinds there too that I think you can see on the kind of on the ground. I don't think my laser's working here, right there. He was shot in the stomach. His body was outside. We don't think he ever entered the house. His bag that he was there to get was literally, I don't have a, like right back there, like she put it there, like expecting him to come. So we have the justification hearing. Now, this is defensive habitation. And I think the way, this was, we debated this case. This was a tough one for us to decide when we had to charge because of defensive habitation. And the way, the logic that was applied, and we can disagree with this, I'm not professing to be an expert on any of this stuff, was let's say Demetrius doesn't get shot and he survives, okay? But he's successful in getting his bag back, but her door is damaged, her window's got a crack in it from him hitting it with a rock. Are we gonna charge a burglary there? Is that an aggravated, is that a burglary? Is that a forcible felony? Entering someone's house to get your stuff? I don't know. I'm not liking that case. I'm probably charging him with criminal mischief for damaging her property and trespassing a dwelling, right? And so for force of habitation, the entry must be made in a violent and tumultuous manner. I'll concede that in this case, assuming he entered. And the victim reasonably believes that the entry is attempted for the purpose of assaulting or offering personal violence to anyone inside. None of his texts really said, I'm going to come in there and kick your butt. They were basically, I want to get my stuff, okay? Or it was made because the entry was made and they reasonably believed it was for the purpose of committing a felony in the habitation. And I've just talked to you, I don't see the felony there. But the court felt differently, Court felt it was justified, case was dismissed, and she's back in Texas. Okay? So that was that case. This next one I want to show you is a case that we have. And this is more of like a law school thing, like just watch this crazy thing that happened in Murray, and like let's piece it together, okay? All right. Let me just kind of set the stage here. So this is going to be an apartment complex in Murray. I can't remember the defendants' names. They're escaping me right now. I'm sorry. But you're going to see a guy walking around in the apartment complex parking lot with an AR-15 strapped behind him, as we tend to do, as is his right to do. And he engages someone in the parking lot. And they're trying to joke in around, but then I think his name was Abdul. Abdul's talking to him, and Abdul's dad comes out. And Abdul's dad is pretty ticked off at this group of kids because they're constantly parking in his parking spot. So he's kind of come out there and he's like, you got to move your car. I'm tired of you being in my parking spot. Well, AR guy ain't going to be disrespected like that. So he racks his AR in front of him. They start exchanging words. And Abdul will then reaches and tackles him and grabs the AR. Okay? They're wrestling over this gun now. While the AR guy is telling his friend, Kobeth, shoot him. Kobeth has one of those like satchels. Have you seen these the kids are wearing in these days? If you ever see a kid wearing a fanny pack around his chest, just walk away. Especially in Salt Lake. There's probably a gun inside there. That's where they keep their pieces now. So, shoot him. He pulls his gun out, shoots Abdul's dad. Abdul freaks out, takes the AR, just starts shooting down the hall. Misses these guys, okay? That's kind of what we're going to be watching here. If my video will play. Oh, shoot, I screwed it up. There you go. You might want to turn the volume down. These shots are really loud. I don't want to blow the speakers out. Okay, so here's our guy with AR. See it hanging there?
Oh, that's our Shia.
He's talking. This is Abdul. Here's Abdul's dad coming out to meet him.
So,
I'm at the parking lot.
Oh, we've been waiting here for 40 minutes, bro. For what? Move your car to that spot. We get told it every time we cross the road, we get told.
See him rack the gun soon.
We've been honking for like 40 minutes, bro. I ain't know it's y'all spot. Y'all ain't finna trip on me.
This is the guy with the handgun.
No, man, that's not that's the reason. I'm not finna trip for no reason. Don't pull that shit. You can't shoot me. You not touch me. I'll bust your ass down, nigga. Shut the fuck up there. Focus y'all niggas on, nigga. Huh? Focus y'all on. Why y'all? Hey! Shoot me, bitch! Hey, let shoot me, bitch! Shoot that shit! Shoot me! You better fuck out. Hey, shoot! Hey, nigga!
So the dad goes down. They're going to come running down here. Abdul's right here. They're gonna come up. Abdul stayed on scene. Kobeth is seen on separate surveillance video ditching his 9mm behind a dumpster. So we arrest. Let's just walk through kind of the elements of self-defense here. It's kind of a tricky one, I think. So defense of others. If you are Kobeth, the guy with the handgun, and you see your buddy wrestling around with two other guys, and one of these guys has now secured an AR-15, do you think you might now be reasonably justified to protect your friend and shoot at these people? I expect the defense is going to make this argument. I don't think he is, because I think provocation, the first guy, I can't remember his name, he provoked this entire thing when he racked his gun and then punched at him, and then they were trying to wrestle the gun away from him. The one question that we struggled with was Abdul, whose dad just got shot. There was a break in the action there. He comes around and he just starts shooting that AR down that breezeway. He doesn't hit anyone, but was that necessary? Could he theoretically be charged with discharge of a firearm? Was he justified in doing that? We're not going to charge him. I think it's kind of a heat of passion situation, extreme emotional stress situation, and he's our witness. So that's an example of, I anticipate, though, that we are going to have a justification hearing in this case, and it's going to boil down to his perception of his friend wrestling around with a gun. Is that a justification or not? We had another homicide that got tossed for a similar situation. It's going to be really ironic because this kid was exiting a bar and he had a gun. He was like 120 pounds and he was picking a fight with a big Samoan guy. And the Samoan guy knocked him to the ground and is punching him. And he takes his gun and he tosses it to the side to his buddy, who picks it up and then shoots the Samoan guy. And the judge threw out the case on the little guy that was getting pounded, even though he was kind of a provoker. That case got dismissed, but he's weighing whether he's going to keep the case alive on the shooter. And that just blows my mind. You charge 2 people with murder, 1 guy gets off who had the gun in the first place, and now we're going to charge. This is the problem I see with a judge. I get along with a lot of judges, but they're human too. And these issues need to be discussed amongst a jury. You can't put that much pressure on one judge, especially if it's going to be attached with a dismissal of prejudice. I got a little bit more time, so I did save a few other clips to show you guys outside of my... Ron, can we switch the screen here? So one thing that I enjoy too is in Salt Lake County is they build a prison in Salt Lake County. So we get all the prison crime. And my public defenders think it's cute to start setting justification hearings on prison assaults. Defense of others. My homeboy, my buddy was getting beat. I had to come to his defense. Okay? Now, I want to get a vote here. And appeals guys, don't listen to me. We kind of want to run a motion that says these guys are cohabitants. This is domestic violence. They don't get a justification hearing. They are cohabitants.
You're up there now, so.
This one is entertaining. These things can be brutal. This one isn't as brutal. So this is, oops. Here it is. Okay. So this is one of our max security areas of the prison that houses members of the SAW and the SAC gangs, our Aryan Nation gangs, okay? I'm just going to let you watch it, and then we'll talk about it. And you want to know what hell would be like? Hell would be living with these guys. Pretty soon they're all going to convene in this area here. I will say this, even though they made the prison smaller, they definitely made the video footage a lot better. So I'll give them that. So everyone's shaking hands. How you doing? How you doing? Okay, keep an eye on this guy here. He's going to get the party started. It's really fun screening these cases and picking these guys out, just to let you know. It's awesome. The ending is worth it, trust me. Not in a violent way, trust me. Guards do not dare go into this situation. Got a little shoe thrown at him there. Yep, here we go. Here it is. Love you, brother. Love you. Just had to get some aggression out. So it puts us in a predicament. Like, what do? You charge these guys because you got to restore some order in the prison, but it's like a mutual combat type of a situation. You know, there's no justification here. They're going to try to pinpoint some of their guys defending someone else, but we're going to have to bring in our gang experts, talk about gang culture in the prison and how these guys resolve their beefs and stuff like that. And it's just another layer of process that we have to go through thanks to this statute. So I see that I am out of time. So I do want to say this, like, if you guys want to come and work cases like this with me, come see me afterwards. We're hiring, all right? Put you to work, get some good experience, and 5 years from now, my friends in Davis and Utah County and Summit can hire you after we train you up, all right? Okay, thank you, everyone.
Started. So I will start your countdown timer.
Okay.
Yeah, I'll start you at 4, so you end right at 5.
Okay.
You know, if you're
Minimum day is what, 25 minutes here?
something like that. Yeah. Okay, our last presentation of the day is our civility. We've got Brad Jepson. We appreciate him being here. So Brad, let's see, flip my pages, graduated from Box Elder High School and then Southern Utah University. Went to law school at the U. After graduation, went to work for the West Valley City Prosecutor's Office. After spending some time on loan with the U.S. Attorney's Office, he returned to West Valley City as a public safety attorney representing the police department and fire department, and was there for 14 years, and he is now the Bountiful City attorney. When we think about police-prosecutor relations, Brad is kind of unique in that is, prosecutor working directly with law enforcement agencies, advising them, has had tremendous experience, and so we are grateful and appreciative for him rounding out our day today. Brad.
Yes, thanks, Bob. It is an intimidating group to speak to. I am by far the least experienced or least accomplished prosecutor in the room. Your guys' war stories match up to the misdemeanor prosecutions I did. I'm kind of like that scuffle you saw in the jail versus the shooting of the AR. We're, on the other hand, I'm probably not even. Sorry, I'm really loud. There are certainly better civil rights attorneys, 1983 attorneys that I've heard present, you guys have all heard present. My hope today is that I can just kind of share with you my experience coming into the prosecutor world as a new prosecutor working with police, and then shifting over to where I was advising a police department, defending officers, as well as working on some employment issues with them. So we're gonna look at about 5 things today. I'm going to talk about my own biases, and I don't know what biases you guys had. I don't know your guys' background. I'm going to talk about my own biases when I first came into prosecution. We're going to go a little bit into the inherent conflict of interest, and truthfully, we could have this whole presentation on the conflict of interest between being a prosecutor or an elected attorney who also has to oversee the civil side of a police department or a law enforcement agency, as well as we need officers to do our job. We need police officers to do our job. We need them to do a good job, and we need to do a good job for them to do your job. Now, there is a lot been written in the last few years about this conflict, and we'll talk a little bit about that. Then I'm going to switch a little bit to the civil side. For the individuals here who kind of play a dual role, and you're not only prosecuting officers' cases, but you're also advising those agencies where you could be put into a position where you're defending their actions in a civil or even a criminal court on one hand, and on the other hand, you're disciplining them or even terminating an officer. And finally, we're going to talk about how we can build a relationship through being an asset to your police departments, and then increasing communication. Let's start with my own biases. So a little bit about me. When I started as prosecution, this is kind of how I viewed officers.
Oh, hey, what you got there? A Blu-ray disc system. Blu-ray disc system, huh? Yeah. Is it worth going to jail for that? $700 DVD player?
700? No, man. They drop these down to like $250, $269 right now.
No.
Oh, yeah, these is cheap as hell.
Now, if I watch Blu-rays on my tube, is it going to have letterbox or is it going to be full frame like standard?
Now, if you, well, what's your aspect ratio? Is it 16 by 9 or 4 by 3?
I do not know.
Hello, officer.
Hi.
Hey.
What you got there?
A little Blu-ray player. Brand new Blu-ray player.
Oh, Blu-ray player. Hey, I got a question.
Yeah.
Do those things play on plasmas or just CRTs?
No, these play on plasma, CRT, DLP, LCDs, any kind of format you have.
How much you pay for that one right there?
Oh, this one right here?
Yeah.
Oh, this one's free for me. I sold it.
Hey, Junior?
Yeah.
You still got that 8-track tape player?
Yeah, I don't think those will work on a Blu-ray, though.
Oh.
So unfortunately, I didn't have a lot of interaction with police officers growing up. Nobody in my family was in law enforcement. My dad was a teacher. I grew up in Manaway, Utah. Now, what is Manaway, Utah known for in this state? RoboCop. RoboCop. Did you go to Utah State? Well, thanks for paying for our fireworks. I appreciate it. We are very well known for our traffic enforcement. I had a good relationship with our officer growing up. I understand how we got that. Then I went to SUU. You see the map there on the right. So pretty much all through college, my experience with officers was, answering the question we all have to answer. Yeah, I know why you pulled me over, officer. It's very simple. I was going over the speed limit. Then I went to SJ Quinney College of Law. Who went to University of Utah Law? And who had a fight with their parking ticket coordinators? Oh, come on. I swear, they have a fraternity over here. You got guys hanging out the window. You got, kegs with 19-year-olds drinking from it. And you got the officers sitting there on their watch, like waiting for that 2 hours up so they can come issue you a ticket. And then finally, I went to work for the West Valley City Prosecutor's Office. Started in the Justice Court dealing with traffic tickets. This was also a time, if you guys go back to 2010, where West Valley Police Department was very much in a transitional phase. We'd had a breakdown in some policies and procedures. Our NNU unit had some issues, and it was in a very much a transitional phase. James is laughing at me when I said issues. You can talk to him later. He knows more about those issues than I do. So that was my perception going into this prosecution realm. I didn't have a lot of court experience, as most of us didn't, and I had some biases. And here's one of them. I had this idea, whether I said it out loud or not, that I went to law school and this guy's just a cop. I'm in charge of this. This courtroom, this is my realm. Well, as I got further into it, and I started, actually looking and starting to think about what I had done, you see my experience there on the left. I did not get a criminal justice degree. I got a history degree and then a pretend master's degree that did absolutely nothing to help me on my career. I think I maybe had con law in my undergrad. Then law school, we had criminal law, con law, criminal procedure, and victim rights. But where did we really learn how to prosecute cases? Yeah, I mean, we got our experience. We got to court. Most of us probably started in justice court. We got to court, and all of our experience came to that justice court. On the other hand, you have our cop Carl. Now, for my hypothetical officer here, we're going to say that he went to the criminal justice 2-year associates program at Salt Lake Community College. Part of that program, they have all those classes up there, 24 credit hours of very specific things. And then to get a job as an officer. I was talking to Trent Dressen back there. When he became an officer for West Valley City in 2007, you guys remember how hard it was to get a job in 2007. And this numbers kind of match our records. They had about 300 officers test for 7 or 8 spots. It's not easy to even get past that first phase. And then once they get past that first phase, they do an extensive background check. And now I know what you guys are thinking. The bar did a background check. Yeah, the bar did a background check. Like Dr. Pepper's a real doctor. This is a real background check. I mean, we hire detectives. They go meet with your roommates. They go meet with their ex-wives. They go meet with your brothers, your sisters. It's a real background check. Then they go through 4 months of a police academy. Now, once again, 4 months. What could you really accomplish in 4 months? These things are pretty intensive. Not to mention 60 hours of specific training to Utah laws. Most of us probably didn't even really dive into even a Utah statute until after law school. Was the first time we were like, oh, 76, that's a section I should start getting to know. We really didn't look at it. So if you look straight across, my first year as an officer, as a prosecutor, I was 31. And I was essentially the same age as an officer who already had 8 years experience. Yet I'm walking into that courtroom with this idea that I know what's going on. I know more about traffic tickets. And I remember one time I was cross-examining on a speeding ticket or something. I don't remember what type of ticket. I was direct examining. I put my officer up there and I started into like the law school stuff, like what experience you have, how do you know your radar gun was working, all those questions we were taught to ask. And Judge McCullough, Justice Court Judge in West Valley, looked at me and said, "Sir, this officer's been here for 25 years. His credentials are well noted by this court. He knows more than you do about it. Move on." Those of you who know Judge McCullough, that is Judge McCullough. But it was true. Like, I had never used a radar gun at that point in my life. I didn't know what a tuning fork really did. I really didn't know what LiDAR was. Yet I was trying to take this officer along, but he was the one with 8 years experience. Now you see that I threw this down here. We'll talk about that here in a minute. So, the other one, and I did say this, I can tell you, I remember the exact officer I said this about. She is a great officer, and I was talking to friends of my prosecutor, and I said, "Man, she's really smart. I wonder why she became a cop." Now, don't pretend like I'm the only person that's ever thought this or said this out loud. This next slide is going to be a little bit controversial. It certainly would have changed my life, and I was arguing with Dressen about why he became an attorney. So I just did the math. Don't do the math, but I did the math for you guys. This is based on current Utah tuitions. If you were just to pay tuition by the time you graduated from law school and your undergraduate, 7 years later, you'd be looking at about $230,000. In that same time, an officer who got his 2 years associates, got a job with Salt Lake City, worked through the ranks, would be up on you about $376,000. That means we're starting $600,000 behind. So a prosecutor, we do make a little bit more than officers, maybe $30,000 a year more. By the time we make up that difference, the officer will be retired and fishing. So once again, I asked Trent Dressen back there, maybe we ought to ask the other question. She's pretty sharp. I wonder why she went to law school. That is kind of what the officers look at us. There is a side. But my point in showing this is not a backup profession. This is a profession that is a reasonable profession to go into, both financially, both lifestyle-wise. A lot of officers didn't accidentally become cops. This is what they wanted to do, and it's a reasonable decision. So, things I learned. Being a lawyer does not mean, just by being a lawyer, that I'm smarter than an officer or that I know more than an officer. The next thing that I learned was, what is my role as a prosecutor, and what is their role as a police officer? So let's just ask that question to the group. What is your role as a prosecutor? Do justice. That pretty much fits in with some mission statements we'll look in a minute. What's your role in protecting the civil rights of the people of your jurisdictions? If you guys have a case with an obvious constitutional violation, what is our role there? Do the defense attorney's job for them. What is our role with evidence that hurts our case? We turn it over. We do have a role there. But also the officers have their role, and we're kind of going to examine that a little bit deeper. Now, how do cops perceive prosecutors? This is how they perceive us.
I'm a college man. I won't need my high school diploma anymore. I am too smart. I am too smart. I am too smart. I am too smart. S-M-R-T. I mean S-M-A-R-T.
So, once again, we can look at this, and what does this first-year prosecutor look like to this 8-year officer? Well, we look like King Joffrey, a young guy, kind of, flush with power, sitting on our iron throne, telling them, your cases are bad. I'm going to dismiss this case. You're bad. I sent a letter, an email, a few years ago. I sent an email out to my officers, and I said, tell me about prosecutors. What complaints do you have? What are your thoughts on prosecutors? I got quite a bit of response. I think we had 220 sworn officers around that at the time. So about I don't know, a third of them, a fourth of them responded. Most of them looked at communication issues. Some complained about their offices. Only 12 of them actually provided specific examples. You guys laughed at this. You guys remember what this was from? Yeah, Kyle Whittingham up 43-0 did an onside kick, and Wyoming's coach didn't think much of it. So here were some of the responses. How much time do you have? Prosecutors have no clue what we do. Prosecutors waste our time in court. This was a big one. I think a lot of police officers, they believe that if we subpoena somebody for a prelim, that we purposely keep them there an extra 45 minutes. That we're that guy can go, but he didn't use enough commas in his report. I'm gonna make him sit out there and stew for another 45 minutes. I hope that's not what we do. Prosecutors waste our time in court, and a lot of officers believe that any going to court, is a waste of time, and prosecutors are lazy. Another thing they were upset about was preparation from officers, especially that second part there. And that is more what stood out to me because honestly, it was true a lot of times when I was prosecuting. I would go into a preliminary hearing and or even a bench trial, and the defense attorney would play body camera that he knew better than I did. He was better prepared than I was. And you can imagine why as an officer, someone who spent a lot of time on their case, the fact that the defense attorney might know the case a little better than the prosecutor might irk them a little bit. All right, let's move on. Let's talk about the inherent conflict of interest that exists. So we're going to start with this myth. We have this myth, and we talk to officers all the time. I've even used this. Hey, we're all on the same team here. That's not really true. And we see that coming apart as we move along. We're really not on the same team here. We're really not even playing the same game. We're more like Real and the Jazz. We're both in the same city. We're going to team up from time to time, to fight cancer or something. But we're really not even playing the same game. So I pulled up a couple of the mission statements. And this is a simple one, mission statement of the FBI and the DOJ. Now, some of these things, you're going to say they mesh together rather well. And then sometimes, they're not going to be the same. Here's Salt Lake City PD's and Salt Lake City Prosecutor's Office. You see words like protect property, guardians of the citizens. Then we have with the prosecutor, solve community problems, to serve and restore our communities. Many times these goals are going to align, but they're not always going to align. I got a call from a prosecutor several years ago, and he said, it was a prosecutor I knew quite well from the DA's office in Salt Lake County, and he said, hey, just a heads up, Brad, I had to dismiss this case. It looked like your officer pulled over a victim without any reasonable suspicion. I dismissed the case, but there could be some civil rights litigation coming for us. Just wanted to give you a heads up. So I called up my officer, and I said, officer, what happened? You really pulled over somebody without any reasonable suspicion? And he was like, yeah. It was like 2 a.m. We got a report of multiple shots fired through the window of a house, and I was driving to that area, and coming away from that area, I saw a car pass me that had obvious bolt holes in the side of it, and I pulled him over. And he's like, no, I didn't have any reasonable suspicion. The best case scenario I had was that he was a victim in my case, but I pulled him over. And I said, well, why did you pull him over? He's like, 2 a.m., shots fired. My objective is towards the community. Right at this moment, I'm not looking at prosecuting this guy for possession of a stolen vehicle or unlawful possession of a firearm. I wanted answers. I wanted to know where the bullets came from, if somebody was still shooting, what type of scene I was going into. Now, many of you guys are probably thinking, yeah, the case may have survived, the criminal case may have survived, under one of those cases that says you could have like a pertinent witness. But in my mind, as a public safety attorney, this was reasonable. Did he have reasonable suspicion of a crime? Probably not. But this was reasonable. Is it direct conflict with their civil rights to be free from liberty? I don't know. But for his objective that night on the scene to stop the car, to say, hey, where are the bullets coming from? Where should I go? Is the person still around? To me, that was reasonable. Now, this lady up here, I don't know anybody who's familiar with her story. Her name is Marilyn Mosby. She was a state's prosecutor for the city of Baltimore. She became nationally known when these 6 officers below were involved in the death of Freddie Gray. Freddie Gray was arrested for suspicion of possession of a dangerous weapon. He died on the way to the jail. These 6 officers were charged by Ms. Mosby's office under various allegations. Ultimately, all of them were acquitted or had a hung jury, or she dismissed the case. But anybody know what recently happened to Ms. Mosby? Yeah, she was recently arrested herself, found guilty, and is now facing prison time, which is why we have this conflict of interest. We can go around it, we can talk to our officers, say we trust each other, we work together, but in reality, there may be a time there may be a time where a prosecutor has to charge a cop with a crime. Like, that is our job. Also, there may be a time when officers themselves may be called upon to arrest a prosecutor. Also, we fight for resources. Many of you guys know Ryan Robinson and Chief Jacobs at West Valley City, where I was. If you were to ask Ryan, he would say, man, the police department, they get everything. They get all the money they want. They get all the people they want. They get to have cool new cars all the time. And if you ask Chief Jacobs, she'd be like, man, the prosecutor's office, they get everything. They get new offices. They get to borrow one of our cars. Like, this is always going to be a competition. Anybody who's worked on the budget knows there is going to be an inherent competition over resources. You guys might dismiss an officer's case, a case that they've worked long and hard on, that they believe they have the right guy, they believe they have the right crime. That's going to cause tension. There's no way around it. That's going to cause tension. Officers may fail to arrest. And then we get these last 2, and this one really is a big conflict of interest, particularly for the smaller counties or for the city prosecutors. Not only can we be called upon to defend the officers in a 1983 case, we can also use our other prong where we're out and we're going to terminate those same officers for the same case or discipline those same officers for the same case that we're defending in him. That is a conflict of interest written into it. So we have this idea, all these things that make us different, that really don't put us on the same team. Now, I do think that despite all this, we can coexist. We can not only coexist, we can have good relationships. Now, I'm going to take a brief detour here, and I want to just touch real quick on the legal risk. Just by a show of hands, who here is in a position where they represent their police departments or a law enforcement agency on a civil level as well as on a criminal level? It's not too many. We have a few. I'll breeze through it. We do have to understand the legal risks. Those of you who haven't been, paid attention to history for the last 150 years, during Reconstruction, we passed the Civil Rights Act. We have this thing called Title 1983 case. It basically says that you can now sue a state agency for any discrimination, any constitutional or discrimination. I think it was in, 1963? Civil Rights Act 1963. We added on to that. But we call this a Title 1983 case. Now, we also have this idea of societal risk. We call it the public duty doctrine. We remember this way back from our first day in torts. If a guy's drowning in the ocean, do we have to rescue him? No, but if we do start rescuing him, can we have some liability? This actually happened in Maricopa County. That became a big news article and a big question in my world.
What are you doing, my friend? Huh? What are you doing?
I'm free to go, right? You can't swim in the lake, man. I'm free to go, right?
You're not allowed to swim in the lake. far do you think he's going to be able to sleep?
Sorry, I might be, I got bad liver problems. I just didn't
You have bad knee problems?
Liver problems.
Liver problems.
Well, you guys got this thing, just in case it gets out. I'll get that thing. All right.
So in my world, this case was a big deal. I don't know, maybe in the prosecution world, it went past without much notice. But this was a big thing. I had police agencies, on all the forums and the trainings we go to, they talked about this case. Well, what should the officers have done? What would have been a better scenario? But essentially, we have this conflict. And I've had this conversation with several police chiefs. You have this conflict because we have this idea that police officers are guardians and they ought to help. And then you have the devil cricket on their shoulder telling police chiefs, no, don't do that, there's too much risk. Don't do that, there's too much risk. Don't do that, there's too much risk. So you're always going to have this conflict. Do officers engage or do they not? So in that situation, that's the ultimate question. There really is, and I know most of you guys are thinking, that maybe they're liable. In my mind, there's really less liability for them staying on shore. If they get in and start doing something, then we lose the public duty doctrine. Now, on the other hand, as far as political or societal risk, those officers are put on administrative leave. I believe their bosses must have felt like there was some action they should have taken. But that really is the question. So let's get back to this idea of societal risk versus legal risk. And this may be a case one of you guys still has. I've changed the names, obviously. But we had an officer get a text very early in the morning from a semi-reliable, paid, confidential informant. By semi-reliable, you guys know that I mean not really reliable at all. She has given us good information in the past. She's also given us bad information in the past. So we have this text from an informant. And the informant says, officer, you got to hurry. There's a lady, I'm at this guy's house. There's a lady. He keeps telling me to go get his hammer because he's going to kill her. He's going to kill her. So our officer drives over there, immediately responds, and he's outside the door, and nothing on the text message. Doesn't hear anything from her. And he's texting her saying, hey, I need something. I need to know you're in there. I need something to confirm. I need dual source on this. He sees nothing. All right? So what does the officer do? This officer calls you guys. What do you tell him to do? I mean, it's a huge conflict, right? Because we all know this saying. It comes from Delaware versus Prowse, but it really is pretty much in every Fourth Amendment case where an officer enters a home. Physical entry in the home is a chief evil, which the wording of the Fourth Amendment is meant to present against. So what do? You have this other side where you're required to protect and serve. Now, whoever has this case knows the answer. The officer did. He went in. Everything was just as the informant said it. He saved a life. Guy was charged with aggravated kidnapping, attempted murder. Saved a life. I had a very similar case where the exact opposite happened. Went in, nothing was wrong. We were sued for unlawful entry, and we ended up having quite a hefty settlement. So we're always going to have this conflict between the protect side and the serve side, and also the guardians of the community and protect the civil rights. Like we saw here, we saw the FBI's vision. Now, officers, as prosecutors, what is our immunity? We have prosecutorial immunity. For the most part, anytime I've seen a prosecutor's office named in a Title 1983 case, because of this case, Imbler versus Pacman, they get out at motion on the pleadings. For the most part, prosecutors have immunity, meaning the Supreme Court, made up a bunch of lawyers like us, did us a solid, and they said, yeah, remember that whole civil rights thing where we say you can sue a government for constitutional deprivations? Well, you can't sue a prosecutor and you can't sue a judge. That wouldn't work. So we have immunity. Now, officers, they have what we call qualified immunity. Now, qualified immunity, we've heard a lot about it. What is it really? This could be a presentation of its own, obviously. We've probably heard this a lot, whether an alleged fact shown by the plaintiff show a constitutional right, whether it was clearly established. But the real thing here is police officers can actually be on the hook for the decision that you guys make as prosecutors. Say a prosecutor and a police department work together to investigate public corruption. They give the case, they give it to the prosecutor files, and then the case is dismissed at prelim, and the person that was charged goes to sue both offices. Prosecutorial immunity applies, they get out, and ultimately the police officers are left kind of, I don't want to say completely liable, but they're at least held liable for their part in an officer's charging decision. So while you guys have prosecutorial immunity for your charging decisions, many of your charging decisions can actually fall back and show liability towards your police departments. All right, so let's get back to building relationships. The key thing that I've found with building a relationship with your officers is that we need to be assets. We are professionals, we're experienced, we need to be assets. So, this was one of the complaints, is the only time we ever hear from our prosecutors is when we're getting in trouble. When we miss court, when we did a wrong stop, they don't show up, they don't train us, we don't hear about these new Fourth Amendment cases, we don't do that. So, as a show of hands, after you guys go to this conference, who here goes and passes this stuff on to their law enforcement agencies? It's quite a few. I mean, that's what our role is. We are the experts. Once we pass that on, it also helps build a relationship if we get in front of that instead of behind that. So, when we got to law school, they said, we're not going to teach you guys how to be a lawyer, we're going to teach you guys how to think like a lawyer. I've hated that term ever since, because thinking like a lawyer is the worst. We're hard people to get along with because we think like a lawyer. And officers don't need this. For us, we like to throw around the word "it depends." We use "it depends" all the time. We say, well, what are the totality of the circumstances? What did he know at the time? We look at all that. That's not a helpful answer at 3 a.m. when you have a guy on the other side of the door that may or may not be dangerous. So, if I were just to ask this question to a room full of lawyers, who won the 2008 NCAA Football National Championship? Florida did? Yeah, I mean, we're going to argue about it. I would say that Richmond did because, they were the Division I. That was the only tournament the NCAA held that year. So I'm going to say that Richmond won the FCS. Grambling State, they won the HBCU. Minnesota Duluth, they won the Division II. That's a tournament. That's sponsored by the NCAA. And then, Tyson and a few other people are going to be like, well, the Utes won because something called the Anderson and Hester poll put us #1. But if you Google this answer, what is the real answer? Like, this is what pops up. Tim Tebow won it. Aaron Hernandez was on that team. Urban Meyer was there. That's who won the national championship. But us, as lawyers, we're going to pick apart every one of those words. Well, what's the NCAA championship? The playoff championship? Anybody know who these two people are? I love both of these people for different reasons. The guy on the right is a guy named Eric Daigle. Anybody ever heard of Eric Daigle or heard him talk? I believe he's out of California. He's a use of force expert, and he makes his money by having these big, by being a use of force expert, by also having these big conferences in Vegas. He charges $800 to $1,200 for an officer to come down there and hear him talk about use of force. I've gone to talk to him several times. And what makes him so appealing to officers? He is an expert, I think, I don't know, but he talks so decisively that everybody that listens to him talk believes he's an expert. He doesn't talk in "it depends." He doesn't talk about totality of the circumstances. He is decisive. And on the left, we have Heather White of Snow Christensen and Martineau. She's one of the lead Title 1983 defense attorneys in the state. Same thing. Every time I've sat in a room with Heather and a bunch of officers, she is an expert, she's decisive, and they trust her. Both of these people make their money because they have gained the trust of law enforcement officers from around the state and around the country. And if I had to say what their keys were, they're experts. Like I said, I hope they're experts. When I hear them talk, I really believe they're experts. They are decisive, they know their answers, and they're confident in them. So, how do we do this? Get a call from somebody, wake us up at night, 1 a.m., the guy says, this dude has a gun, show me an active protective order, can I arrest him? What's the answer to that? It depends. It depends is the answer. But that's not good enough. Like, that doesn't help out our officer on the street. So here's our statute. Protective order, the respondent received actual notice and a chance to participate in the hearing. Pull up the docket. We see it was originally declined. We see now the disposition is granted. We also can see why an officer who pulled this up on the street may be a little confused about whether or not this is denied protective order. So the answer is yes. But that's how we build relationships. We see these dockets all the time. This is something that we see in our work all the time. It's easy for us to get a decisive answer. It's easy for us to be an expert. When you can tell an officer on 2 a.m. exactly what he should do, that starts building that relationship. All right, number 5. And the last one, increased communication. Out of my poll that I took, almost every officer said something about communication. Now, I know from talking to officers, from prosecutors, being a prosecutor myself, this is a two-way street. But they feel as though voicemails go unanswered, phone calls are returned as text messages, that cases get dismissed without them knowing, or that cases get pled down, or something happens on a case and they're the last to know about it. They want to have more communication. We want to have more communication. So where's the breakdown? Where's the breakdown in our communication? I mean, for me, it's simple. I do like to answer like voicemails with text messages. I don't like to have that face-to-face conversation. Plus, sometimes it's awkward. Sometimes you're like, yes, officer, I know you spent 6 months on this case. I think it's crap, and I think you're really bad at your job, so I'm going to dismiss it. But that communication helps build a relationship of trust. Like I said, we're never gonna get along 100%. We have that conflict of interest that is going to keep us from always seeing things the same way. When we clearly communicate what we did, why we did it, it helps build that relationship. Here's a couple quotes from our officers. I've never been contacted by a prosecutor and would love it if you guys contact us directly when something we could do better. That's when I get a lot. They don't feel like we answer our messages promptly. They feel as though they're required, to expediently respond to all of our concerns. We don't do the same with them. So, how can we increase communication? First of all, we need to be accountable. I hear this from a lot of officers. We just went through like 3.5 hours of cases where cases were lost, and I don't think I heard really more than 1 or 2 where it was the officer's fault. Like, there is times where prosecutors lose cases. There is times it wasn't just because it was a bad report. We do make mistakes. I recently made a mistake in my old job. I made a mistake. I was working with my police chief on an agreement, and I messed up the agreement. It was a bad agreement. And when it came time to enforce it, I was like, yep, I messed up this one. And I know she was joking, but she said, oh, the first attorney that's ever admitted he's messed up. It is hard, but we do hold our officers accountable, so we need to be accountable to them. Recognize good work. You guys know, I think everybody understands a commendation. So when an officer does good, we give them a letter in the file, commendation. It helps them throughout their career, promotions, all that stuff. They get commendations for a whole bunch of things. And working for West Valley, I saw what commendations come from. Very rarely are they coming from prosecutors. Every now and then we'll get one. This was a great case. We got a good, he did good on the stand. He was great with our victim. She did a great job in the fingerprints. Every once in a while we get one. But when you guys can recognize good work and an officer gets a commendation, that not only increases communication, but it helps build that relationship. Specific examples. This is probably one of their biggest pet peeves is the prosecutors will say, well, the report was bad. Guys, that doesn't help an officer. If you say the report was bad, that doesn't help them fix it. If you say, well, I felt like the case was lacking in detail, that really doesn't help them fix it. Like, I know their report's bad. Most likely they wrote it at the end of their shift on the side of the road based on some notes they took 4 or 5 hours ago. We need to be able to tell them, what is wrong with this report? What is it that bought them an extra hearing? What is it that was deficient? The chain of command. The chain of command is a big deal in many police departments, especially the larger police departments. You have your chief, your DCs. Some will have captains. Some will have commanders, corporals, lieutenants. Every police department is going to be a little bit different, and every supervisor I've worked with has been a little different. Some supervisors want us to work through the lieutenant down through. Some supervisors just want us to go straight to the officer with any concerns or with any compliments, commendations, any of those things. I really don't have any advice how to do this, only to understand that it exists and then understand how it exists in your agency. Like I said, a lot of police chiefs are different. A lot of police chiefs want you to work on down through the chain, and a lot of police chiefs say, no, call that guy directly. Why are you wasting my time with it? All right. A few parting shots here. Before I let you go, be kind. Now, I am not the expert to talk about this at all. I have an abrasive personality. Frankly, I have very few friends because of it. I'm not the one to talk about being kind. But what I can tell you is sometimes we get into work mode, especially when we're around officers. And I'm not saying don't be professional, but just simple interpersonal skills. I caught myself at this many times. Officers that I've worked with their entire career, I know their names perfectly well as long as I have a name badge on. And then when they become a detective, I'm just like, detective, you. And this is probably pretty common across prosecution. We see a lot of officers. We work with the same officers over and over again, and they take out that name badge, and we simply can't even remember their names. Find mutual ground. For me, those of you who know me, it's easy for me to find mutual ground through sports. Most law enforcement officers are, for some reason, I don't know, Cowboys fans. So if you can talk about Cowboys football, you can pretty much talk to most law enforcement officers. But if you can't talk about Cowboys football, use what you have. But long story is just interpersonal skills. Like, I see a lot of these interactions between officers and prosecutors, and it's like 7th graders at a dance. Like, they're on one side of the room, we're on one side of the room, and you're kind of like, well, I guess I could go talk to him if somebody dared me. We're all human. We all have things to talk about. That's the #1 key in building a relationship. And finally, the last thing that I want to talk about is we do know that police officers have been the target. Police officers and prosecutors alike, we have not been doing things perfectly. There's been some problems. Officers know this. Officers know that this is occurring. They know that bias exists. They know they need to be better at de-escalation. They know these things. But the officer themselves, they all believe they're part of the answer. They all got into this job for a reason. They're very principled. They believe in the job. They believe in the rule of law. They're very principled. They believe they're not blind. They know problems exist, but they believe theirs is a solution. as I think most of us do. I doubt many prosecutors here would raise their hand and be like, I agree, I'm corrupt. Like, nobody's going to raise their hand. Like, there are corrupt prosecutors out there. They're below average prosecutors, but most of us believe that we're the solution to that, to not the problem, as do officers. So help them at that. Understand that and help them at that. All right, do I have any questions? Yeah, the guy who asked the question right before they get to go home. Oh, here he is right here. Will you state your name and where you're parked?
So you said officers are smart.
Very smart.
You also said they're Cowboys fans.
Yeah, I don't understand it either. I don't understand Cowboys fans, even a little bit. All right, any other questions? All right, well, thank you guys.